We'll hear argument this morning in Case 23477, United States versus Scrimetti. General Prelogger.
Mr. Chief Justice, and may it please the Court. This case is about access to medications that have been safely prescribed for decades to treat many conditions, including gender dysphoria. But SB 1 singles out and bans one particular use. In Tennessee, these medications can't be prescribed to allow a minor to identify with or live as a gender inconsistent with the minor's sex. It doesn't matter what parents decide is best for their children. It doesn't matter what patients would choose for themselves. And it doesn't matter if doctors believe this treatment is essential for individual patients. SB 1 categorically bans treatment when, and only when, it's inconsistent with the patient's birth sex. Tennessee says that sweeping ban is justified to protect adolescent health. But the state mainly argues that it had no obligation to justify the law and that SB 1 should be upheld so long as it's not wholly irrational. That's wrong. SB 1 regulates by drawing sex-based lines and declares that those lines are designed to encourage minors to appreciate their sex. The law restricts medical care only when provided to induce physical effects inconsistent with birth sex. Someone assigned female at birth can't receive medication to live as a male, but someone assigned male can. If you change the individual's sex, it changes the result. That's a facial sex classification, full stop, and a law like that can't stand on bare rationality. To be clear, states have leeway to regulate gender-affirming care. But here, Tennessee made no attempt to tailor its law to its stated health concerns. Rather than impose measured guardrails, SB 1 bans the care outright, no matter how critical it is for an individual patient. And that approach is a stark departure from the state's regulation of pediatric care in all other contexts. SB 1 leaves the same medications and many others entirely unrestricted when used for any other purpose, even when those uses present similar risks. The Sixth Circuit never considered whether Tennessee could justify that sex-based line. Because the Equal Protection Clause requires more, this Court should remand so that SB 1 can be reviewed under the correct standard. I welcome the Court's questions.
Much of the latter part of your opening statement suggests that it seemed to suggest that there's an outright ban on this treatment, but that's not the case. It's really for minors. So why isn't this simply a case of age classification when it comes to these treatments as opposed to a ban, as you suggested in your opening statement?
It's certainly true, Justice Thomas, that the statute classifies based on age, but it packages that age classification with a sex restriction and says that for all adolescents, you cannot take these medications if they're inconsistent with your sex. So I acknowledge that the state so far has not banned this care for adults, although I think that the arguments it's making that this isn't a sex-based line in the first place would equally apply in that context. But the Court has likewise made clear that when you classify on the basis of multiple characteristics, you can't avoid heightened scrutiny just because you have a non-protected characteristic that accompanies the protected one. And if you look at it from the standpoint of the plaintiffs who are actually affected by this law, the reason I'm calling it a categorical ban is because the state has left no out for those patients to obtain these medications when there's a showing of individualized medical need. And that is, I think, a stark departure from how the state ordinarily handles issues related to measuring risks and benefits, even in the pediatric context.
Well, is there no difference if a girl takes testosterone or if a boy takes testosterone?
So the district court specifically considered this question in detail and found that with respect to the risks that the state had identified, it was not substantiated that there would be unique risks associated with a cross-sex use of the hormones.
Is there no physiological difference?
Certainly, I understand that there are biological differences between males and females, but when it came to the specific risk factors that the state was focused on, what the district court found is that many of those risk factors would exist regardless of the birth sex of who was taking those medications.
I'm more interested in whether or not there is a difference in testosterone and its reaction in a male as opposed to in a female, and vice versa for estrogen.
So if you take hormones, they will prompt the development of secondary sex characteristics in whether you're a male or a female. If you take testosterone, you might develop a deeper voice register. You might have facial hair growth. And in fact, that's one of the intended effects of these treatments, because that can be critical to helping manage gender dysphoria that transgender adolescents would otherwise experience. But I think when it comes to the question of whether that creates unique risks, the district court found that for the most part, the state had not substantiated those risks, and that it leaves regulation of medication unrestricted, even in contexts where these same medications or others would pose a comparable set of risks.
General, can I just...
Counsel, you rely very heavily in your briefing on cases like Morales-Santanas, which was about the distinctions between men and women when it came to adoption and things of that sort. Here, it seems to me that the medical issues are much more heavily involved than in many of the cases that you look to, including, I understand there's a dispute between both sides on how extensive any evolution or increase in uncertainty in Europe has been and elsewhere. And, of course, we are not the best situated to address issues like that, unlike in, like Morales and Craig Reborn and some of the other ones where it doesn't strike me that they're intensely affected by medical considerations. And if that's true, doesn't that make a stronger case for us to leave those determinations to the legislative bodies rather than try to determine them for ourselves?
So let me respond to that concern with a couple of different points, Mr. Chief Justice. I certainly take the point that you might think that states should have a lot of leeway to regulate when it comes to medical uncertainty, and we're not arguing otherwise. If the state is not restricting access to medications on the basis of a protected characteristic, that is only going to be rational basis review from the outset. And it's only in a circumstance where the state is saying your access to drugs depends on your birth sex or your sex generally that the court would apply heightened scrutiny. But even at that stage, I don't think it's necessary for the court to step in and suggest that states have no ability to draw those kinds of lines. And I think this relates to my point in colloquy with Justice Thomas as well. We, of course, recognize that if there is a lot of medical uncertainty or differential risk, and if the state can actually come forward and show that it has an important reason to restrict access based on sex, that can be taken into account in heightened scrutiny, and it wouldn't provide a basis to displace the state legislatures altogether from weighing this evidence. But I think it would be a pretty remarkable thing for the court to say that just because we're in the space of medical regulation, you are not going to apply the traditional standards that ordinarily are applied when there's a sex classification.
Well, I guess I wouldn't say just in the area of medical regulation. It's more in the area of evolving standards and technical treatment issues and the effect of certainly prescribing particular medications. That seems to me to be very much in the area of medical nuances, unlike, Craig v. Bourne, different drinking ages, or Morales. Can men and women adopt children in the same way?
And I think the court could recognize that concern can be accommodated under intermediate scrutiny. It is not like strict scrutiny where states are automatically prohibited from drawing lines based on sex. They just have to come forward and demonstrate that they do have an important state interest. And I don't think it would be any different, Mr. Chief Justice, than if the state were to say, we think there is some concern about safety and efficacy for this drug with respect to women, so we're going to ban women from taking it. The court would recognize that's a facial sex classification, and then the role for the court is not to come in and entirely second-guess the legislature, but you would ask questions like, well, is there evidence to suggest it's risky for women but not for men? And what does the state do when there's comparable risk in other contexts? Does it just ban medication outright, or are there less restrictive measures? And could the state have tailored its approach to the unique concerns and try to potentially screen for the people for whom this would be safe and effective while enacting a more tailored law to try to safeguard against that important state interest? So I don't think we're asking the court to break new ground in this case. And in fact, we don't even think the court needs to delve into the heightened scrutiny analysis itself here. We think it would be sufficient for the court to recognize that a law that on its face says you can't have medications inconsistent with sex is a sex classification. But then you could send this case back and have the Sixth Circuit do the heightened scrutiny analysis in the first instance.
General, can I ask you a question about the state of medical evidence at the present time?
In your petition, you made a sweeping statement, which I will quote. Overwhelming evidence establishes that the appropriate gender-affirming treatment with puberty blockers and hormones directly and substantially improves the physical, psychological well-being of transgender adolescents with gender dysphoria. That was in November 2023. Now, even before then, the Swedish National Board of Health and Welfare wrote the following. They currently assess, quote, that the risks of puberty blockers and gender-affirming treatment are likely to outweigh the expected benefits of these treatments, which is directly contrary to the sweeping statement in your petition. After the filing of your petition, of course, we saw the release of the Cass report in the United Kingdom, which found a complete lack of high-quality evidence showing that the benefits of the treatments in question here outweigh the risks. And so I wonder if you would like to stand by the statement that you made in your petition, or if you think it would now be appropriate to modify that and withdraw the statement that there is overwhelming evidence establishing that these treatments have benefits that greatly outweigh the risks and the dangers.
I, of course, acknowledge, Justice Alito, that there is a lot of debate happening here and abroad about the proper model of delivery of this care and exactly when adolescents should receive it and how to identify the adolescents for whom it would be helpful. But I stand by that there is a consensus that these treatments can be medically necessary for some adolescents, and that's true no matter what source you look at. You mentioned both the Cass report and Sweden, but neither of those jurisdictions
can be medically necessary for some minors, but for the general run of minors, do you dispute the proposition, in fact, that in almost all instances, the judgment at the present time of the health authorities in the United Kingdom and Sweden is that the risks and dangers greatly outweigh the benefits? Do you dispute that?
I do dispute that, because if you actually look at how those jurisdictions are addressing this issue, they have not outright banned this care. The Cass report says at multiple points that this care can be medically indicated for some transgender adolescents. And of course it's true that they have called for a more individualized approach to these issues and have questioned whether it should be readily applied to all adolescents as a matter of course.
Is it not true that in England, I'm sorry to interrupt, but the time is running out, that the National Health Service some months ago limited the prescription of puberty blockers to adolescent males who are over the age of 16 and are already on estrogen, but for those who are under the age of 16, it's allowed only for experimental purposes. Is that not true?
So the approach in the UK right now is to allow hormone therapy for anyone 16 and older. And with respect to puberty blockers, the UK has restricted new prescriptions outside of research settings. But the Cass implementation plan itself makes clear that if a medical team determines that these medications are necessary for a particular patient, they will be provided. And that is
the restriction that I mentioned was imposed by the British government some months ago. It was reaffirmed by the current Labour government, was it not? It was upheld by the High Court of Justice as based on sufficient medical evidence. Isn't all of that true?
I believe that all of that's true. It's outside the record in this case, and so I haven't myself confirmed everything that you just cited, which wasn't before the district court in this case. But let me make a couple of additional points. To the extent that you think that this needs to be taken into account in the application of heightened scrutiny, there's a time and a place for that, and it's with record evidence on remand. We think the court here just needs to recognize the sex-based classification in this statute and send the case back. If the court wants to go ahead and look at what's happening in Europe, the UK has not categorically banned this care. Sweden, Finland, and Norway, the other jurisdictions that my friends point to, have not banned this care. And I think that's because of the recognition that this care can provide critical, sometimes life-saving benefits for individuals with severe gender dysphoria.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
In your opening brief, you did not mention any of these European developments, and in your reply brief, is it not true that you just relegated the Cass report to a footnote?
So, Justice Alito, with respect to the developments, there has been no change in the law that I'm aware of in Sweden, Finland, and Norway. Each of the medical authorities in those states has called for an individualized approach to care. They've said it shouldn't be routinely applied, but they have not changed their laws to do anything like what Tennessee is doing here, which is to categorically ban it no matter the need. With respect to the CASP report, that isn't in the record in this case, but we have discussed that report in our reply brief. And as I just noted, it likewise recognizes the need for this care in individual cases. The UK has not banned the care, and Hillary CASP is not calling for such a ban.
Your primary argument in your oral presentation this morning is based on Bostock-like reasoning. Is that not correct?
I think that's incorrect. Our primary argument is that this statute on its face says you can't have medications inconsistent with sex. And no matter what you think about transgender discrimination generally, that's a sex-based line. It's no different than saying you can't dress inconsistent with your sex. My friends concede on page 25 of their brief that's obviously a facial sex classification, but our primary argument is SB 1 is worded exactly the same way and it works exactly the same way.
Well, you have a Bostock-like argument, and you say that a girl who wants to live like a boy cannot be administered testosterone, but a boy who wants to live like a boy can be administered testosterone. So, and that's one of your major arguments. I take that to be a Bostock-like argument. So my question is, why should we look to Bostock here? Bostock involved the interpretation of particular language in a particular statute. And this is not a question of statutory interpretation. It's a question of the application of the Equal Protection Clause of the 14th Amendment. And the Court has addressed the question of how an equal protection claim should be analyzed when the law in question treats a medical condition or procedure differently based on a characteristic that is associated with just one sex. And that was Geduldig in 1974, reaffirmed in Dobbs in 2022. And neither Bostock nor Dobbs saw any connection between the Bostock reasoning and the Geduldig-Dobbs standard. Bostock did not mention Geduldig, and Dobbs did not mention Bostock. So why should we look to this Bostock-type reasoning here?
So with respect to how to identify a facial sex classification in the first place, I don't think there's any relevant difference between the Court's approach in Bostock and what this Court has long done under the Equal Protection Clause. In both contexts, the Court has made clear that the right to equal treatment is an individual right, so you look at the particular person and see how the law affects them. And the Court in both contexts has already made clear that sex just needs to be one but-for causal factor. It doesn't have to be the sole reason or the primary reason. So for purposes of identifying whether facial sex classification is happening at the outset, we think it's equal protection principles as much as Bostock that carries the day, although, of course, Bostock reinforces those principles. You asked why this case isn't controlled by Geduldig and Dobbs. The Court's reasoning there was that when you have a statute that doesn't classify based on sex on its face at all, the fact that the medical condition might be something that only one sex can experience isn't a basis to necessarily say that's facial sex discrimination. But that doesn't apply in any relevant respect here. First, because here we have the facial sex classification. The statute says no medications that are inconsistent with your sex. And second, these aren't drugs that are limited to one sex or another. Both males and females alike for decades have been prescribed puberty blockers, hormones, testosterone, estrogen. They produce the same physical characteristics, as I was saying to Justice Thomas, no matter whether your birth sex is male or female. So this doesn't look anything like pregnancy, where the Court found that the medical condition itself was expressly limited to one sex.
Well, I'm not sure that's anything more than a play on words. Suppose the statute said, let's just talk about puberty blockers. Suppose the statute said that puberty blockers may not be prescribed or administered to any minor for the purpose of preventing the onset of puberty prior to the time when puberty generally occurs. Okay, that statute makes no reference whatsoever to anybody's sex. It applies to all minors. Would you say the same thing about that?
So I'm sorry, if I'm understanding the hypothetical correctly, the statute says you can't take puberty blockers before the time when you would ordinarily have puberty, so it's ruling out precocious puberty?
You cannot, no, it doesn't rule out precocious puberty. It rules out the administration of a puberty blocker for the purpose of preventing puberty from occurring at the time when it generally does.
I see. So if you're hypothesizing a statute where, in essence, the legislature is trying to get at the idea of prohibiting access to these medications for gender dysphoria reasons or otherwise, then maybe you would apply an Arlington Heights type of analysis. But, of course, that kind of law that you're hypothesizing would also prevent people from taking puberty blockers if they have cancer and want to preserve their fertility, because it would prevent them from undergoing puberty at the ordinary time. I think that's why the legislature hasn't tried to circumvent a facial sex classification by drafting a law like that. It would have many other applications that the state might not want to aim at. That's very different from a law like this, where the state was being clear, we only want to prevent the medications when it's inconsistent with sex, and we're doing that because we have an interest in having minors appreciate their sex and not be disdainful
Well,
of
let
their
me
sex.
ask one final question that addresses Geduldig and Dobbs. Let's take Geduldig first. One could make the same argument in Geduldig that you've made here. A man cannot, which concerned whether a pregnant woman was entitled to disability benefits for time missed at work, when a man would be entitled to benefits for time missed at work. So in that situation, a man cannot work due to a medical condition that prevents him from working. He gets benefits. The woman cannot work due to a medical condition, pregnancy, that prevents her from working for a period of time. She doesn't get benefits. It's the same argument you're making here. Or we could do it in Dobbs. A man who has a medical condition that causes physical and mental distress and pain and limits his daily activities can get a corrective medical procedure. Let's say it's a hip replacement. But a woman who has a medical condition that produces similar consequences, namely pregnancy, cannot get an abortion. So you can make exactly the same argument that you make here under Geduldig and under Dobbs, and yet there was no equal protection problem in either of those cases.
And that's because the court said that there was no facial sex classification insofar as using pregnancy does not automatically mean that that's a proxy for sex. But here there's a facial sex classification. No one can take these medications if it would be inconsistent with their sex, and that's imposing on the face of the statute two parallel rules on classes of people according to their sex. All adolescent males who want to take these medications to feminize their bodies, and all adolescent females who want to take these medications for masculinizing purposes. That's a facial sex classification through and through, and I don't think it's controlled by Dobbs or Geduldig.
Thank you, General.
Justice Sotomayor?
General, just to unpackage some of this argument, your point, I think, is very clear that Bostock is pertinent only to the extent that whether it's Title VII or the Equal Protection Clause, the first question is the legislature using sex as a classification, correct?
That's right. So our argument is that when you're looking for whether there's a facial sex classification under the Equal Protection Clause, it has always been the same but-for causation principles. And of course we agree with the logic of Bostock, but we think that that logic carries over in this context where the court has already said it just needs to be one but-for cause. It doesn't need to be the only cause. And one way you look at that is seeing whether the application of the statute changes when you change the person's sex.
Now, Bostock is very different than this case, because in Bostock, what we said is if you use sex at all, unless you have a statutory exemption, you can't do it, correct?
Exactly. And I think that's an
here,
important...
Under the Equal Protection Clause, we recognize there are inherent differences between the sexes.
And that can sometimes provide a legitimate basis for classification.
That's the point.
So you're exactly right. The standards for liability are different. Under Bostock and under Title VII, you can't use
With respect to the discussion about the European countries and the fact that they haven't limited these treatments altogether, the Cass report, as you point out, explicitly says that medical intervention might be necessary for some adolescents, correct?
That's right.
And that is recognized by all the European countries, correct?
Yes, I think it's reflected in the laws of those countries which have not outright banned the care.
Isn't the purpose of intermediate scrutiny to make sure that we guard against I'm not intending to insult, but we all have instinctual reactions, whether it's parents or doctors or legislatures, to things that are wrong or right. And for decades, women couldn't hold licenses as butchers or as lawyers because legislatures thought that that we weren't strong enough to pursue those occupations. And some people rightly believe that gender dysphoria may be changed by in some children. But the evidence is very clear that there are some children who actually need this treatment, isn't there?
Yes, I think the evidence is uniform on that, whether you look at the standard of care, whether you look at the view of every major American medical association that has taken a position, many of whom are amici here. It's reflected in the clinical practice. The nation's leading children's hospitals for decades have been providing this care.
Some children suffer incredibly with gender dysphoria, don't they?
Yes, it's a very serious medical condition.
Some attempt suicide?
Yes, the rates of suicide are striking, and it's a vulnerable population.
Drug addiction is very high among some of these children because of their distress, correct?
It is a serious condition,
One of
yes.
the petitioners in this case described throwing up every day, going almost mute because of their inability to speak in a voice that they could live with. These are physically challenging situations as well, too, correct?
Yes, that's correct.
And isn't the purpose of intermediate scrutiny, the level of scrutiny that we apply, necessary to ensure that whether it's legislatures or this court, that we don't make those personal judgments, but that we subject the judgments about these issues to a heightened review to ensure that those children who are going to suffer all of these consequences will be made to do so only when it's compellingly necessary?
Yes, in a circumstance where the state has an important interest. And we don't think that that means the states are entirely barred from regulating in this space. Obviously, they are grappling with these issues in a variety of contexts. But you're right to say that when the state is using sex-based line drawing, a court needs to look at that. And the problem with Tennessee's law here is not that it's just a little bit over-inclusive or a little bit under-inclusive, but that it's a sweeping categorical ban where the legislature didn't even take into account the significant health benefits that can come from providing gender-affirming care, including reduced suicidal ideation and suicide attempts, and where the state leaves unregulated entirely access to these treatments in all other pediatric contexts where there's a similar risk-benefit trade-off. And for the families affected by this, Justice Sotomayor, these are difficult decisions. Obviously, anytime you're thinking about a medical intervention, you need to weigh risks and benefits. But the state has come in here, and in a sharp departure from how it normally addresses this issue, it has completely decided to override the views of the parents, the patients, the doctors who are grappling with these decisions and trying to make those trade-offs.
Thank you.
Justice Kagan?
General, I wanted to get your thoughts first on why one should think of this as primarily a sex-based classification, because there's another way of looking at a law like this, maybe a more obvious way, which is that it's a classification based on transgender status. In other words, there are trans young people on one side of the line and cis young people on the other side of the line, both male and female on both sides of the line. And why what is really going on here, I understand the formal ways in which this is a sex-based classification, but I'm wondering whether that's not a little bit formal. And what's really going on here is a discrimination against, a disregard for young people who are trans, and why we shouldn't think of the law in that way.
I think you can conceive of the law in that way, and we certainly do think that this law discriminates on the basis of transgender status, and that likewise should trigger heightened scrutiny, both because that's inherently a sex-based classification and because we think transgender status discrimination warrants heightened scrutiny in its own right. But I don't think it's unduly formal to look at this as a sex classification, and the reason for that is because of the first operative provision of SB 1, which says you can't have these medications to live or identify in a manner inconsistent with your sex. That is quintessentially imposing sex-based rules and expectations on adolescents in the state, and it's true it arises in the context of medical care for transgender youth. But here we think it's a very straightforward path for the court to look at that and say, well, in any other context, when you say you can't do something inconsistent with a protected characteristic, that's obviously classifying people on the basis of that characteristic. And here it wasn't accidental or incidental. This is threaded throughout the statutory scheme because the legislature was quite upfront that part of the interest here is in ensuring that minors appreciate their sex and not become disdainful of their sex, or as Judge White put it in dissent below, that they look and live like boys and girls. And I think that adds on an additional layer of sex classification here insofar as it shows that part of what the state was attempting to do is ensure that adolescents conform their bodies to the state's physical expectations of how males and females should appear. It's not at all surprising to think of that as a sex classification.
So is what you're saying is that the two are just embedded in each other, or is what you're saying that sex stereotyping is built into our understandings of trans and cis classifications? Or again, is that this more sort of logical analysis that might be found in an opinion like Bostock? And maybe those are not exclusive, but what's your sense of that?
So I think those aren't exclusive. I think they're reinforcing here. And I guess what I would say is I think this is an even easier sex classification than maybe the one the court confronted in Bostock or the one the court would confront if the statute simply discriminated on the basis of transgender status, because here the legislature actually put the sex classification into the face of the law and made the first order restriction here one that prohibits inconsistency with sex. And I just go back to the kinds of examples we give about dressing inconsistent with sex or pursuing a profession inconsistent with sex. I think the court's recognition that that is a sex classification is obviously right, but it also can build in a layer of conformance with sex stereotypes that might be underlying those laws and that we think equally underlie this one.
So let me flip now to what it means to do heightened scrutiny in this area, because as you point out, this law, and I think almost all of the similar, or maybe all of the similar laws that have been passed like this, allow this exact same kind of treatment for the opposite purpose, if you will. For a person born male who wants to get to puberty already,
Right.
And you say that that's a kind of under-inclusion problem, and it strikes me that on formal equal protection analysis, it is, unless the state can come forward with some piece of medical evidence that says that the risks are greater in the one area than in the other area, which you say Tennessee has not done. I guess what I'm asking is, isn't the structure of these laws going to mean that all of them are going to have to be struck down once you get to heightened scrutiny? Because you seem to want to say, no, you can do heightened scrutiny, but you can also make certain deferential moves towards the legislature. And I guess I'm pressing you on whether that's really true.
So I think it is true. To be sure, we think that a categorical ban like this one is severely under-inclusive and also severely over-inclusive, which is an important ingredient here, and so should be invalidated. And if other states likewise have this kind of sweeping ban, then they would fail under heightened scrutiny. But I don't think that means that heightened scrutiny ties the hands of the states in this regard. One of the problems with the state's approach here is that although it has targeted this gender-affirming care for disparate treatment on the basis of sex, as we say, it has left these exact same medications entirely unregulated for all other purposes and also turned its back on how it handles the risk-benefit calculus with respect to all other pediatric treatments. But we do think there is a real space for states to regulate here, and I point to the example of West Virginia. West Virginia was thinking about a total ban like this one on care for minors, but then the Senate Majority Leader in West Virginia, who's a doctor, looked at the underlying studies that demonstrate sharply reduced associations with suicidal ideation and suicide attempts, and the West Virginia legislature changed course and imposed a set of guardrails that are far more precisely tailored to concerns surrounding the delivery of this care. West Virginia requires that 2 different doctors diagnose the gender dysphoria and find that it's severe and that the treatment is medically necessary to guard against the risk of self-harm. The West Virginia law also requires mental health screening to try to rule out confounding diagnoses. It requires the parents to agree and the primary care physician to agree. And I think a law like that is going to fare much better under heightened scrutiny precisely because it would be tailored to the precise interests and not serve a more sweeping interest like the one asserted here in having minors appreciate their sex.
Thank you, General.
Justice Gorsuch? Justice Kavanaugh?
First, I want to ask about our role here and pick up on the Chief Justice's questions at the beginning. Who decides? I mean, you've put forth forceful policy arguments to allow these medical treatments, and Justice Sotomayor's questions elaborated on that. But the 20-plus states on the other side put forth very forceful arguments against allowing these medical treatments for minors. So it seems to me that we look to the Constitution, and the Constitution doesn't take sides on how to resolve that medical and policy debate. The Constitution's neutral on the question. At least that's one way to look at it. I want to get your reaction to that. If the Constitution doesn't take sides, if there's strong, forceful, scientific policy arguments on both sides in a situation like this, why isn't it best to leave it to the democratic process?
Well, I do think that the Constitution takes a position that individuals are entitled to equal protection of the law, and I totally understand the force of your intuition that states need space to regulate and to try to take into account concerns like adolescent health. We're not denying that that's an important interest here, but when you look at how this law actually operates, what it is doing is denying individual plaintiffs the ability to access medications on the basis of their sex. And that doesn't mean that the states are disabled from taking into account the actual biological differences between males and females, but that has to be channeled to the heightened scrutiny stage. And I think that there would be a real danger in this court saying, looking ahead essentially and saying, we think there might be benign justifications here, or we think that states should have some flexibility in this regard to overlook the facial sex classification in the statute. If you are concerned, Justice Kavanaugh, about moving too fast in this space and maybe restricting the ability of states to take a close look at these issues, I think the court could write a very narrow opinion in this case, and the court could say simply that when you prohibit conduct that's inconsistent with sex, that is a sex-based line, so you do have to apply heightened scrutiny. But the court has made clear that that's an intermediate standard, and if the state can come forward with an important interest and substantiate that it needed to draw those sex-based lines to substantially serve the interest, that's going to be okay.
Keep going, sorry.
And the final point is, then you can send it back and let the Sixth Circuit grapple with this in the first instance.
On the sex discrimination point, I guess picking up on Justice Kagan's questions, I mean, the way you would think about this is, I guess, it prohibits all boys and girls from transitioning using certain medical treatments, and it doesn't say only boys can do so or only girls can do so.
Well, I think the problem with trying to put that transitioning label on it as a basis to avoid the sex classification is that transition itself is inherently tied to sex. In other words, the prohibited purpose here are those treatments that would allow a minor to live and identify inconsistent with sex, and the statute would permit anyone to have those treatments for the non-prohibited purpose, which again is when it's consistent with sex. The court has said many times that labels don't control in this space, and I think when you have that kind of purpose that's expressly defined using sex-based line drawing, you have to recognize that for what it is.
And no matter how you articulate the standard, whether it's rational basis or intermediate scrutiny, it'll come down to whether the state, and I think you said this, has sufficient justification for limiting these treatments for minors. And the state says its justification here is health and safety for minors. You say there are benefits from allowing these treatments, but there are also harms, right, from allowing these treatments. At least the state says so, including lost fertility, the physical and psychological effects on those who later change their mind. and want to detransition, which I don't think we can ignore. We can't ignore what you're talking about and what Justice Sotomayor raised. I agree with that, but you can't ignore, I think, the risks on the other side of the balance. So even if it is intermediate scrutiny or rational basis, those justifications for the state, how do we as a court choose which set of risks is more serious in deciding whether to constitutionalize this whole area?
So let me react to a couple of different points you brought up. First of all, I do think that the standard of review very much matters. And the court has made clear that rational basis is an entirely forgiving standard. It applies to, mundane economic regulation where there's no reason for courts to take a closer look. So I think the court should hold the line that any time the state classifies based on sex, you do need to take a look at that. But I totally take the point that, of course, when a state is coming forward with an important interest like protecting adolescent health, that may well justify the lines the state has drawn. And it's not about asking courts to step in and make a first-order determination about how to weigh risks and benefits. But I do think that the state is under a basic obligation to first substantiate its concern. And here there were extensive factual findings by the district court that many of the risks that the state was asserting are not uniquely tied to gender-affirming care at all. And also to take into account the harms that would come from categorically banning access to medications on the basis of drugs, including the benefits that I was discussing with Justice Sotomayor. You mentioned fertility and regret, and I'd like to take both of those concerns head on. I do want to acknowledge that there is evidence to suggest that gender-affirming care with respect to hormones can have some impacts on fertility. Critically, puberty blockers have no effect in and of themselves on fertility, so I don't think that concern can justify the ban on puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity. With respect to hormone use, there are some effects on fertility, but the court found that many individuals who are transgender remain fertile after taking these medications. They can conceive biological children. There are fertility preservation measures that they can undertake, and that they have to be counseled on those risks. And as I said before, I can understand that that could be a hard trade-off, but it's not unique to this care. There are other treatments for adolescents that likewise affect fertility, including some of those that SB 1 expressly permits, like on intersex individuals who often have surgeries as infants that might permanently affect their fertility. I would also say that if you are concerned about fertility, there are measures the state could undertake, like requiring warnings, more informed counseling, trying to ensure that there's informed consent in this area. You also mentioned the possibility of regret. The record evidence demonstrates that the rates of regret are very low because for the population that has access to this treatment, so these are adolescents who have marked and sustained gender dysphoria that has worsened with the onset of puberty, they are very likely to persist in their gender identity. But if you're thinking about this from the standpoint of there's no harm in just making them wait until they're adults, I think you have to recognize that the effect of denying this care is to produce irreversible physical effects that are consistent with their birth sex, because they have to go through puberty before they turn 18. So essentially what this law is doing is saying we're going to make all adolescents in the state develop the physical secondary sex characteristics consistent with their gender or with their sex assigned at birth, even though that might significantly worsen gender dysphoria, increase the risk of suicide, and I think critically make it much harder to live and be accepted in their gender identity as an adult. Because if you're requiring someone to undergo a male puberty and they develop an Adam's apple, that's going to be hard to reverse, and they're more likely to be identified as transgender and subject to discrimination and harassment as adults. So I think the relevant question is, you have this population of adolescents, and there are documented very essential benefits for a large number of them, and maybe a small number that will regret this care, just like with any other medical care. But for the state to come in and just say, across the board, you can't have the medication because of your birth sex, we don't think that's a tailored law.
You acknowledge there is some group, though, who later changes their mind and wants to detransition. That doesn't defeat your case. I just want to make sure you acknowledge there is, as a factual matter, some group of people. Yes.
We're certainly not denying that some people might detransition or regret this care, but all of the available evidence shows that it's a very small number.
Then to pick up on the Chief Justice and Justice Alito's questions, it's obviously a evolving debate. I mean, just in the last couple of years in Europe, there's big changes in terms of how they're thinking about it and how they're thinking about these risks and benefits that you and I have just been talking about and you've been elaborating. if it's evolving like that and changing, and England's pulling back and Sweden's pulling back, it strikes me as, pretty heavy yellow light, if not red light, for this court to come in, the 9 of us, and to constitutionalize the whole area when the rest of the world, or at least the countries that have been at the forefront of this, are pumping the brakes on this kind of treatment because of concerns about the risks.
We certainly are not asking the court to set forth some bright-line constitutional rules in this space that is going to really take further debate and evaluation of regulatory options away from states. We think, as I mentioned, that the court really only needs to decide the first-order question here of whether this law classifies based on sex. I think that's entirely distinct from some of the concerns you've identified about what justifications the state has.
Do you think that West Virginia law you mentioned is constitutional?
I think it would likely satisfy heightened scrutiny. It hasn't been subject to adversarial testing because I don't think anyone has sued to challenge it, so I haven't looked at the record that West Virginia would build, but I do think that there is room here for states to enact tailored measures to try to guard against the kind of risks that you're concerned about and that the state has identified. And
last topic on the heightened review, and you say all we need to do is do heightened review, and that's kind of a minimal step. I mean, I'm not sure, really, that the follow-on effects of that could be pretty significant. I think Justice Kagan alluded to that in her question, or at least raised that as a question. And I want to ask in particular about one thing. If you prevail here on the standard of review, what would that mean for women's and girls' sports in particular? Would transgender athletes have a constitutional right, as you see it, to play in women's and girls' sports, basketball, swimming, volleyball, track, et cetera, notwithstanding the competitive fairness and safety issues that have been vocally raised by some female athletes seen in the amicus brief of the many women athletes in this case? So can you explain how intermediate scrutiny would apply to women's sports?
Yes, and just as a threshold clarifying point, I want to be clear that when it comes to access to sex-separated spaces like sports and bathrooms, courts already recognize that those are facial sex classifications that trigger heightened scrutiny. So it's actually not the question teed up here about how to classify the law in the first place or how to identify whether it's a sex classification. Instead, that's taken as given in that litigation, and the entire focal point of the disputes in those cases has been, well, does the state have an important governmental interest, and does it need to draw the lines to exclude transgender people? Right,
but how would intermediate scrutiny, which we may not, if we went to intermediate scrutiny, there's a possibility we would apply it here. How would it apply to, in your view, and maybe you don't have fully informed views, which would be fine, but how do you think it would apply to sports?
So courts have split on that issue, and I hesitate to try in a vacuum without an actual factual record to try to opine on the state's justification and whether it will satisfy that standard. It's obviously a different set of governmental interests that are being asserted there, and those would have to be analyzed in their own right. But I think that this court, if it wants to preserve space to make clear that nothing here should be understood to affect the separate questions that are arising there, the court could very well do so, and we would have no objection to explicit language saying this decision does not in any way or should not be understood to affect the separate state interests there that have to be evaluated on their own terms.
Okay, but looking ahead, do you think it's logically possible as a matter of constitutional decision-making to say that laws like the one at issue here do not satisfy intermediate scrutiny, but laws that restrict women's and girls' sports in a way that transgender athletes cannot participate would satisfy intermediate scrutiny? Is that logically possible?
Oh, yes, definitely. So we do think intermediate scrutiny applies in both contexts, but there are a different set of state interests at play. And I think one readily apparent difference is that in the context of sports, there are arguments made that that affects the rights of cisgender women, and that the ability to allow transgender women to compete on those teams is going to be other regarding in the sense of having those external impacts. There's nothing like this here. Allowing transgender individuals who have carefully thought about this and consulted with their parents and their medical team to access these medications that have health benefits recognized here and abroad in no way affects the rights of other people. And so I think the court could well understand the statute here to fail intermediate scrutiny, even if it would survive there.
Thank you.
Justice Barrett?
Morning, General. I want to pick up on one of Justice Kavanaugh's early questions. He pointed out that the burdens of the law fall equally on boys and girls because neither can transition. And you responded that it's kind of the sex classification or the expectations that one will conform to one's, biological or gender assigned at birth. Why isn't that more of an Arlington Heights argument about intentional discrimination then, if what you're really saying or what the legislature is really saying is the burden of this is going to be equally applicable. Neither boys nor girls can have access to these drugs. But the reason why is because we want girls to be girls and boys to be boys, at least until they're old enough to decide otherwise.
So I think it would be wrong to overlook the fact that even separate and apart from any interest in conformity here or sex stereotyping, this is a law on its face that does not subject boys and girls to equal treatment. And you can see that if you look at how the law applies to some of the individual plaintiffs. Take Ryan Rowe, who is one of the individual plaintiffs here. He wants to take testosterone in order to live and identify as a boy, and he's prohibited by SB 1 from doing so because his birth sex was female. But if you change Ryan's birth sex and suppose he was assigned male at birth, then SB 1's restriction lifts. So he is not being treated the same as a boy, who was assigned male at birth. And I think that is the kind of quintessential test the court has applied for purposes of identifying when there's a sex classification.
So what would your argument be if a new drug is developed within, say, 2 or 3 years that just the only purpose of the drug, there's no precocious puberty purpose or anything like that, the only reason to give this drug is it targets minors who have gender dysphoria particularly. And a state passes a law, the FDA approves it, so it's available in some states, but a state passes a law saying no one has access to it. So now you don't have that whole thing falls out.
Yeah. So that would not be a facial sex classification. And there I do think that you would have to apply an Arlington Heights type of analysis to see whether the context and history demonstrate that actually the state was intending to treat people differently based on their sex. But I think that would function very differently from SB 1.
Why don't you have an Arlington Heights argument here, too? Because I take it one thing you think would be wrong with that law is the stereotyping function.
Well, I think that Arlington Heights doesn't seem like the natural doctrinal home for a law like SB 1 that says on its face you can't act inconsistent with sex. And I take your point about that's applying some equal rules to boys and girls, but that's true anytime you have a law that says you can't act inconsistent with a characteristic. That means that there's going to be a restriction on males and a restriction on females. It's true of any other factor, too, inconsistent with race, inconsistent with religion. You might say, well, that's not just singling out one religion or one race or one sex for disparate treatment, but I think it actually increases the number of classifications when you're applying parallel restrictive rules on the basis of a protected characteristic across the board.
So let me return to Justice Kagan's questions. She asked you whether really the more natural way to think about this is that it is discriminating on the basis of transgender status rather than, I feel like trying to make the Bostock-like argument, holding all things equal, or that you have to do this by reference to, biological sex, feels like an odd way to solve the problem, and kind of that hypothetical I gave you about the drug that just has the transitioning purpose. So if we just head-on confront the question which you raise in the second part of your brief about whether transgender status should be a suspect class, one question I have is, at least as far as I can think of, we don't have a history of de jure, or that I know of, we don't have a history of de jure discrimination against transgender people, right? You point out in your brief that in the last 3 years there have been these laws. But before that, we might have had private societal discrimination. But I don't know of, but is there a history that I don't know about where we have de jure discrimination? And my concern about it is this: all of the other suspect classes that we've recognized so far do have that long de jure history of discrimination. And, the Equal Protection Clause applies to state action, so it feels like an odd fit to say that in their private lives, people have discriminated against transgender people. Therefore, we're going to treat it as a suspect class for purposes of the Equal Protection Clause.
So I think you may be right that the discrimination, historical discrimination against transgender people may not have been reflected in the laws, but I think there's no dispute that there is a broad history here, and it hasn't just been confined to private actors. I think that if you actually looked at the facts, there's a wealth of evidence to suggest that transgender people throughout history have been subjected to violence and discrimination and maybe lost employment opportunities or housing opportunities, even in contexts where there might be state public employment at play. And of course, that's especially reflected now in the law, where there has been this, I think, attention and focus on trying to limit transgender people from being able to live and identify consistent with their gender identity in our society. So I don't even understand the state to be disputing the historical discrimination point. But if you're approaching this from the standpoint of saying, is this a group with a distinguishing characteristic that has no bearing on their ability to contribute and that needs some protection from the courts, I think if any group qualifies, this one does in light of the current laws and what might come in the future. And our basic argument is, if you can look ahead and say, maybe the states will ban medical care for adults who are transgender, maybe they'll ban adoption by transgender people or not allow them to be teachers, that doesn't look anything like the workaday economic regulation that just gets rational basis review. And I think the court could give effect to that intuition.
Yeah, and I don't want to be misunderstood to say that I don't think there's a problem or that there hasn't been private discrimination. I guess it doesn't seem analogous to me to say race or gender or national origin, those kinds of things, because we did have de jure discrimination to point to. And so I guess what I'm thinking is, when we are in the business of identifying suspect classes, in Cleburne, we expressed, and I'm not saying that this is analogous to Cleburne in that respect, but we expressed in Cleburne hesitancy, to identify groups such as the elderly, or the mentally disabled as suspect classes, in part because those are judgments that are pretty hard for courts to make. And at least de jure discrimination of the sort experienced by women, or people on the basis of race gives us something to point to if we're going to be identifying a new suspect class, which we haven't done for a long time.
Yeah, and I, of course, take that point, and I should reiterate, we don't think the court has to confront it here. But in the cases involving age and disability, I understand the court to have approached those issues with somewhat different reasoning, that age is something we all experience, that disability is a broad and diverse group, and that individuals with disabilities have been able to harness the majoritarian political forces to protect their rights. And none of that is true here. Transgender individuals are a discrete minority. I think there's no dispute that they are being subject to a wave of legislation across the states today. And I think that this is the kind of circumstance where the court could rightly recognize that heightened scrutiny should apply.
Last question. Do you agree with me that the resolution of this case has no impact on the parental rights claim that the Sixth Circuit also addressed?
That's right. I think we are not making a substantive due process parental rights claim here, and this court obviously didn't grant review of that issue. I will say that I think parental rights are actually relevant to the Equal Protection Clause as well, insofar as it's significant to me that Tennessee, in choosing to categorically ban this care, is taking a sharp turn away from how it ordinarily handles parental rights in the medical decision-making space. And Justice Kavanaugh said, who decides here? But when it comes to medical risks and benefits, the state's general approach is to say parents get to decide along with their doctors and their children. And so I think from the standpoint of under-inclusivity, it's pretty significant that Tennessee now is completely overriding parents' wishes when they are best positioned to know their individual child and to have a good sense of whether the risks of this treatment are outweighed by the benefits.
But this isn't, I guess my point is, even if we decided that this wasn't a sex-based classification that triggered intermediate scrutiny, that would not prevent parents from still asserting the substantive due process right.
Yes, of course. I agree with that. I do think that the sex-based classification under Equal Protection Clause is the most straightforward way to think about what's going on here, though.
Yeah. Thanks.
Justice Jackson?
So I'm glad that you've clarified that how we characterize this law is really the issue on the table today, not the risks or benefits or the policies that justify it, but how we characterize it. And I guess I think there might be some confusion a little bit, at least I'm confused, because there's so many lines that this statute could draw. The classification, as far as I can tell, is a line drawing, is the statute drawing lines, and there are lots of different ones. And Tennessee says this is drawing a line between people on the basis of age and purpose, and I totally see that. You say this is drawing a line on the basis of sex. I see that as well. But I guess my sort of initial question is, are those mutually exclusive? Do we have to choose between those characterizations? Isn't there a world in which this statute is doing both of those things? And the question for equal protection purposes is, if you're right that there is a sex-based line being drawn, then to the extent the plaintiffs are implicated by that line, don't we have to apply heightened scrutiny in evaluating their claims?
Yes, that's exactly right. And I think, of course, you could say this is a statute that classifies based on age and purpose and sex. Critically, we think that purpose incorporates sex here because the purpose is expressly defined in terms of treatments that are inconsistent with sex.
Right.
So I think the problem with the state's approach is to say, well, it's just purpose going on. You take one look at that, and that just dissolves down into drawing a sex-based line itself.
Can we put more flesh on that, though? Because, I mean, even if we separate out their age and purpose, and we just say, okay, so how is this actually drawing a line on the basis of sex? I think I heard you say it a couple times with respect to some examples, but I think it would be helpful to get on the table exactly who's falling on what side of the line in a particular situation related to sex.
Yes. So the way that the sex-based classification is working here is that from the standpoint of any individual who wants to take these medications, their sex determines whether SB1 applies. John Doe, one of the plaintiffs, wants to take puberty blockers to undergo a typical male puberty. But SB1 says that because John's sex at birth was female, he can't have access to those medications. And if you change his sex, then the restriction under SB1 lifts and it changes the result. And my friends say, well, that also simultaneously changes the medical purpose of using these medications. We don't dispute that point, that it might also inherently change purpose when you're changing sex.
But it doesn't have to, right? I thought of an example in which we have a plaintiff, a person a minor, who would like to take this medication to affirm their gender as a male because the medication deepens their voice, for example. They want a deeper voice, and they're biologically male. They're taking the medication because that's what they want. They, I think, can get that medication.
That's right. And
but a person who is biologically female who wants to take the medication for that same purpose, to deepen their voice because they would like to live as a male, can't get it. Is that right?
That's correct. And that is on the basis of their sex.
So the purpose is held constant with that example. It's not changing. What is changing is just the biological sex of the individual.
I think that that's correct. But even in a circumstance where you might characterize that as treating delayed puberty instead of gender dysphoria, if you said, well, there is a different purpose there, even though the effects are exactly the same and they want the medications for exactly the same reason, that doesn't eliminate the sex-based classification because sex only has to be one but-for cause of disparate treatment. And I think the state will say it's perfectly reasonable to treat different medical purposes or uses differently. We don't disagree, but that's something that's channeled to the application of heightened scrutiny. And if the state has a really good reason to say there's a danger in using these drugs if your birth sex was female and you want to deepen your voice,
right.
And it's different.
So that's Justice Alito's studies and all of this.
Exactly. That all goes to the application of heightened scrutiny, and maybe the state can prove it up and show they have an important state interest and they really have a reason to distinguish between who can have these drugs for which purposes based on their sex. But that doesn't eliminate the facial sex classification or provide a reason for this court to turn its back on 50 years of precedent saying if you classify based on sex, you have to justify that.
And it's interesting to me that you mentioned precedent because some of these questions about sort of who decides and the concerns and legislative prerogatives, et cetera, sound very familiar to me. They sound in the same kinds of arguments that were made back in the day, 50s, 60s, with respect to racial classifications and inconsistencies. I'm thinking in particular about Loving, and I'm wondering whether you've thought about the parallels, because I see one, as to how this statute operates and how the anti-miscegenation statutes in Virginia operated.
Yes, and I think the court has recognized that the Equal Protection Clause was intended to force some changes in society and get us to think more closely about the way that people were being classified, including when that was based on overbroad generalizations of how we expect them to live and order their affairs. And the court has made that clear in the sex discrimination cases as well, where it said sometimes these laws operate to disadvantage someone who falls outside the average description, and that person needs the protection of the court.
Well, and I think I thought what was most interesting about the potential comparison to Loving is that in that case, everyone seemed to concede up front that a racial classification was being drawn by the statute. That was sort of like the starting point. The question was whether it was discriminatory because it applied to both races and it wasn't, necessarily invidious or whatever. But, as I read the statute here, the case here, the court starts off by saying that Virginia is now one of 16 states which prohibit and punish marriages on the basis of racial classifications. And when you look at the structure of that law, it looks in terms of, you can't do something that is inconsistent with your own characteristics. It's sort of the same thing. So it's interesting to me that we now have this different argument, and I wonder whether Virginia could have gotten away with what they did here by just making a classification argument the way that Tennessee is in this case.
Yes, I think that's exactly right, that there is absolutely a parallel between any law that says you can't act inconsistent with a protected characteristic, and in all other contexts, the court has recognized that as a facial classification based on that characteristic, and Tennessee even concedes the point when it comes to dress codes and to seeking a profession inconsistent with sex. But I think one other way to look at this, Justice Jackson, is that, to me, it would be a remarkable proposition for this court to say that a statute that on its face says you can't have medications inconsistent with your sex, and in part that's because we want you to appreciate your sex, isn't drawing a sex-based line in the first place. That would have no correspondence to or grounding in the text of the statute or how it works in operation or what effects it produces for individuals on the ground.
Thank you.
Thank you, counsel. Mr. Strangio?
Mr. Chief Justice, and may it please the court. On its face, SB 1 bans medical care only when it is inconsistent with a person's birth sex. An adolescent can receive medical treatment to live and identify as a boy if his birth sex is male but not female. And an adolescent can receive medical treatment to live and identify as a girl if her birth sex is female but not male. Tennessee claims this sex-based line drawing is justified to protect children. But SB 1 has taken away the only treatment that relieved years of suffering for each of the adolescent plaintiffs. And critically, Tennessee's arguments that SB 1 is sex neutral would apply if the state banned this care for adults too. By banning treatment only when it allows an adolescent to live, identify, or appear inconsistent with their birth sex, SB 1 warrants heightened scrutiny under decades of precedent. Because the Sixth Circuit failed to apply that standard, this court should vacate and remand. I welcome the court's questions.
If you are successful, what would your remedy be?
Your Honor, if we're successful here, the remedy would be to enjoin the state of Tennessee defendants from enforcing SB 1 as applied to our individual plaintiffs. So, in practical terms, what would it be? What would you get? Wouldn't you get you would get different treatment based on sex? In practical terms, what it would mean is that an individual like John Doe, who is receiving medical treatment to undergo a typical male puberty prior to SB 1 and is now barred from doing so because his birth sex is female, could then receive that treatment as he had been doing with the consent of his parents. So his sex would no longer be the basis for the denial of the medical care that his doctors recommended and his parents consented to.
Counsel, is there any significant respect in which your position departs from that of the Solicitor General?
No, Your Honor. The only argument that we make before the court here that the Solicitor General has not advanced is that this is a law that fails under any standard of review, that it is so discontinuous with the asserted interest in protecting children and therefore fails under any standard. But we think, as the Solicitor General made clear in her remarks, that it is clearly a sex classification on its face and should be resolved on that basis and remanded for the Sixth Circuit to apply that standard in the first instance.
Is there anything you would like to add, and maybe there isn't, but with respect to the Solicitor General's responses to my concern that this is unlike a case like Craig versus Bourne, unlike a case like Morales, and those where it was quite clearly simply stereotyping with respect, can men have the same rights as women with respect to adoption and the liquor laws. This does strike me, whatever you think about the disagreements between where Europe was some years ago and where Europe is now, where Europe is, where the United States is, in that it is quite a distinct type of inquiry that involves medical expertise, predictive judgments in the medical area than in those cases?
I don't dispute, Mr. Chief Justice, that at the application of heightened scrutiny, there will be particular considerations that involve the underlying medical evidence, as there always is. But I don't think that it would break new ground to apply heightened scrutiny here. The purpose of applying heightened scrutiny has been because, in part, we don't know at the outset whether a classification is benign. And many justifications for sex-based differential treatment in law were defended on the ground of biological differences and were upheld by the court under rational basis. And the role of heightened scrutiny is not to make sex a proscribed classification. It is just to shift the burden to the state to show their work and show that, in fact, this is a law that substantially advances an important governmental interest.
Counsel, are there other situations, the Chief Justice's question just made me think of this, in which any of our levels of heightened scrutiny, whether they be intermediate or strict, require courts to make the judgment, the means-ends calculation in this kind of medical context? Because I agree with you. I mean, I can see your point, like, well, as a matter of logic, we should shift this to that stage, assuming that the suspect class is triggered and we say this is sex classification. But is there any other situation in which courts get into that? In the tiers of scrutiny?
I mean, so I would point, Your Honor, to recent cases involving the COVID-19 pandemic, in which many cases came up before this court, in which the states were regulating, undeniably in areas of public health and evolving science, and the court repeatedly made clear that, yes, of course, the states have latitude through their police power to regulate, but when they do so in ways that classifies based on suspect lines or infringes constitutional rights, then heightened scrutiny remains the standard that the courts apply to ensure that the state is advancing an important governmental interest.
Yeah, I guess I'm thinking of some. Can I just last follow-up? But even in those COVID-19 cases, courts weren't, and we certainly weren't, diving deep into the medical evidence and comparing Europe and America and looking at research. I mean, this would be, I think, of a different order. Do you agree?
I don't agree, Justice Barrett, in the sense that I do think it is precisely the role of the courts to assess the tailoring and look at the evidence, whether it's presented through expert testimony or not. It is not the role of the court necessarily to say definitively these risks outweigh these benefits or vice versa, but do what the district court did here, which is to look at the assertions of harm, make comparisons to how Tennessee treated all other medical care, and then see whether or not Tennessee had met its burden under heightened scrutiny. That type of tailoring inquiry, I believe, is precisely the role of the court.
Counsel, in the COVID, I have a colleague to my right, whom I think very highly of, who spoke about the need of the courts to look at that evidence to ensure that there wasn't suppression of religion, correct?
That's correct, Justice Sotomayor.
Now, with respect to Justice Barrett's question on COVID, in my mind, it's a little more similar to the bathroom situation, because there, COVID was a risk not just to the individual and the threat to their own life, but their contact with others could threaten others. So the compelling state interest was different than just a pure medical issue, correct?
That's correct. I totally agree. The state interest was different.
All right. With respect to treating that issue, you can hear from some of my colleagues that they're worried that, and there is a plethora of science in this area, both that developed in Europe, and the lower court hasn't really looked at it. No one has. That courts are ill-suited to that. Why do you think they're not? What about the fundamental role of the court makes us suited to answer those questions?
Well, I think first, Justice Sotomayor, the role of the court is to ensure that when the government draws lines based on suspect classifications, that the states are tested to ensure that they're substantially advancing an important governmental interest. And when it concerns underlying questions of medicine or science, the judges and judges in the lower courts have every ability to assess the testimony before them, as the district court did here. This is not an area where I believe Tennessee is saying that medicine is altogether an area in which suspect classifications have no bearing on the judicial inquiry. It is precisely the role of the court to ensure that the government of Tennessee has substantially advanced an important governmental interest.
I have one small question to finish with. The regret issue that was raised to the Solicitor General. Respondents cite a figure of 85% of children expressing gender dysphoria regret later. You use a figure of 1% of minors who receive this treatment expressing regret. Can you tell me where those figures lie and exactly what the difference is between that 1% of children who receive these treatments expressing regret and the 85%?
Certainly, Justice Sotomayor. And so the first point I would say about the 85%, and we address this on page 22 of our reply brief, that's a misleading figure for two reasons. I think most critically, it refers to older studies of prepubertal children. And everyone here agrees that the medications that are banned by SB 1 are only prescribed to individuals after the onset of puberty. And so in JA 151 to 153, the evidence shows that once an adolescent reaches the onset of puberty, their likelihood to ultimately desist and identify with their birth sex is very low. And then as to the question of the 1%, the question of regret, which is a different question than what happens with prepubertal children, the record shows there that the rate of regret when people receive this medication after the onset of puberty is as low as 1%, and that's in JA 131 to 133. And I think what's important here, and the Solicitor General mentioned this, is that is exponentially lower than the rates of regret of treatments that are expressly permitted by SB 1.
Thank you, Counsel.
Could we explore what intermediate scrutiny might look like in operation in assessing laws like Tennessee's? So the Solicitor General on page 48 of her brief lists a lot of things that she says, well, if Tennessee were really concerned about the health and welfare of these minors, it would have taken into account a variety of things. So one is waiting periods. Another is whether puberty blockers should be exempted. Another concerns things to make sure that the future of these minors is properly respected, even though they personally cannot make mature judgments about potentially irreversible procedures. So she mentions things like two-parent consent or counseling, readiness criteria, age recommendations, licensing, certification, or reporting requirements for physicians, and other guardrails which are not specified. So if intermediate scrutiny were the regime that would apply, would it not be the case that judges would have to decide whether a particular package containing this much of that and that much of the other thing is sufficient? Wouldn't this be endless litigation with the decision based on determinations by lay judges regarding complicated medical issues?
So if I could make 2 points in response, Justice Alito. And the first is going back to the Solicitor General's example of West Virginia, where West Virginia looked at the underlying science and instead of categorically banning this medical treatment, created pathways with guardrails for individuals to access medical care. There has been no litigation over West Virginia's law, and if there were in other contexts, the question would remain whether or not the state could make out the showing that this is being treated in such a substantially different way than other forms of medical care. I do think that judges are equipped to make those determinations as they do in many other contexts.
A lot of categorical statements have been made this morning in argument and in the briefs about medical questions that seem to me to be hotly disputed. And that's a bit distressing. One of them has to do with the risk of suicide. Do you maintain that the procedures and medications in question reduce the risk of suicide?
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record. I think, as with all underlying questions of looking at evidence, there can be disagreement. I don't dispute that. But here, and sort of going back to questions about the Cass review, for example, the Cass review only looked at studies up until 2022.
Well, I don't regard the Cass review as necessarily as the Bible or as something that's true in every respect. But on page 195 of the Cass report, it says, there is no evidence that gender affirmative treatments reduce suicide.
What I think that is referring to is there is no evidence in the studies that this treatment reduces completed suicide. And the reason for that is completed suicide, thankfully and admittedly, is rare, and we're talking about a very small population of individuals with studies that don't necessarily have completed suicides within them. However, there are multiple studies, long-term longitudinal studies, that do show that there is a reduction in suicidality, which I think is a positive outcome to this treatment.
Let me ask a question about another issue that came up during Justice Kagan's questioning and Justice Barrett's questioning in particular, and that is whether transgender status should be regarded as a quasi-suspect classification. And Justice Barrett referred to one of the things that our cases have mentioned in explaining when something should be classified as a quasi-suspect classification, and that is a history of discrimination. Another one is immutability. Is transgender status immutable?
May I answer, Mr. Chief Justice?
Sure.
So I would say that under this court's consideration of that criteria, it is a distinguishing characteristic. Transgender people are characterized by having a gender identity that differs from their birth sex. That is distinguishing and discrete. And that also within the characterization, I would also point, if I could, to the history of discrimination, and there are many examples of in-law discrimination, exclusions from the military, criminal bans on cross-dressing, and others.
Thank you, counsel. I think I lost track of the discussion you were having about COVID. What was the point you were trying to make?
I think
somebody was trying to make.
Yes, I think it was me, and the point about COVID and the question of whether or not this court has ever considered applying heightened scrutiny to contexts in which states are grappling with evolving medical evidence, and I would point to Justice Gorsuch's statement in South Bay United Pentecostal, in which the purpose of heightened scrutiny, even when the government is grappling with experts of a medical character, is to still test whether or not that infringement on an individual right or that use of a suspect classification meets the heightened scrutiny standard. It's not exempt simply because it is in the context of public health or medicine.
Well, I don't want to relive the COVID cases.
You and me both, yeah.
But it does seem to me that one of the issues that came up, and as to which courts around the country had vastly different views, was the lack of knowledge about precisely what was going on, what the effects were going to be, what the remedies were going to be. If this is similar to that, I think that would be very troubling to say that in such a evolving situation, we are going to decide what the right approaches are. I mean, you said at some point that the Tennessee court, not the Tennessee court, this court is just as qualified as as Tennessee to make the decisions here. And it's not really so much a question of qualifications. It's more questions of constitutional allegation of authority. And, we might think that we can do just as good a job with respect to the evidence here as Tennessee or anybody else. But my understanding is that the Constitution leaves that question to the people's representatives rather than to 9 people, none of whom is a doctor. And particularly and maybe I'm just repeating myself, but you can look, should we follow the United Kingdom position from 3 years ago? Should we follow the United Kingdom's position now? It seems to me that it is something where we are extraordinarily bereft of expertise.
Well,
anyway, just what you think.
Mr. Chief Justice, if I could first respond to the first half of your question about whether or not this is comparable in terms of the underlying science with respect to COVID-19, and I think absolutely it is not. I merely use that example to say that the court has not hesitated to suggest that heightened scrutiny applies in contexts that deal with medicine and science. And then with respect to what is the role of the courts, I continue to think it is to test whether or not a law is properly tailored, and that is what the district court did here. And in fact, the underlying science and the evidence showed that Tennessee's assertion of harm and their prevalence were not supported. The district court made factual findings to that effect, of which Tennessee has not argued were clearly erroneous. And so if what is left here is just bare rationality review, Tennessee is in essence saying, let's not look at the evidence at all, whether this is a law that bans this medical treatment for minors or for adults, that in all other contexts, what Tennessee does is recognize that there are risks and there are benefits. And usually the state regulates by informing patients of the risks and tailoring to minimize them. Here what they've done is impose a blunderbuss ban overriding the very careful judgment of parents who love and care for their children and the doctors who have recommended the treatment.
Thank you. Justice Thomas?
The point I was getting at with respect to remedies is normally in equal protection cases there's a difference between one group and another. In Bourne it would be that the women could buy alcohol, but the male students could not. And what would that be in this case?
So 2 points, Your Honor. I think that what the birth males can do that birth females cannot do is receive medical treatment to live and identify as boys, and what birth females can do that birth males can't do is receive medical treatment to live and identify as girls. That's
okay, let's change. What if, would you make the same argument if we were only talking about puberty blockers?
If it was puberty blockers, I would point to John Doe, who is receiving puberty blockers. The purpose of receiving puberty blockers for John Doe is so that in the future he can undergo a typical male puberty.
No, I'm talking about from an equal protection standpoint, the difference in treatment. Normally in these cases, one group receives something that the other group does not. And I'm trying to discern that in this case.
And so what I would say to Justice Thomas is that a birth sex male can receive puberty blockers to undergo a typical male puberty, and a birth sex female cannot. And if I could slow it down and just explain a little bit how that works. If you're someone who was born male and you are going through puberty too early, you want to be able to have a final adult height that is typical of boys. You may receive puberty blockers so that you can develop as a typical boy. Someone who has a sex of female at birth is also receiving puberty blockers so that they can undergo a puberty like other boys. And so it is the same purpose, and what makes the treatment prohibited for the birth sex female is their sex.
Justice Alito?
Counsel, I don't think you had a chance to finish answering my question whether transgender status is immutable. You cited a bunch of other criteria, but is it immutable?
I think that the record shows that the discordance between a person's birth, sex, and gender identity has a strong biological basis and would satisfy an immutability test. And I also think under this Court's precedence for determining whether something is a suspect or quasi-suspect classification, a distinguishing characteristic is sufficient.
Does the category of does transgender status apply to individuals who are gender fluid?
I think that the distinguishing characteristic is to have a birth sex that does not align with, or a gender that does not align with one's birth sex. So it may include people who have different understandings of their gender identity, but I think it is still the distinguishing characteristic of a birth sex and a gender identity that are incongruent.
Are there individuals who are born male, assigned male at birth, who at one point identify as female, but then later come to identify as male, and likewise for individuals who are assigned female at birth, at some point identify as female, identify as male, but later come to identify as female? Are there not such people?
There are such people. I agree with that, Justice.
So it's not an immutable characteristic, is it?
Well, I think people's understanding of it shifts, but the evidence shows that there is at least a strong underlying basis. And I think the normative reason for that particular consideration is whether or not this is something that someone should or could change, and whether they should have to change it in order to receive constitutional protections. And I think transgender status squarely fits within that.
We have said that having a disability is not a suspect or quasi-suspect classification. So if we were to agree with you on the question of quasi-suspect classification, how could we justify saying, for example, that a person who is schizophrenic does not fall within a category that is not a law that distinguishes on that ground is not a suspect classification? And I'm not suggesting that gender dysphoria is a disease, a mental illness. I'm not suggesting that at all. I'm just saying, how could we justify that different treatment?
I think that
it's immutable in the sense that there isn't any cure for it. There's been severe discrimination against people suffering from schizophrenia. At one point, they were locked up in hellish institutions. They can make a valuable contribution to society. Think of John Nash. How would we distinguish that?
Justice Alito, what I think would be the difference is that in Cleburne, the Court in essence said as to the distinguishing characteristic that this was a large and diffuse group of individuals who have different forms of disabilities, and that group of people had been able to secure some protection through the legislative process. But again, if this Court certainly does not have to reach the question of transgender status as a quasi-suspect classification, SB 1 on its face hinges its prohibition on inconsistency.
Well, I understand that, but would you dispute the proposition that transgender status is a very broad category? Doesn't the American Psychological Society Association say it's an umbrella term?
I don't know exactly what the American Psychological Association says, but I don't dispute that there are people who fall within a transgender identity who may not fit into a binary identity. I still think that the distinguishing characteristic applies to every single transgender person, which is a birth sex that is inconsistent with their gender identity. And of course, here on SB 1, this is the law that I think is easiest to understand and the most straightforward classification on the basis of sex.
So, when asked whether you differed from the SG's position, I assume that if you win in this proceeding, what you're asking for us to reverse is the Sixth Circuit conclusion that rational basis review applied, correct?
That's correct, Your Honor.
Now, you think, as does the other side, that each of you should win on that question, but are you differing from the SG that should be remanded to the court below to apply strict intermediate scrutiny in the first instance?
No, Justice Sotomayor, we're not disagreeing.
Now, with respect to Justice Thomas's question, I'm not sure you answered it. You did in part, and you said the relief you're seeking in the lawsuit, assuming you win on the intermediate standard review, is to permit your plaintiffs to receive the medication other children receive. I don't know if he was suggesting that one of the things we can go up in discrimination or we can go down, which is, but I don't think we've even decided who makes that choice, because the other alternative is to block the usage of all of these drugs for all children, which would present a very different than Arlington Heights, perhaps, question. But the point is that what the relief is still something that has to be determined as well.
Well, so if I could clarify, Justice Sotomayor, I don't think that the relief we're seeking is for our clients to receive the medication. The relief we're seeking is for SB1 to stop being a barrier to their ability to continue to access medical care and make the individualized assessments with their doctors. So it is just simply an injunction of the barrier to the medication that they had been receiving in Tennessee.
Got it. Thank you.
Justice Kagan? Justice Gorsuch? Justice Kavanaugh?
Two basic questions. So whether we apply a rational basis or intermediate scrutiny, either way, you end up looking at the state's justification, and they are articulating a health and safety justification. So it's not simply morals legislation, as they've described it. It's health and safety justification. And it seems that there are risks and benefits both ways here. So it's very hard to weigh those, at least as the briefing has set out the issues. If the treatment's barred, some kids will suffer because they can't access the treatment. If the treatment is allowed, these treatments are allowed, some kids will suffer who get the treatment and later wish they hadn't and want to detransition. At least that's how I see the positions set out in the briefs. And so there are risks both ways in here, allowing the treatment or not allowing the treatment. And how to choose there is a very difficult judgment call, it seems to me. But it's one, it's a difficult judgment call as a matter of policy. And then for us to come in, and this is repeating what I said earlier, but I want your reaction to it, for us to come in and to choose one side of that, knowing that either way, people are going to be harmed. There's no kind of perfect way out, at least as I've read the briefs here, where everyone benefits and no one is harmed, right? The difficulty of the issue is some people are going to be harmed. And then the question becomes, how does the court choose which group? Why isn't that a choice for policymakers as best they can to make that choice in the first instance? So I just throw that out there and take your reactions and anything you want to say on that.
Okay. So if I could just make a few points in reaction.
I had one more point,
okay.
Sorry, to add to that. And I don't think, with respect, that what you and the Solicitor General said, we'll just send it back to the district court and they'll make fact findings. It'll be back here in a year and we're going to have this same discussion as I see it. So just to get you thinking about that too. Go ahead. Have at it.
So a few points, Justice Kavanaugh. And the first is I don't see this as the court choosing what is the appropriate response here. What I see the role of the court is assessing whether the choice that Tennessee made is one that they can justify under heightened scrutiny. And so that question is whether or not by taking this decision away from the adolescents, their parents, and their doctors based on claims of harm, that protects children and protects children from adverse side effects. And what I think the record here shows, and again, this is a preliminary injunction record, what it shows is that broad categorical ban does not advance that interest. That doesn't mean that a more tailored response would not advance that interest, in which you may be able to actually come up with a solution to ensure that you are protecting those who may come to regret this treatment, which are much, much smaller than those who benefit and find it medically necessary, something like West Virginia did. And I think the relevant inquiry here is whether what Tennessee did meets their constitutional burden because they use sex-based classifications to pass this law. And then on two quick other points that With respect to the difference between rational basis and heightened scrutiny, yes, of course it will be weighing the state's asserted interest in both circumstances, but there's a world of difference between rational basis and heightened scrutiny, and we think the Sixth Circuit got it wrong by simply applying rational basis here. And to the question of, well, is remand, a sufficient? Well,
can I just stop you there? If even under rational basis, if there were no benefit to anyone, then it would probably lack a rational basis. So I guess in the end, you still come down to there are risks and benefits both ways. Either way you go here, and I don't know whether rational basis or intermediate scrutiny, however that gets applied, you still have to kind of look, is there a real justification here? I think you look at that either way.
And I think the difference under heightened scrutiny, there's a chance to look at the evidence in a much more substantial way and have the state come forth and show whether they've met their burden. In terms of your question, Justice Kavanaugh, about, well, is it sufficient to just remand it? It will be back up here again. I would say two things in response. I think that there are often examples where there's a threshold question and it goes back down on the application of heightened scrutiny. And I do think an instructive case is Johnson versus California here, in part because it gives us some guidance for what happens on remand in the application of scrutiny. And that, of course, was when the court was considering whether or not to apply strict scrutiny to racial classifications in prison or Turner deference. And when the court reversed and said the wrong standard was applied, strict scrutiny still applies, and sent it back down, it did so with guidance that even under strict scrutiny, the lower courts could take into account the particular context of prison. And I think here, this court could send it back down with instructions to take into account the particular context.
And just one point there. You agree that there's some group of people who receive the treatments who later wish they hadn't and wish to detransition. I know you say it's a smaller group. I understand that. I just want to make sure you agree as a factual matter there is some set of people.
I agree as a factual matter, as there is in all areas of medicine.
And then on the sports question, I want to get your reaction as well, which is it logically and legally possible to apply intermediate scrutiny and say that the Tennessee law and the other laws like it do not satisfy intermediate scrutiny, but laws that limit women's and girls' sports to exclude transgender athletes would be constitutionally permissible? Is that legally and logically possible?
I agree with the Solicitor General that it's legally and logically possible, because in the application of heightened scrutiny, it's wholly different state interests that are being asserted.
Thank you.
Justice Barrett?
Mr. Trangelo, I wanted to give you a chance to see if – I'm not sure if you named all of the laws when we were talking about de jure discrimination before. You mentioned bans on cross-dressing and bans on military service. And I had thought of the military service, but I didn't know about the statutes prohibiting cross-dressing. Could you think of others? Are there?
I mean, I would say that there are other examples that exist in which sometimes homosexuality and transgender status are sort of lumped together in discriminatory frameworks as language has changed. But I think the most salient to me would be the cross-dressing bans and the explicit bans on military service for transgender individuals.
Okay, and thinking about when we identify suspect classes, the factors that we've considered, one of the ones that the Sixth Circuit addressed was political power. Do you have a reaction to the Sixth Circuit's discussion of that?
I would just say, Justice Barrett, that I think looking out at the country at the moment, that there is a significant challenge for transgender people to protect themselves in the political process, where you do have laws excluding transgender people from places where they need to go in all aspects of life, and there is a difficulty in that type of majoritarian protection. I think that's precisely what the political powerlessness prong of the test accounts for.
Thank you.
Justice Jackson?
So I guess I'm suddenly quite worried about the role of the court questions and the constitutional allocation of authority concerns, because I understood that it was bedrock in the equal protection framework that there was a constitutional issue in any situation in which the legislature is drawing lines on the basis of a suspect classification, that it's a constitutional question that is being raised when that is happening as a threshold matter. And then you may get into why is it happening, what is the justification, and then you've said here at the podium today that the different levels of scrutiny account for how strong the government's evidence has to be for doing that. And the court really holds them to it in a heightened scrutiny scenario. But the kind of initial issue is that a law is drawing lines on the basis of some suspect classification. Does that accord with your understanding of what we normally do? And that's a question for the court, because it's a constitutional question. Is the statute doing this, right?
Yes, I completely agree with that, Justice Jackson. That's precisely why we think heightened scrutiny applies here, because this is a statute that on its face draws.
All right, and to answer the question, is this statute doing this, I understood that we had a sort of two-step framework for looking at it, that we don't just kind of launch into an assessment of the evidence or why the state is saying that they're doing this, or the scientific basis for it, that we're looking at something else when we're trying to determine is a classification being made, right?
Yes.
And I guess my real concern, and maybe I'll just ask you to react to my Loving parallel because I'm getting kind of nervous, is that in Loving, those same kinds of scientific arguments were made. So I'm reading here where the court says the argument is that if the Equal Protection Clause does not outlaw miscegenation statutes because of their reliance on racial classifications, the question of constitutionality would thus become whether there was any rational basis for a state to treat interracial marriages differently from other marriages. On this question, the state argues the scientific evidence is substantially in doubt, and consequently the court should defer to the wisdom of the state legislature in adopting its policy of discouraging interracial marriages. And so for me, this kind of idea that the way we look at it is not first, are you drawing these classifications, and then state, give us your evidence so we can make sure that there's a proper fit. If instead we're just sort of doing what the state is encouraging here in Loving, where you just sort of say, well, there are lots of good reasons for this policy, and who are we as the court to say otherwise, I'm worried that we're undermining the foundations of some of our bedrock equal protection cases.
I share your concerns, Justice Jackson. I think one of the things that's happening in this case is we're seeing a lot of concerns that come in at step 2 of the analysis being imported into that threshold question of whether a classification has been drawn in the first instance. Concerns about real differences between males and females. That is exactly what heightened scrutiny is intended to test in the application of heightened scrutiny. If Tennessee can have an end run around heightened scrutiny by asserting at the outset that biology justifies the sex-based differential in the law, that would undermine decades of this court's precedent.
Thank you.
Thank you, counsel. Mr. Rice?
Mr. Chief Justice, and may it please the court. Tennessee lawmakers enacted SB 1 to protect minors from risky, unproven medical interventions. The law imposes an across-the-board rule that allows the use of drugs and surgeries for some medical purposes, but not for others. Its application turns entirely on medical purpose, not a patient's sex. That is not sex discrimination. The challengers try to make the law seem sex-based this morning by using terms like masculinizing and feminizing, but their arguments conflate fundamentally different treatments. Just as using morphine to manage pain differs from using it to assist suicide, using hormones and puberty blockers to address a physical condition is far different from using it to address psychological distress associated with one's body. The Equal Protection Clause does not require the states to blind themselves to medical reality or to treat unlike things the same. And it does not constitutionalize one side's view of a disputed medical question. Half of the states, Sweden, Finland, and the UK, all now restrict the use of these interventions in minors and recognize the uncertainty surrounding their use. These interventions carry often irreversible and life-altering consequences, and the systematic reviews conducted by European health authorities have found no established benefits. Politically accountable lawmakers, not judges, are in the best position to assess this evolving medical issue. The Sixth Circuit should be affirmed. I welcome the Court's questions.
Both the SG and petitioner have suggested that a better approach would be the approach of West Virginia. What's your reaction to that?
Your Honor, my friend's arguments with respect to the alternative approaches is pure policymaking. As Justice Kavanaugh recognized throughout his questioning, they cannot stand up here and say that if these alternatives were imposed, that there would be no detransitioners. So they cannot eliminate the risk of detransitioners. So it becomes a pure exercise of weighing benefits versus risk. And the question of how many minors have to have their bodies irreparably harmed for unproven benefits is one that is best left.
I'm sorry, Counselor. Every medical treatment has a risk, even taking aspirin. There is always going to be a percentage of the population under any medical treatment that's going to suffer a harm. So the question in my mind is not, do policymakers decide whether one person's life is more valuable than the millions of others who get relief from this treatment? The question is, can you stop one sex from the other, one person of one sex from another sex, from receiving that benefit? So if the medical condition is unwanted hair by a 9-year-old boy who can receive estrogen for that, because at 9 years old, if he has hair, he gets laughed at and picked on, and his puberty is coming in too early. But a girl who has unwanted hair says, or has unwanted breasts, or a boy at that age can get that drug, but the other can't. That's the sex-based difference. It's not the medical condition is the same.
We don't
but
agree.
You're saying one sex is getting it and the other's not.
We do not agree that the medical condition is the same. We do not think that giving puberty blockers to a 6-year-old that has started precocious puberty is the same medical treatment as giving it to a minor who wants to transition. Those are not the same medical treatment. And once
what
you
you're
recognize,
saying is you're still depending on sex to identify who can get it and who can't.
I don't think so, Your Honor. If a minor comes up to a boy, goes to the doctor and says, I want puberty blockers to transition, the answer will be no. If a girl goes up to the doctor and says, I want...
If a sex-neutral looking child walks into a doctor and says, I don't want to grow breasts, doesn't the doctor have to know whether it's a girl or a boy before they prescribe the drug?
I don't think so, Your Honor.
I've got to tell you, I've made that mistake on children often. Look at one of them and think it's a boy, and I'm corrected, and it's a girl, and vice versa. I hope that you're not going to tell me you haven't made that mistake.
Well, I may have made that mistake, Your Honor, but I don't think that that is an example of where a sex-based line is being drawn.
Why not?
Because...
Yeah, please.
Because all that matters is the medical purpose for which the drug is used. So if the minor comes up, if you have a biological...
No, it's the same medical purpose. Her hypothetical is, I don't want to grow breasts. Same medical purpose. I'm trying to stop the development of breasts.
Well, Your Honor, I think that likely would not be allowed under SB 1 for a girl.
For a woman who is, for a girl, but
yeah, and it would also not be allowed under Tennessee law with respect to a biological boy.
Really?
Tennessee law doesn't just allow doctors to prescribe drugs without a medical purpose. They can't.
No. But the way I understood the law to work is it has to be inconsistent with your sex in order for it to be blocked. So I don't understand why a boy. I don't understand why it would work in the way that you're saying. Why wouldn't it be differentiating on the basis of gender? A girl who doesn't want to grow breasts for whatever reason could or could not get it.
Does not want to grow breasts
yes.
without a medical reason could not get it.
And a boy who doesn't want to grow breasts could or could not get it.
Could not get it if there was no medical purpose. There has to be a medical purpose for these drugs. All my friend's arguments rest on conflating different medical purposes.
But they couldn't get it not under this law, right? Because this law is operating around the inconsistency. So if they couldn't get it, it would be for some other reason, right?
But we have other laws in Tennessee law that prevent malpractice and that prevent the use of drugs for a non-medical purpose.
I understand, but this law is the one that is being challenged today, and we're trying to decide whether or not it's operating on a sex-based basis. And
well, I don't think
so what about my lower voice hypothetical?
Yeah.
All right. So a biological boy comes in and asks for a hormone treatment to deepen his voice in order to affirm his masculinity because it hasn't come and he'd like to deepen his voice. Can he get it?
If there's no medical purpose, no.
No, that's the medical purpose. I don't understand what you mean. The purpose is to bring on a deepening of their voice.
Let me try to rephrase.
Yes.
If there's no medical condition, the answer is no. You cannot use testosterone for purely cosmetic reasons. It's a Schedule III drug.
In this statute or in another statute?
In another statute.
Okay, so setting aside that other statute, we're looking at this one and how it operates. This statute says something about inconsistency with your biological sex, and that's what I'm trying to test. The boy comes in, he asks for a hormone treatment to deepen his voice, to affirm his masculinity. Can he get the treatment? Under this statute?
Under this statute, no, but under Tennessee Code annotated 63.
The boy could not, under this statute, to get a medication that would deepen his voice?
If there was no medical condition, no.
That's the other statute. Under this statute, with respect to consistency, he could.
Under this statute, he could.
Okay.
Under 63-6-21412, he could not.
I understand. Setting aside that other statute, under this statute, he could. Now, looking at this statute, a girl comes in biologically and asks for a hormone to deepen her voice in order to affirm the identity that she chooses, which is masculinity. I'm asking you, would under this statute she be precluded from getting that treatment?
She wants to, I'm sorry, one more time, Your Honor.
She wants to get the medication in order to deepen her voice and affirm her masculinity.
Your Honor, I think if it's for the purpose of identifying inconsistent with their sex, she would be barred from doing that under the statute.
But isn't that the point, Mr. Rice, that if it's for the purpose of identifying with their sex, I mean, the prohibited purpose here is treating gender dysphoria, which is to say that the prohibited purpose is something about whether or not one is identifying with one's own sex or another sex. The whole thing is imbued with sex. I mean, it's based on sex. You might have reasons for thinking that it's an appropriate regulation, and those reasons should be tested and respect given to them. But it's a dodge to say that this is not based on sex, it's based on medical purpose, when the medical purpose is utterly and entirely about sex.
Justice Kagan, we think that is a slightly we think that's a request for a substantive right to engage in nonconforming behavior. We don't think it's actually drawing a line based on sex. And again, the only way that my friends can point to a sex-based line is to conflate the use of puberty blockers to address precocious puberty with the use of puberty blockers to transition. And those are fundamentally different treatments. They have different effects on the body. They're used for different purposes. I actually think my friend's response to Justice Alito's hypothetical regarding puberty blockers is devastating, because that law draws no different lines than the law that's drawn in SB 1. It just doesn't use the words inconsistent with sex. So we use the words inconsistent with sex to describe a single prohibited medical purpose. We do not use it to draw lines between males and females.
Counsel, I want to be clear about this. I assume you agree with me that no matter how difficult the science may be, and no matter how evolving it may be, at the end of the day, legislation on this subject is subject to judicial review.
Yes,
is that
sure.
correct? And I also want to be clear that the issue about the difficulty of regulating the science and attempting to figure out where to sort of stop and place the scale in the evolution is a matter that goes to the level of judicial review. Is that right? The level of the scrutiny that's applied?
Yes, Your Honor.
Okay, thank you.
Counselor, given your argument, you're saying your state can block gender treatment for adults, too.
Your Honor, we think that if we're assuming a similarly worded statute, that there still would not be a sex or a transgender-based classification.
So you're licensing states to deprive grown adults of the choice of which sex to adopt.
Your Honor, I don't think that's a fair characterization.
That's what you're telling me, because you're saying to me rational basis would be the review for that kind of law for adults as well.
And this Court has not hesitated to hold laws unconstitutional under rational basis review when they are rooted in unsubstantiated fears and prejudices. That's exactly what this Court did in Cleburne. And
That's
to the extent,
quite an interesting way to protect the population.
And to the extent, Your Honor,
I thought that that's why we had intermediate scrutiny when there are differences based on sex, to ensure that states were not acting on the basis of prejudice.
Well, Your Honor, of course, our position is that there is no sex-based classification. But to finish the answer, that to the extent that a law dealing with adults would pass rational basis review, that just means it's left to the democratic process, and that democracy is the best check on potentially misguided laws.
So
when you're 1% of the population, when you're 1% of the population or less, very hard to see how the democratic process is going to protect you.
Well, Your Honor,
you blacks were a much larger part of the population, and it didn't protect them. It didn't protect women for whole centuries.
Mr. Rice, I have one factual question and then one legal question. The factual question is, the Sixth Circuit mentioned that this is an off-label use, that the FDA has not authorized. Is that still true, and is that just for children, or is it for adults too?
It's still true. I think with respect to both children and adults. I know with respect to children, I'm not certain with respect to adults. But we do think that that's relevant in the sense that the FDA, when it approves drugs, it does so based off of the purpose for which the drugs are being used. And we think that we are drawing the same type of distinction in our law between using one drug for different purposes.
Okay, my legal question is, I wondered if you had a response. I was asking your friends on the other side about de jure discrimination and what we should take account of if we're thinking about whether transgender people should be a suspect class for purposes of the 14th Amendment. Do you have a response to that, what we should be thinking about, or do you know the history of de jure discrimination?
I do not know the history of de jure discrimination. I mean, our frontline position is that the Court has gotten out of the business of creating new quasi-suspect classes precisely because it's a very unprincipled test when it comes to creating these classes. And in some of the cases, political powerlessness means that you need protection from the majoritarian process. In other cases, it means can you gain the attention of lawmakers in the most recent Cleburne test. So the Court has not applied any form of principled analysis when it comes to creating these tests. It's been an exercise of judicial power. And the intermediate scrutiny analysis that accompanies the quasi-suspect classification is no more principled, and the Court has often struggled to apply that as well. So we don't think the Court should even open the door for further judicial creation of new quasi-suspect classes.
Okay, and last legal question. I was just going to ask you one. I have a second one. Could you address Justice Kavanaugh's questions about what the implications of this case would be for the athletic context or the bathrooms context?
I would love to, Your Honor. So we think this is we differ with our friends on the other side with respect to their argument is that, well, there's a sex-based classification in sex-separated sports, so necessarily that means that there's a sex classification, intermediate scrutiny applies. We are not actually seeing challenges to the sex classification. when these challenges are being brought, they're not arguing that we don't want there to be boys and girls sports. They're arguing we want there to be boys and girls sports. We just want to be classified based off of our gender identity. And so we think that is fundamentally a transgender-based challenge and not a sex-based challenge if you are not actually challenging the sex classification that is at issue.
Can I ask you, so in my sort of loving parallel, Virginia, in your view, would not have been making a racial classification if they had just reworded their statute to say no person can get a license to marry for the purpose of uniting with another person whose race is inconsistent with their own. I took you to say that the use of the term inconsistent with their sex was drawing a line to prohibit one use of the medication. So why couldn't these statutes have been interpreted as drawing a line to prohibit one use of a marriage license?
Your Honor, we think that in a case like Loving, when you look at the individual level, which we agree with our friends on the other side, that the protection of the Equal Protection Clause operates at the individual level, that if there is a line that is being drawn based off of race, like in Loving, where you had a white male who could not marry an African-American female under that law, that is a race-based line. You are creating multiple groups of permissible and impermissible behavior based off of race. Where we differ from our friends on the other side is we just don't think that there is any sex-based line in this.
But I don't understand why not. I mean, the law here operates in the same way. The question of can you marry this other person depended upon what your race was. You could marry the other person if it was the same, consistent with your race. You couldn't if you couldn't. I take your law to be doing basically the same thing. You can get these blockers if doing so is consistent with your sex, but not if it's inconsistent. So how are they different?
We think it's different because we think in their use of inconsistent with sex and all of these examples that they have in the briefing, those actually do create separate categories of conduct that is permissible either based on sex or based on race. But in this case, the only way that they can point to a sex-based line is to equate fundamentally different medical treatments. Giving testosterone to a boy with a deficiency is not the same treatment as giving it to a girl who has psychological distress associated with her body. This is not only
what's your basis for saying that? I'm sorry. Is it just because of why they're asking for it, or is there some kind of medical? I took the SG to be saying that it operates on the body in the same way. So what's your basis for saying they're not the same?
I don't think it operates on the body in the same way. Take testosterone. If you give a boy with a deficiency testosterone because he has constitutional delayed puberty, that allows him to go through and develop the reproductive organs associated with being a male. If you give it to a girl, it renders the girl infertile. So we have 8 to 12-year-olds being
I'm sorry.
asked.
I thought your reasons for them being different was that you said they were for different purposes. I'd heard you say at the beginning the reason those two are different is because one wants them to transition and the other wants them for some medical purpose.
Well, to go back to my example in the introduction, I don't think anyone would say using morphine to assist suicide is the same treatment as using morphine to manage pain. It's the same drug, just like it's the same drug here, but they're being used for fundamentally different purposes. They have different effects on the body. And once you take out and you recognize medical reality, then there is no argument that our law differentiates between treatments for males and females.
Can I ask you about one of the purposes of this law? And I note that your brief does not talk a lot about this, but one of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization of our law.
Encourage minors to appreciate their sex and ban treatments that might encourage minors to become disdainful of their sex. Sounds to me like we want boys to be boys and we want girls to be girls. And that's an important purpose behind the law. And I understand that sentiment, but it's a fundamentally different sentiment and it's a fundamentally different understanding of what produced this law than the one that you're talking about now.
Your Honor, if I could make a few points. First of all, it sounds like the question is rooted in a potential improper purpose-based argument under our Arlington Heights argument, which, as Chief Judge Sutton pointed out below, that argument was never raised until it got to this court.
Well, I'm less interested in sort of like the legal box to put this in, and more interested in, you're spending a lot of time talking about what exactly the classification is here, and I think we've talked a good deal about that. But what produced this classification might be relevant to understanding what the classification is about.
Absolutely, and I would love to address.
And what seems to have produced this classification is that we want to ban children treatments that might encourage minors to become disdainful of their sex. So we think that there's something fundamentally wrong, fundamentally bad about youth who are trying to transition. And that's the way this purpose seems to me.
If I could try to unpack both of those, Your Honor, because I think both of those read in context do not support the narrative that Tennessee wants boys to live as boys and girls to live as girls. So the appreciate their sex reference detailed in legislative findings, that is simply the recognition that given the high desistance rate among minors and given the tragic regret of detransitioners, that there is an interest in making sure that minors have enough time to appreciate their sex before undergoing life-altering changes. So I think that has to be viewed in the context of the legislative findings, which both emphasized the detransitioners and the high rate of desistance. With respect to become disdainful of their sex, the challengers have never explained why it would be problematic to prevent interventions that could affirmatively cause minors to become disdainful of their sex and thus at issue for psychiatric conditions. And in fact, there are multiple studies, I would point to this court, JA 400, where minors actually, their mental health and suicidality got worse after taking these interventions. Now, my friends on the other side may disagree with that research and that assessment of whether the findings of that study, but the legislature specifically noted those studies, so I think that statement was rooted in the notion that actually this is causing affirmative harm to minors who are undergoing the interventions. And that's why they were saying we don't want these interventions that will cause minors to become disdainful of their sex.
Go ahead.
You go.
No, go ahead. No, go ahead. I'll be back.
Justice Kavanaugh.
At a big picture level, I think the argument on the other side, putting aside some of the details, is why not trust parents rather than the state, particularly in a situation, as General Prelogger said, where there's not the kind of direct harm to third parties that you might see in other contexts like sports.
Yes, Your Honor. So, as my friends recognize, the parental rights question is not before this court.
She explained how it informs. So just take the question as best you can.
Yeah, I think our position is that there are certain times in medicine, history has shown, where the states in their traditional role as regulators have had to intervene. And that's not because, of course, the parents are trying to do the best they can and get the best treatment for their kids. But we've had multiple instances in somewhat recent history where we have stuff like lobotomy, eugenics, that had widespread acceptance among the medical community, and the state had to intervene as a regulator to protect the children.
Mr. Rice, just to let you kind of finish what you started to say to Justice Kavanaugh, you agree that the parental rights question is not before the court, so it would be open to parents to continue to press that point in other cases.
We agree, and we think Chief Judge Sutton got it right, but we agree.
Can I just ask you about, I don't understand at all the similarly situated argument that you make, and I hope that you can help me, because I don't know how you can say both that girls and boys are not similarly situated at step one when this law is being evaluated and it's not making a sex-based classification. It seems to me that recognizing their lack of similarity, as you do in making the argument, is making a sex-based classification. So, Your Honor,
I think our position is that if you're in the point where we're treating giving testosterone to a boy with a biological deficiency as the same thing as giving testosterone to a healthy biological girl who wants to transition, then there has to be some threshold inquiry that recognizes the biological differences between those two.
Right, but when you're doing that, you're making a sex-based classification. I mean, the very argument carries with it the characterization that we're trying to identify here. You start by saying it's different to treat a boy who's using this medication for a particular reason from a girl who's okay, so that's a sex-based classification. Haven't we dealt with step one now? We should be going on to step two. No. Intermediate scrutiny applies by the terms of what you're arguing.
I don't think that we agree that we've checked the box at step one, because there is no medical treatment that boys can receive that girls cannot. So we disagree with the notion.
Didn't we already dispose of that kind of reasoning with our equal protection cases that looked at things like interracial marriage, where we said even though it applies to both, it's still making a racial classification? Even though whites can't marry non-whites and non-whites can't marry whites in the statute, right? So both are equally disadvantaged. We said that's not an argument for why you shouldn't have a heightened scrutiny or why the statute is not making a race-based classification.
And that's not the argument that we're making,
okay,
Your Honor.
So what is
we
your
are not
argument?
arguing that you can discriminate and draw lines so long as you do so both against boys and against girls. We're arguing there is no sex-based line. If you're a boy and you go in to get puberty blockers, you can get the puberty blockers if you're going to use them for precocious puberty. You cannot get the puberty blockers if you're going to use them to transition. That is not a sex-based line. That is a purpose-based line. So our fundamental point here is not that you can discriminate against both sexes in equal degree. Our fundamental point is there is no sex-based line here, and the only way they get to a sex-based line is by equating fundamentally different treatments that defy medical reality and defy how the statute itself sets out what is a treatment.
And the treatments are different because of the biological sex of the person, right? I mean, that's what you said. The purposes are different because of the biological sex and why you're going in to get them.
Not at all. I mean, with puberty blockers, the purpose, nothing turns on sex. Take puberty blockers. There's nothing that turns on sex as to whether there's a sex-based classification there. Everything depends on what is the reason that you are using those puberty blockers for. I'm happy to take more questions if the court has them.
Justice Thomas?
A number of times you've mentioned off-label uses of these hormones. What are some of the other off-label uses that are not legal in Tennessee?
So, for example, Your Honor, testosterone, we have a separate law that prohibits the use of testosterone for hormonal manipulation intended to increase muscle mass, strength, or weight without medical necessity. We have, like every state, we regulate medicine and we regulate the use of drugs. You cannot use drugs in the state of Tennessee if it's not for a legitimate, viable medical purpose. Here, through this law, all that we have done is make clear that these treatments, which are irreversible often, have significant effects on minors and often leave them with bodies that are infertile and permanently damaged, that you have to wait until you turn 18 to receive those type of treatments.
A number of times you've tried to say that what the classification that the state of Tennessee has advanced in this legislation. Would you spend a few minutes on that?
Yes, Your Honor. So, again, we think that our law fundamentally draws a distinction based on medical purpose. I'll go back to puberty blockers. If a boy wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. If a girl wants puberty blockers, the answer is yes if you have precocious puberty, no if you're doing this to transition. That is fundamentally a different treatment, and what is dictating under this law is the use for which you are putting the drug. And just to kind of build out on the notion that these are not the same treatments, we talked about earlier testosterone. If you give it to a biological boy, it allows the boy to develop a normal body and healthy body, whereas providing it to a girl causes a physical condition, hyperandrogenism, and that results in clitoromegaly, atrophy of the lining of the uterus, blood cell disorders, increased risk of heart attack. So the notion that the risks are the same when you give testosterone to a boy as when you give it to a girl are simply not borne out by medical reality.
Justice Alito? Justice Sotomayor? Justice Kagan? No? Justice Kavanaugh?
Just one clarification. It's an obvious point, but I want to make sure you agree with it, which is you're not arguing that the Constitution takes sides on this question. You, as I understand it, you are arguing that each state can make its own choice on this question. And so from your perspective, as I understand it, it's perfectly fine for a state to make a different choice, as many states have, than Tennessee did, and to allow these treatments, correct?
Yes, Your Honor, that's correct. And we think that's because of what Your Honor has pointed out, that no matter how you draw these lines, there are risk and potential benefits and harms to people on both sides. And the question of how to balance those harms is not a question for the judiciary, it's a question for the legislature.
Thank you.
Can states make a different choice if doing so means that a state's law operates to treat its citizens differently on the basis of name the suspect classification? I thought that was the work of the Constitution and the Equal Protection Clause.
Your Honor, we don't think that it draws any lines based off any.
No, I understand. I'm not talking about this law. I'm going back to Justice Kavanaugh's suggestion that the Constitution doesn't play a role if the state is making a policy choice regarding issues such as these. And I guess I'm still seeing a role for the Constitution in circumstances in which the claim that is being made is that the state's choices are implicating the equal protection rights of its citizens.
Your Honor, I think the point, I don't want to misstate the point, but I think the point is that the Constitution is neutral in the sense that it does not provide heightened protection based on any suspect classification, and thus rational basis review applies in the presumption of legislative validity and the presumption that these types of policy choices are best left to the democratic process. I think that is exactly what the correct way to think about this case.
Thank you.
Thank you, counsel. Rebuttal, General Prelogar.
Thank you, Mr. Chief Justice. Two quick clarifying points. I want to make clear that Tennessee here is not regulating based on off-label use. Off-label use is extremely common in pediatrics, and we've pointed to a number of uses of these medications on page 40 of our brief, the very same medications that likewise are off-label use. If there are problems with safety and effectiveness, then that would not become the standard of care, and there are self-regulatory measures to address that issue. Justice Kavanaugh, you said this might be a space where each state can make its own choice, but I think it's important to recognize that my friend's arguments would equally apply to a nationwide ban if this were enacted by Congress, and so I think that the court should keep that in mind when thinking about the level of scrutiny here. There were a lot of questions about how to take account of disputed medical evidence when there might be some uncertainty, and I want to make a few points. As my friend acknowledged, that doesn't go to the level of scrutiny, so that doesn't mean that you should ignore a sex classification when one exists in the statute. But at the point of applying heightened scrutiny, the court can take context into account, and we're not asking courts to step in here and say we want to figure out as a matter of policy exactly what the right approach is, but you can ask the familiar judicial questions like, does the state actually have any evidence to support its claims that there's a harm to adolescent health? And is this law severely over and under inclusive? And if the court conducts the analysis here in the first instance, this law doesn't look anything like a typical medical regulation to protect adolescent health. That would look like the West Virginia law, where you're tailoring it, but still leaving some possibility for care when it can have enormous benefits. And the reason it doesn't look like a typical medical regulation is because the legislature was doing something different in trying to get minors to appreciate their sex and not become disdainful. That's not a medical-based justification, but I think it shows exactly why the state drew the lines where it did. Finally, I think the court should think about the real-world consequences of laws like SB 1. Consider its effects on Ryan Rowe. As Justice Sotomayor noted, Ryan's gender dysphoria was so severe that he was throwing up before school every day. He thought about going mute because his voice caused him so much distress. And Ryan has told the courts that getting these medications after a careful consultation process with his doctors and his parents has saved his life. His parents say he's now thriving, but Tennessee has come in and categorically cut off access to Ryan's care, and they say this is about protecting adolescent health. But this law harms Ryan's health and the health of all other transgender adolescents for whom these medications are a necessity. And the state says it doesn't even want the courts to take a look at whether this protects adolescent health. But the reason Ryan can't have these medications is because of his birth sex, and a sex-based line like that can't stand on rational basis review. Thank you.
Thank you, counsel. The case is submitted. We will hear argument first this morning in Case 2438, Little versus Hecox. Mr. Hurst.
Thank you, Mr. Chief Justice, and may it please the Court. Idaho's law classifies on the basis of sex because sex is what matters in sports. It correlates strongly with countless athletic advantages like size, muscle mass, bone mass, and heart and lung capacity. Tragically, but not surprisingly, male athletes have even injured female athletes in many sports. If women don't have their own competitions, they won't be able to compete. Gender identity does not matter in sports, and that's why Idaho's law does not classify on the basis of gender identity. It treats all males equally and all females equally, regardless of identity, and its purpose is exactly what the legislature said: preserving women's equal opportunity. In fact, it's our friends on the other side who want to classify based on gender identity. They're seeking special treatment for males who allegedly lack an unfair advantage, but only if those males also identify as transgender. Denying special treatment isn't classifying on the basis of transgender status. It's consciously choosing not to. Idaho's sex-based classification would get intermediate scrutiny if Hecox challenged it, but Hecox's requested relief presupposes separate women's sports. All Hecox challenges is the law's application to a tiny subset of males who identify as transgender and suppress their testosterone. But that's not how intermediate scrutiny works. Idaho's law is a substantial fit for 99% of males, and a perfect fit is not required. If it were, that would be the end of all sex-based classifications. Finally, a word about mootness. When trying to avoid mootness below, Hecox told the Court, "I intend to play women's club soccer this semester, next semester, and through the remainder of my time at BSU." A contradictory post-cert affidavit does not make it absolutely clear this controversy is over, so Hecox's formidable burden isn't met, and this case isn't moot. I welcome the Court's questions.
There'll probably be some questions about mootness, but I'd like you to, in focusing on the equal protection analysis, the sex classifications in sports is not being challenged.
That's correct.
How does that work in this case when we're talking about one individual being accepted from a particular or included in a particular category?
There's no basis for heightened scrutiny, intermediate scrutiny in that situation, Your Honor. If the sex-based line passes intermediate scrutiny, which no one disputes that it does, then the edge cases, the potential exceptions, that's all rational basis review.
That makes no sense to me. All right? And I don't know how you can say sex classification is not being challenged. There's no question here that a male who identifies as a female, but it's a male, is being excluded from a female sport, correct?
That's correct.
All right? By its nature, that's a sex classification. And all sex classifications, we have said repeatedly in our case law, require intermediate scrutiny. Now, what you're saying is, well, she's not challenging a male's generally not playing. She just doesn't want to be the one male excluded. So it's a subclass of people that she's challenging, correct?
Yes, I think that is correct.
All right. So how do you square our various case law, Caban, Lear, Claiborne, VMI in particular, all of whom involved a subclass of people who challenged on equal protection grounds their exclusion from a definition?
I'm happy to take those cases in order, Your Honor, starting with Caban. There was no notion of as-applied anything in Caban. In Caban, it was a facial challenge to the statute, and individual circumstances were used as examples to prove that the statute was overbroad and lacked a substantial fit.
That's the point. That's what she's saying here, that the state interest here is the safety of women, correct? And promoting competition. That's the state interest. And in Caban, the state interest was in ensuring that only children with active parents, let's say, were given a state benefit, correct?
Yes, and Caban was struck down facially. The statute was considered unjustified.
How about Lear?
In Lear, we had the same.
That's the opposite. That's the subclass, the people who were excluded.
In Lear, the court said the law would be justified with respect to you, plaintiff, and because the law would be justified with respect to you, you are not able to challenge the law elsewhere.
All right.
So the
How
court
about
says,
BMI? That distinction doesn't make any sense to me. It's still an exception. It's a subclass of people who are covered by the law and others are not. That's what we said.
The VMI case is the flip side of Idaho's law. The VMI case, equal opportunity required letting women in to previously single-sex spaces. In this case, equal opportunity for women requires giving women separate spaces. And VMI said that was okay. VMI said separate housing.
That's begging the very question at issue here. You can have a sex classification based on sex. You just have to have a reason for it and one that matches your exclusion. What you're trying to say is we don't even look at the reason to see if it has a scientific basis.
The reason we don't look at the reason in this case to see whether there's a scientific basis is because no one disputes that there is a scientific basis for separate sports.
Oh, but there is a dispute of that.
I'm sorry. Are you then saying, Mr. Hurst, that there really is no such thing as an as-applied equal protection challenge?
No, Your Honor, but what I am saying is that equal protection, the question is whether the classification is valid and not whether it makes sense in individual situations.
But that sounds to me as though, and, I think our precedent is actually very sparse in this area, sort of surprisingly sparse. But it sounds to me as what you're saying is as long as the classification is facially valid, a person does not get to come in and say that with respect to some subclass, a small subclass in this case, a person doesn't get to say with respect to some subclass there's a mismatch, that the justification has run out, that the justification doesn't apply. You're saying that that really is just not an available argument.
I agree that is not an available argument, and I think this court has taken that approach, our approach, in cases from Conn v. Shevin all the way to Wynn, and Wynn is the best example because there the petitioner had been raised in the United States by the U.S. citizen father, and the court said Congress's interest in making sure there's a connection with the United States is enough to justify the classification. Well, this petitioner obviously had the connection with the United States. There was no basis to apply these justifications to that petitioner. Didn't matter.
I mean, one thing that this case could be about is, and in this case I mean generally, this litigation, is whether the plaintiffs are right here that there is a mismatch, right? And some of your briefing addresses that question. Right, you can take all the hormones in the world, you can take all the puberty blockers in the world, you say, and there still will be a competitive advantage. That's one thing that this litigation could be about and one way to resolve this litigation. Another thing that this litigation could be about is this deeper and, as I say, surprisingly unanswered in my mind, equal protection question about what an as-applied equal protection challenge is and whether they exist. And I guess, you're suggesting that we should, well, I don't really know what you're suggesting, because here you're saying, look, just do it that way. They could be right on the science, and we would still win. A lot of your briefing really contests their view of the science. So which way should we think about this case?
We think that equal protection jurisprudence is about the validity of classifications. It takes a classification to trigger the doctrines to begin with, and then you ask, is the classification justified under intermediate scrutiny? And so that we think that's the right approach. Is the classification justified? Not is it justified in each individual instance, because as Wynn said, this court has never held, Wynn said, that a law has to be capable of achieving its ultimate objective in every instance. And as soon as that possibility of forcing the legislature to justify the law with respect to individual plaintiffs is on the table, intermediate scrutiny is over. That is strict scrutiny. Can
I question the premise that you are putting forward? even if I agree with you that equal protection is about, is this classification justified? I think that begs the question, what is the classification? And so to the extent that you have an individual who says what is happening in this law is that it is treating someone who is transgender but who does not have, because of the medical interventions and the things that have been done, who does not have the same threat to physical competition and safety and all of the reasons that the state puts forward, that's actually a different class, says this individual. So you're not treating the class the same, and you're not, how do you respond to that? In other words, the as-applied challenge essentially redefines the class, or one could think of it as that. And so what's wrong with that, number one, and how do you square that with our holdings in Caban, which Lair later described in this way? In other words, Lair suggested that Caban was establishing that as-applied challenges of this nature do exist.
Certainly, take the second question first.
Yes.
Caban says nothing about as applied. I know that Lair says later this was an as applied case, but simply reading Caban, it does not say that. It simply applies intermediate.
No, I understand, but those two cases were in juxtaposition with one another,
yes.
And Lair comes out the way it does, distinguishing Caban on the basis that it's an as-applied challenge, and we in Lair have a facial challenge, and it's basically the same facts. So if you're right, those two cases can't come out the way they do.
I don't think so, Your Honor. Again, Lair was actually briefed as a standing argument of maybe you might be able to argue that this law is overbroad, but you individually are not in the overbroad part, and therefore you don't get to challenge it. The court didn't use standing language, like express standing language in the opinion, but that is the logic of the opinion.
Mr. Hurst?
Yes.
There's another way to think about the case your friends on the other side posit, and that is that transgender status should be conceived of as a discrete and insular class subject to scrutiny, heightened scrutiny in and of itself, given the history of de jure discrimination against transgender individuals in this country over history, in immigration and family law, cross-dressing statutes. They give a long laundry list, and I'd like you to respond to that.
Certainly. On the de jure discrimination point specifically, there has been some discrimination against transgender people, significant discrimination against transgender people in the history of this country. The same can be said of many groups. The same could have been said of the mentally disabled in Cleburne, et cetera, et cetera. I think Justice Alito's concurrence in Scrimeti is helpful with this in saying this quasi-suspect class or suspect class process, what we're really looking for is classes that look like race or like sex. And if you compare the discrimination in this case, where not one of the laws they cite actually classifies expressly on the basis of transgender status, if we look at that history and we compare it to the history of African Americans and women who were not able to vote, who were not able to own property, who had express classifications based on their status written into the law for most of this country's history, these things don't compare. They're just not alike.
I'm sorry.
No, please.
No, go ahead.
Okay. There are two things in that answer that are kind of at odds with one another. You start by saying you don't question that there's a history of discrimination, I assume de jure, in this country. Mm-hmm. And then you say, well, but they don't classify on that basis. How should we think about that?
I think that the famous footnote 4 helps, right? This has been a discrete and insular minority. Has it been a group of people that were recognized as a group where laws were passed on the basis of their membership in that group, demonstrating that they lacked the political power to protect themselves in the political process? This is from Justice Barrett's concurrence, of course. We just don't have any of that here. All they can point to is conduct. It says, no cross-dressing, no drag performances in bars, these kinds of things. As I think our friends on the other side would admit, people cross-dress who aren't transgender. This is not a classification on that basis.
What do you do with the legislative history in this case, where the people who introduced the bill called it a transgender bar? So you in answering Justice Gorsuch, you said there's no evidence of that, but there's certainly a lot of comments in this bill when it was passed.
Your Honor, I respectfully disagree. I am aware of nothing in the legislative record that says that. I know that the Ninth Circuit opinion says that, but if you'll notice, the key quote that the Ninth Circuit relies on puts the words transgender women in brackets. And if you look up that colloquy in the legislative record, in their transcript that they provided in the district court, the word transgender, gender identity, et cetera, do not appear in that section of the transcript.
Can I go back to the mootness question that Justice Thomas talked about, but not addressed here at all? Yes, this respondent made certain allegations about her intent at a certain point, but she signed an affidavit with this court attesting that she has permanently stopped playing sports covered by the ban. She will not try for any school-sponsored women's sports, and in fact, I think she'll finish school very shortly. And there's no reason to question the sincerity of that belief, given that dropping out of sports puts you at a disadvantage where you lose your competitive edge, and she's going to graduate soon. How is this different than Atchison Hotel, where the person in the litigation made representations that she intended to visit and continue visiting hotels in the future, and then, when the case got before us, she voluntarily dismissed those suits, like here, with prejudice, and we then directed that the case be considered moot. How is that different?
To begin with,
I add one further difference between the two cases.
Certainly.
Here, it's not like she's attempting to avoid us reaching the question. In just a little while, we're going to reach the identical question in another case. So we don't have a subterfuge in attempting to stop the court from reaching an important legal question.
I'll start with Atchison Hotels, Your Honor. In Atchison Hotels, no one disputed that plaintiff's plans going forward. In this case, even the district court does not credit the plaintiff's plans going forward. The district court struck the notice of dismissal and said, Hecox's plans have changed before. Hecox's plans could change again. And also, the court feels that this is somewhat manipulative in order to escape the Supreme Court's jurisdiction. None of that existed in Atchison Hotels, and that puts us in City of Erie territory, where in that case, the premises were sold. The business was closed. The owner was in his 70s. And they said, that's not enough. You could still reopen this business. Your company is still incorporated. Under these circumstances, where it's the respondent seeking through post-certiorari maneuvers to moot the case, that isn't enough. This case isn't moot.
Thank you, counsel. Justice Thomas.
Does the justification for a classification, as you have in Title IX, male-female sports, let's take, for example, an individual male who is not a good athlete, say a lousy tennis player, and does not make the women's and wants to try out for the women's tennis team, and he said, there is no way I'm better than the women's tennis players. How is that different from what you're being required to do here?
It's not all different, Your Honor, and that's exactly what we're concerned about, that their arguments about needing to make exceptions from an otherwise valid classification for people for whom that classification doesn't make sense, those arguments don't limit themselves to people who identify as transgender. Many males could say, I can't really compete with the women's basketball team, and therefore I should be able to try out. And I haven't seen an answer from the other side as to why they couldn't. Beyond, I correct myself. They say that, well, those people don't face the same dignitary harm as transgender people. But I don't see how that's relevant to the intermediate scrutiny analysis. The analysis is this classification substantially related to a legitimate state interest? The person's reasons for wanting to violate the classification don't come into the analysis.
Justice Alito?
Justice Sotomayor raised the question whether the issues here are identical to the issues in the case we're going to hear in a couple of minutes, and I'd appreciate your views on that. Suppose we affirm or reverse in this case, in the other case. Would that leave something undecided with respect to your case?
Yes, Your Honor. Our case involves the issue of the constitutional definition of sex, which the Ninth Circuit made a decision about, what sex means for constitutional purposes. The Fourth Circuit did not make that decision. We will be bound by that decision going forward unless the court reaches that question. That said, I would dispute the premise of the question, because whether or not the court has Article III jurisdiction in this case does not depend on what the court might do another day in a different case.
No, that wasn't the premise of the question. It was just an attempt to explore the consequences of deciding the mootness issue one way or the other. Thank you.
Thank you, Your Honor.
Justice
Sotomayor? There's a Munsingware GVR that's being agreed to here. So you're not bound by anything in this case. And our decision there will inform any new decision in the Ninth Circuit on this issue, correct? Whatever analysis we adopt in the Little case will control what happens in a new case.
That is the law, Your Honor, yes.
Right. With respect to the Erie case, there, the 90-year-old man never said he didn't intend to open another business. He just said this business. And that was a distinction we saw. Here, she has said, I don't intend to do this. Now, every other promise that she made in this litigation, that she was going to continue trying out, that she was going to stay in sports, held true until this case and the negative attention she received, correct? To say she misrepresented her intent is going a little extreme when she honored all her previous intents and only changed her mind when new circumstances arose, i.e., the notoriety of this case, correct?
No, Your Honor, nothing changed externally to the plaintiff. The plaintiff's affidavit filed in this court says that there has been negative attention and so forth since the beginning of this case. The only thing that changed is this court granted certiorari. And then after that, the plaintiff said, I want out, and so I will stop playing sports.
Do you dispute that having a case named after you makes your infamy live forever?
No,
you don't think that Brown and any of the other named plaintiffs that we have in famous cases drawn attention to those people as people? Have you studied your law cases? Students do all the time. I think one of my colleagues had a course where they looked at the lives of the plaintiffs. Do you doubt that having a named case with such an eventful event is going to continue attention on this person?
I don't doubt there will be attention, and I confess—
Negative attention.
I confess I have studied a few law cases, but—
have you studied the people?
To some degree, Your Honor. What I would disagree with is there's no background principle of plaintiffs get to leave the litigation whenever they want. Even Rule 41, even in just the district court, the rule is that once the litigation hits a certain point, you can't leave.
So what you're going to assume, I know you don't want to, that you were to lose this case, you would say that we have to force an unwilling plaintiff who has offered to dismiss with prejudice, promised not to incur this activity again, we would force that person to continue prosecuting this case.
The court did in City of Erie.
That it did there, but is it the right thing to do? We didn't do it in Atchison.
In Atchison, no one disputed that the case was moot. The only question was which Article III question would be decided first. In this case, we dispute the case is moot. We dispute all of the facts that this is based on. This is a formidable burden that Hecox bears. That's from Nike, already be Nike, to show that it is absolutely clear that this conduct cannot be reasonably expected to reoccur. We think, as the district court said in its striking order, that based on the changing history here, based on the past conduct, as Scalia mentioned in his footnote 3 of his City of Erie concurrence, there is a reasonable basis to doubt whether Hecox's current plans are the final plans. And as long as there's a reasonable basis not to credit the current plans, Article 3 lets the court hear the case.
Justice Kagan?
Mr. Hurst, I want to take you back to our conversation about whether there's such a thing as applied equal protection challenges. and ask you for two things. The first is I do think that runs counter to a couple of things that we think of as basic principles of constitutional law and maybe equal protection law particularly. In constitutional law, we often say as-applied challenges are the preferred mode of constitutional adjudication. Certainly, we have not erected like bars to them in any other area as far as I understand it. And then in equal protection law, we say all the time things like people need to be treated as individuals and not as just as members of a group. And I'm wondering whether both of those principles don't suggest that any bar on equal protection, as applied equal protection challenges, is just wrong, is off. And then the second thing I want you to do after you do that is assume for me that there is such a thing, and to tell me how, in your view, an as-applied equal protection challenge ought to work in this case.
Certainly, Your Honor. The first answer would be I recognize those principles that Your Honor is alluding to. The contrary principle would be the very nature of intermediate scrutiny analysis, that it is always possible, if you only have a substantial fit supporting legislation, then it is always possible to find people whom it doesn't fit, and then we're in strict scrutiny.
So I completely take that point, Mr. Hurst. I mean, you're exactly right, and of course, intermediate scrutiny is different from strict scrutiny. It doesn't require the, almost perfection that strict scrutiny does. Completely take the point, but isn't that point really addressed to what we often consider in these areas, which is to facial challenges, right? So when you bring a facial challenge, of course, that's right, that you're allowed to have over-inclusiveness and under-inclusiveness and a lack of a perfect fit, but that the nature of an as-applied challenge is different.
Certainly the court could do that, Your Honor. The court has not done that before, as I think we both agree. And the result of that would be judge made exceptions to laws anytime judges thought they didn't make sense for particular classes of plaintiffs. And the deference to the legislature that should exist to some degree, even under intermediate scrutiny, would be done away with. It would be gone. And then the administrability justification for many sex-based classifications, including this one, would also be gone because you could no longer administer the classification evenly. You would have to make as many exceptions as courts thought you needed to make. So it's really an institutional competence thing or institutional power thing between courts and legislature.
So you're suggesting to me that the whole thing is just unworkable and we shouldn't, but flip to the second prong of my question, which is suppose we said, where as applied equal protection challenges exist as applied anything challenges do. What would it look like, do you think? What should it look like?
Yeah, I'm not sure what it should look like. I can say what it does look like in this case and why we think there's a problem with it.
So you're not willing to take me on my second path, which is like, let's assume that there is such a thing as this challenge.
Yes. I mean, the most I can say, I doubt this is a satisfactory answer, Your Honor, but the most I can say is that the as-applied nature of a challenge might go to the remedy. The legal analysis still focuses on the classification and the justification for the classification. And once we're talking about individuals, we're not talking about a classification anymore.
Yeah, I mean, that doesn't seem like much of an as-applied challenge, right? You have to prove the exact same thing as you do in a facial challenge, but don't worry because you only get relief as to you. So that's not a true as-applied challenge.
And I'm having trouble coming up with what it could look like because it will always be possible to carve the class down further, right? I mean, so if they say that their class, that their subclass, I guess, subclass of males is males who identify as transgender, then we would come back and say, well, only something like 10% of males who identify as transgender take the testosterone suppression. And then they might say, well, okay, no, the class is just the males who take the testosterone suppression. And then we might come back and say, well, according to the record, according to their own expert, of males who take testosterone suppression, only 1/4 of them are able to achieve the appropriate, able to achieve ordinary levels of testosterone for women. And the other 3/4 would still have an advantage, and therefore we'd be justified 75%, pretty good fit in intermediate scrutiny, and we'd be justified with the law. But then they can just change the class again. They can say, aha, no, our class is males who identify as transgender, who suppress their testosterone, and who suppress their testosterone successfully and are able to get it down to where they don't have a competitive advantage. And at that point, we can say, if you can define the class so precisely, you're going to force the state to to define the class that precisely. It's going to be enormously burdensome for everyone, and the state can never win, because whenever the state points to the fit in the statute, they just redefine their class as only the people who are outside the fit.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
To follow up on something you were talking about with Justice Sotomayor, would your constitutional position be different if the law explicitly stated that transgender women and girls cannot participate in women's and girls' sports?
My answer to that depends on what's in the rest of the law. So I would refer back to Scrimetti and say it's not a magic words test. The mere presence of the word transgender in the statute is not enough to make it a transgender-based classification.
What would make it?
If the law, either expressly or through its effect, let all males except males who identify as transgender participate in female sports, but made it so that somebody's ability to play in female sports depended on transgender identity.
Assume that the law does not allow males to play in women's and girls' sports, and then explicitly says, in separate provision, transgender women and girls, biological males who identify as female, cannot play in women's and girls' sports. Would your constitutional position be any different in that situation?
No, Your Honor, I think that's Scrimetti. I think that would be a reference to transgender identity, but the law's application would never turn on transgender identity, so it wouldn't be a transgender status.
Even if it says transgender?
The word transgender in the statute might be relevant to a pretext analysis, but it wouldn't be relevant to facial classification if that word did not change how that statute applied in practice.
How many states allow biological males who identify as females, transgender women and girls, to play in women's and girls' sports?
Statutorily, I'm aware of 27 states that take our side and do not permit that, and 23 states that take the other side and do permit it.
And those states who do allow it, is your position that they are violating the Constitution, the Equal Protection Clause, rights of biological girls and women by allowing that? Or do you say that's up to each state to decide, and that the Constitution gives discretion to the state whether to allow it or not to allow it?
I have not yet been persuaded by a constitutional theory that would let us use the Equal Protection Clause to impose our policy on other states in this matter.
Okay.
Justice Barrett?
I have some questions about the implications of your theory. So how would your theory play out if we're talking about 6-year-olds, where there's no difference between boys and girls in terms of athletic ability, testosterone levels, et cetera? Could you have sex-separated teams then? Or sorry, sex-separated teams by biological sex and not allow trans girls on the...
Certainly, Your Honor. First, I'd like to explain how the statute applies to that situation so I can put my answer in context. There are no 6-year-olds in the state to whom the statute applies because there are no school-sponsored
That's why it was a hypothetical.
Okay, right. Yes, it would be the normal intermediate scrutiny analysis. And are we saying it applies only to 6-year-olds or to everybody across the board?
Well, I'm just trying to give you a yours is driven by testosterone levels and differences in athletic capability. So I'm asking you, what if you try to take that out of the equation and you're just drawing the line based on biological sex and saying that trans girls can't be on the girls' team in an age group that's prepubescent?
The record in this case does not support the notion that males lack an athletic advantage at 6 years old. That's about as early as the science goes from what's in the record. And even at that age, males have about a 5% athletic advantage over girls in most situations. Now, if this is not a level of competition where anybody cares about that, the simple solution is the solution you see in most places, which is you have co-ed sports, you don't divide the teams based on sex, and everybody can play. And Idaho's law does nothing to interfere with that.
And remind me whether Idaho's law, and I guess your answer made me think of this, and I guess this goes to the question of whether the law discriminates on the basis of trans status. Is it true that biological girls, trans boys, can play on boys' teams?
Anyone can play on boys' teams, Your Honor.
Anyone can play on boys' teams. Okay. And to this point about medical uncertainty and scientific uncertainty, you were talking about what advantages you might have even that are apart from testosterone levels. Mm-hmm. Your friends on the other side say that, listen, that science is uncertain, and so we need more factual development. It's not really clear how much of an athletic advantage boys and men have if their testosterone levels are below a certain point. How does that play out? Tell me why we don't need more fact-finding, or what is the state's burden in showing what the state of scientific certainty is? Do we have to defer to the state? Presumably at some point, if deference is due, the state would have too little scientific evidence to really get that deference. Tell me how to think about that.
The first question would be, are we applying intermediate scrutiny? And we argue that the court shouldn't. But leaving that aside, if the court is applying intermediate scrutiny, then we'd say it's Turner Broadcasting that says the legislature, First Amendment case, applied intermediate scrutiny and said under intermediate scrutiny, the legislature has to draw reasonable inferences from substantial evidence. It does not need to act only on scientific consensus, which is what the district court in this case assumed incorrectly.
Thank you.
Justice Jackson?
So I guess I'm going back to your discussion with Justice Kagan. I'm not sure I understand why you're characterizing the as-applied challenge in practice as the individual coming back and proposing a different classification, as though we're doing an analysis of the classification in the way that you suggest. I thought that the state has a classification that is its general rule. No individuals who identify as female but were sex at birth male can play in women's sports, and that the individual then is merely seeking an exception based on their individual capacity, because the state's general rule is based on fairness and medical science and all of these things. Do I have this, like, they're not proposing an alternative class necessarily. They are just saying that I should be accepted from that general rule on this basis.
We agree that an exception is what they are seeking, Your Honor. And it's an exception based on transgender status, again.
But that's the way the rule used to work, right? I just want to be clear about what we're talking about here.
Sure.
I understood that this law originally was exactly that you basically said no transgender women in girls' sports, but we'll look at your evidence and look at your circumstances and decide whether or not you individually can be included.
So
is that what used to happen?
As a matter of Idaho law, there was no law whatsoever before this.
Is that what was happening on the ground in Idaho law?
That's what NCAA policy permitted from 2010 to 2022. Before 2010, the NCAA policy matched ours. Since 2025, the NCAA policy has matched ours.
Okay. But what I'm asking is, if that's the ask here, not that all transgender women be allowed, but that this particular plaintiff be allowed based on their circumstances, why is that so not administrable or proposing a different classification that we're not going to be able to sustain? I don't understand.
So first as to administrability, Your Honor, making sure that a transgender athlete does not have an unfair advantage would require ongoing testosterone monitoring, because circulating testosterone can fluctuate. That is invasive. That is intrusive.
No, but that's the burden of the person. The person who wants to play has to demonstrate to you, to whatever degree of scientific certainty, that they don't have a competitive advantage. Why would you not allow that? I guess I don't understand.
The second answer is that there's nothing in that argument that limits itself to transgender identifying athletes. If this athlete doesn't have an advantage over women and therefore can compete safely, then there are other athletes that could say for different reasons that they don't have an unfair advantage and therefore they could compete safely.
Yes, and I understand that, and there are legal arguments. Let me ask you something about the classification. I guess I'm struggling to understand how you can say that this law doesn't classify on the basis of transgender status. The law expressly aims to ensure that transgender women can't play on women's sports teams. So why is that not a classification on the basis of transgender status?
I'd apply Skermetti again. The question is whether the application of the law turns on transgender status, and it doesn't. It turns on sex. The legislature did not want to exclude transgender people from sports. It wanted to keep women's sports women only and exclude males from women's sports.
No, I understand, but with respect to two individuals, a cis woman and a trans woman, who both want to play on a team that reflects their gender identity, this law operates differently based on their sex, right?
The law does operate differently based on their sex, as Your Honor just said. It does not operate differently based on their transgender identity.
But it treats transgender women different than cis women, doesn't it?
It has a disparate impact because men who identify as transgender have a different reason for wanting to play women's sports than women, than biological females do, right? But if that were enough, then Skermeti would have come out a different way, Gaduli would have come out a different way, other cases would have come out a different way. I'm blanking on the other ones.
All right, finally, let me just ask you about mootness, because it's a little odd, I think, that a defendant would not want a case dismissed. Ordinarily, the defendant is the one who's claiming mootness because they've been sued. So this plaintiff has brought a claim against you, and the claim relates to your policy about college sports. And as I understand, the plaintiff is about to graduate. So wouldn't we have a mootness problem potentially notwithstanding any representations that the plaintiff made?
I don't think so, Your Honor. I'd look to Camreta as the case that tells us the best case for telling us how we analyze mootness in this situation. It's, does the petitioner still have an interest in continuing the litigation?
Only for a few more months. What if this decision doesn't come out until June and she graduates in May?
It's my understanding at this point, I defer to my friends here, it's my understanding at this point that May graduation is not possible.
For this individual?
For this individual, that's correct.
All right, thank you.
Thank you.
Thank you, counsel. Mr. Mooppan.
Mr. Chief Justice, and may it please the court. It is undisputed that states may separate their sports teams based on sex in light of the real biological differences between males and females. States may equally apply that valid sex-based rule to biological males who self-identify as female. Denying a special accommodation to trans-identifying individuals does not discriminate on the basis of sex or gender identity or deny equal protection. All of that remains true, even assuming a man could take drugs that eliminate his sex-based physiological advantages. The law is reasonably tailored, regardless of whether it is perfectly tailored, as applied to any such tiny subset of men. And states are not required to redefine sex or monitor the testosterone levels of female athletes. In short, male athletes who take performance-altering drugs are not similarly situated to female athletes, and states need not treat them the same. I welcome this court's questions.
Would you elaborate on what you alluded to, and that is that whether or not a state has to, its asserted interest in classifications has to bear out in each individual case? That seems to be what the applied challenges in individual cases would require.
That's right. So intermediate scrutiny requires a substantial relation or a reasonable fit, which is not a perfect fit. And this court has recognized, and I'd point this court to Edge Broadcasting in particular, it focused on this exact issue of if the law is substantially related in general, can an individual come in and say, well, as applied to me individually, it's not. And the court said, no, we're not going to allow you to do that because that would essentially convert intermediate scrutiny into strict scrutiny on an as-applied basis. Now, I'm not disputing that you can sometimes bring as-applied claims under intermediate scrutiny. So if, for example, you had a law that applied, this sort of law that applied to sports, but also math and also chess, it might be that as applied to math or chess, it was invalid, but it was valid as to sports because for math and chess, at the level of the classification, it's not reasonably tailored. But here, critically, everyone agrees that for sports, for 99% of men, it's reasonably tailored. It's just the 1% of trans-identifying individuals who take drugs and then those drugs are effective that's a problem. And this court's decision in Michael M. makes clear that that's not a viable as-applied claim. In Michael M., this court upheld a statutory rape law that applied differently to men than women, and the rationale was because women faced a unique risk of pregnancy. But of course, if either the male rapist or the female victim was infertile, there'd be no pregnancy. So on their theory, you could have come in and said, well, I have an as-applied claim that I was infertile, so it was okay to rape the underage girl. And this court not only rejected that, the court said it would be ludicrous to say that you could bring an as-applied claim for prepubescent girls. That's just not the way as-applied scrutiny works in intermediate scrutiny cases. That's equally true, as my friend said, in Wynne. In the court's decision in Wynne, the justification for the law was making sure that the parent knew that they were the parent and had an opportunity to have a relationship with the parent. But Wynne's father knew about the birth, was present with Wynne the whole time, and brought Wynne to the United States. Nevertheless, the court held, for the class of men overall, it was reasonably tailored, and they weren't going to focus on the specific facts of Wynne.
You started, Mr. Mooppan, by saying that you did think that there were as-applied equal protection challenges, and giving an example of, well, if it had also applied to the chess team or something. But that doesn't seem like an as-applied challenge to me. That seems as though there's just a provision of the law that's facially invalid, right? So let's put those kinds of cases aside where you can split the law up and say this part is facially invalid, this part isn't, and focus instead on like real as-applied challenges. Your classification is basically okay, let's posit, because there's a substantial relationship to your goal. Is there ever a time where a person can come in either on behalf of herself or on behalf of a subclass and say, notwithstanding that there is no valid facial challenge here, there is an as-applied challenge, this subclass has to be exempted?
So I don't think this court's cases have ever squarely addressed that. I think if it could be brought, it would have to be a very substantial percentage. So to give you a stylized hypothetical, if you had a law that regulated on the basis of sex, and you could imagine 3 subgroups of males, for subgroup 1 and subgroup 2, each of whom were a third of men, it was reasonably tailored. But for subgroup 3, which was a third of men, it wasn't. Maybe in a circumstance like that, the third subgroup could come in and say, for a third of the applications of this law, it's not reasonably tailored. That's not enough of a substantial fit, at least for us, even if you're going to uphold the law for the other 2/3 of
But why does it have to be that many people? Why? I don't understand why that subclass can't make this showing and get the remedy as to them.
Because if it's one person, you're basically converting the law into strict scrutiny.
But you're not. You're not. I mean, because what you're doing is you're allowing that individual to get the remedy that we've said in cases like CASA is the only thing that's available, that you can't have this flow to everybody. It's just about this individual and whether or not he's been unconstitutionally treated.
So again, because if the law is reasonably tailored for 99.99999% of people, and you come up with a point fraction of percent and say that that person has a viable claim, that's more than you would ever require under strict scrutiny. I don't know of any.
No, but I mean, well, what's the result of that? If you're making a facial challenge, I understand that you're saying that if the law has such a broad sweep of constitutionality, then we're not going to strike this thing down just because we can identify one person for whom it doesn't apply. But if you are that one person and you can show that this is unconstitutional as applied to you, I guess I don't understand why it matters that it's constitutional as applied to 99.9% of the other people.
Well, because I think you're begging the question when you say it's unconstitutional applied to you. Laws that classify on the basis of sex only need to be reasonably related. And so if it's reasonably related because it's tailored for 99% of people, then it is constitutional even applied to you.
Even as applied to you. So you are saying there is no such thing as an as applied intermediate scrutiny challenge.
No, again, if there was one where it was a third of the people, I can maybe understand a claim that the third of people, it's not reasonably related for them, even though it is for 2/3 of the people. I'm just saying that when the numbers get as small as they are here, that claim's not viable. And we know that from this court's cases. Again, Michael M., every infertile man.
No, I understand, but we didn't do that same kind of quantitative analysis in Caban, right? We didn't ask the husband in Caban to figure out where he stood relative to all husbands who were to whom this was applied.
Right. So let me talk about both Caban and Lair. So Caban is not an as-applied challenge. Caban did not say that there was some set of people for whom that law was valid. The differential treatment
itself. Lair said that about Caban.
So what Lair held was the father in Lair had abandoned the child. And what Lair essentially said is, if the mother had abandoned the child, the mother wouldn't get a veto.
Can I read to you what Lair said about Caban? Discussing Caban, Lair explained, quote, "We have held that these statutes may not constitutionally be applied in that class of cases where the mother and father are in fact similarly situated with regard to their relationship to the child." So Lair is interpreting Caban as an as-applied challenge, isolating a subset of people where there's not actual similarly situated circumstances. And Lair is different. It is a facial challenge. It is in opposition. No?
That sentence in Lair, the facts of Lair, there was no differential treatment. The father in Lair had abandoned the child, and the court basically rejected his claim because if a mother had abandoned the child, the mother also wouldn't get a veto. So Lair's a case where the plaintiff lost because there was no differential treatment at all. Caban is a case where the plaintiff won because the classification couldn't be justified. The only way those cases would support their position is if either Caban or Lair had said there is some set of cases where the woman gets a veto but the father doesn't, and that's fine. And neither Caban nor Lair said that. This court has never said in those line of cases that the mother could get a veto but the father doesn't, and that's perfectly okay. So that's what they're arguing, and neither of those cases support it. You'd also asked about VMI, so if I could just briefly address why VMI doesn't support them either. In VMI, the point was, yes, lots of women wouldn't want to go to VMI, but also lots of men wouldn't want to go to VMI. As to the set of people who were actually burdened by the exclusion, all of the women, the law was not fairly tailored. The argument that Virginia was making VMI was essentially equivalent to the following. If MIT said, most women and frankly most men can't meet our math and science standards, so we're just not going to allow women to come to MIT at all. Of course this court would reject that argument. That was the argument that they were making in VMI, that just very few women wanted to attend. But for the set of women who wanted to attend, the law was not properly tailored because there was no justification for excluding them.
Thank you, counsel. Justice Thomas? Justice Alito?
Under Title IX, what does the term sex mean?
We think it's properly interpreted pursuant to its ordinary traditional definition of biological sex, and I think probably given the time it was enacted, reproductive biology is probably the best way of understanding that.
Thank you.
Justice Sotomayor?
The problem I'm having with what you're doing now is you're doing exactly what Justice Stevens said should be done, and he admitted later in O'Connor that the court roundly rejected that in Caban and Lear. He wanted to do exactly what you said. He said, in dissent, this court should be in analyzing equal protection, contending that if the classification is justified in those cases in which the rule has its most frequent applications, then it doesn't violate equal protection. And then he said the court should presume that the law is entirely valid and require the challenger to demonstrate that its unjust applications are sufficiently numerous and serious to render it invalid. It's exactly what you said we should be doing. So you want us to accept what the dissent did and not what the majority said it was doing in Caban or Major. In VMI, Justice Scalia said the same thing, that taking the majority's logic to its logical conclusion, a single woman who wanted to attend could satisfy the admissions requirement would be enough for an as-applied challenge, and that shouldn't be the law. You're asking the court to adopt views expressed by two minority dissenting judges in this case. We've been doing an awful lot of that lately, but you're smiling because it's true, but you're asking us to adopt an approach that we have rejected as a majority court and accept what dissenters are doing, correct?
With all respect, no. Again, in Caban, nowhere in the majority opinion in Caban did they say this law is reasonable for certain classes of men, but it's
but
not reasonable.
it did exactly. It said it's reasonable for fathers who don't support their children. It won't be reasonable for fathers who don't.
With all respect, Your Honor, it did not. Caban did not uphold that law as applied to any man who hadn't abandoned their child. Now, it is true Lair's upheld the law for someone who had abandoned their child, but the reason it upheld the law is because women who abandoned their child.
But the logic of the opinion is that if the reverse had been true, it would have ruled the way it did.
I don't think that's true, but even if you thought that was – sure.
No, I just have one last question. What's percentage enough? There are 2.8 million transgender people in the United States. That's an awfully big figure. I do understand that in Idaho this was the first transgender child, but that just happenstance as to location. What makes a subclass meaningful to you? Is it 1%, 5%, 30%, 15%? One is not enough for you, but why?
Well, so I'll say
when the numbers don't talk about the human beings.
So I'll say a couple of things about that, Your Honor. The first I'll say is if the distinction between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit, 1% surely has to be on the side that's reasonable. But if you don't want to just take the 1% on its own face, I would point your court, you want to focus on majority opinions or opinions for the court. Michael M. rejected a challenge even though that law wouldn't, for infertile couples, either infertile rapists or infertile victims, the justification didn't apply. There are certainly more infertile people.
But they did it on a different basis, which had to do with different harms.
No, that's not true, Your Honor.
Well, I can read the decision and tell you.
With all respect, that paragraph, it says, even setting aside the physical differences, it is ludicrous to think we have to exclude infertile children from this rape law. And there are certainly more infertile people than there are trans-identifying individuals who take these drugs and eliminate all their physical advantages. So if we just focus on holdings of this court, we know that this percentage is too small.
Justice Kagan?
Mr. Mooppan, just assume with me that there is such a thing as a as-applied equal protection challenge. What would it take to bring that challenge? What should the plaintiff have to show?
I think they would have to show that, A, they are a substantial enough percentage to be able to bring an as-applied claim, and then as to that group, the law wasn't reasonably tailored for them.
And that they would have the burden on that. It's not for the state to come back and say, the state does not have to satisfy that burden initially.
Certainly not the first of the two things I said. I think if you thought that you could have a valid as-applied claim and they had made it through the gate of saying they were a big enough class, then I think consistent with normal intermediate scrutiny, I think the state does bear the burden of showing justification for that class. So I think the state would have it on the second step. The plaintiff would have it on the first step.
I see. So they have to sort of get through the gate of we're big enough for you to take us seriously, but then the state has it.
I think that would be how you would analyze it.
And I think you were asked this, but big enough to be taken seriously? Like, how do we decide that?
You know, again, the court's cases haven't really talked about it. I think the way I would think about it analytically is the difference between intermediate scrutiny and strict scrutiny is the difference between a perfect fit and a reasonable fit. So is there enough of a group here that we think that we're not essentially holding the state to perfection? If it's so close to perfection, then you're really undermining the difference between the two. If it's a big enough group that we're not asking for perfection.
I mean, are you really undermining the difference between the two? Because usually we think of the difference between the two with respect to facial challenges. So you have to do a whole lot less to show that the facial classification that you're making is okay.
I don't think so. I do think that you would very much be undermining the difference between the two if you said that even a single person could bring an as-applied intermediate scrutiny case. And again, I would urge Your Honor to read Edge Broadcasting. There's a whole section of the opinion that's on this exact issue and says exactly what I'm saying. Now, admittedly, it's a First Amendment case, but it's an intermediate scrutiny First Amendment case.
Thank you.
Justice Gorsuch?
If the class is big enough, in your discussions, say a third, as you discussed, might it just fail intermediate scrutiny facially? I mean, at some point, do they collapse?
So I agree that that's part of why these are so unusual. If there's a big enough group that you've excluded, you're exactly right. It might not be reasonably related as a whole, and so then it facially fails. But I could at least conceptualize a situation where it covers enough people validly that a facial challenge fails, but it covers a big enough group that it can't be justified for, then maybe you could bring an as-applied claim. I don't think this court really needs to grapple with these fairly tricky analytical questions, because this is the world's easiest as-applied claim to reject. It is a fraction of a percent. Whatever as-applied claim you could bring, it cannot possibly be a fraction of the percent. That would be totally inconsistent with this court's decision, Michael M. and Wynn, both of which rejected claims by people who had a much greater percentage than a fraction of a percent.
As you know, a lot of states allow biological males who identify as female, transgender women and girls to play in women's and girls' sports. And you heard Idaho say that those states, other states, constitutionally may allow that, consistent with the Equal Protection Clause. Do you agree with that?
So we've been challenging those laws under Title IX in lower courts, and as we said in our brief, we would urge the court to just reserve judgment.
Can you answer the Equal Protection Clause question that I just asked?
I'm not sure if we've taken a position on the equal protection piece.
Do you have a position?
I don't right now.
Okay, and on Title IX, footnote 2 of your brief seemed to say that you don't have a position on how Title IX applies to those states as well.
No, so we are actively litigating in lower courts, and we are saying that they are violating Title IX. What the footnote said is it's a very different question, and we would urge this court to make clear it's not resolving that question one way or the other by what it says in this case.
Okay, so you have a position on it, but you don't want us to say anything about that issue.
It's a very different question analytically, and so—
I understand. That's why I'm asking.
Yes.
Yeah. Okay. Thank you.
Justice Barrett.
So, Mr. Mooppan, when Justice Kagan started asking the questions early on about the as-applied equal protection challenges, she pointed out that there was kind of a surprising dearth in the case law really grappling with this. But I think you wouldn't be getting all the questions that you're getting about Caban and Lair and, Michael M. and VMI if it weren't the case that you can read some lines of cases either way. So let's say that there is this uncertainty. We haven't really confronted it. As far as I can tell, it's because it just wouldn't be relevant in strict scrutiny because it's often fatal in fact, or typically almost always fatal in fact. So it's really an intermediate scrutiny problem. Maybe it's a rational basis problem too. I mean, maybe this would have implications for all kinds of review. Because it seems to me that if you're never talking, in any case in which scrutiny is not talking about a perfect fit, you might have this problem. What would it do, essentially? I'm just trying to think about the ramifications of allowing as-applied challenges. It seems like it's at war with the theory of intermediate scrutiny for some of the reasons that Idaho said, because all lines, all classifications overshoot or undershoot, right? So can you imagine how intermediate scrutiny works? And this is, this isn't designed to be a layup or something. It's honestly just something I'm grappling with. How would it even work going forward?
So I'm not sure I can say a whole lot more than what I've already said, which is I do think it's a problem. The reason I think it's a problem is it's conflating the difference between strict scrutiny and a perfect fit, intermediate scrutiny and a reasonable fit. And I worry that if you allow as-applied claims to a small enough group, you're essentially collapsing the difference because you're essentially requiring a perfect fit. Because whenever you have a reasonable but not perfect fit, the subset who falls within that will come in and bring an as-applied claim. And so the state will essentially have to have perfectly tailored laws because any single person for whom you don't have a perfect fit could come in and bring an as-applied challenge.
Including, say, boys who just couldn't make the team because they weren't good enough, because the law, to the extent that it's designed to protect competitiveness and safety, et cetera, wouldn't pose the same danger in the case of a boy who just isn't good enough to make the male team, but perhaps could make the girl team.
At least arguably, depending on what their exact theory is for the justification.
Thanks.
Justice Jackson?
I guess I'm still struggling to understand why the state would have to have perfectly tailored laws. I would think the state would just have to make exceptions where people can demonstrate that the justification that makes the state's conduct constitutional doesn't apply to them.
Right. So making exceptions is tailoring your law. That's literally what it means to tailor.
No, but
law.
from the standpoint of a facial challenge, when we're asking whether this law has to be stricken completely because it isn't, perfectly tailored, what we're doing is a different exercise in the as-applied challenge. We're asking whether, even though this law is overbroad, we're assuming it's overbroad now because you've got in there some people to whom it should not be applied. What do we do about that? What is the remedy that those people can get? And what I hear you saying is they get no remedy unless they can demonstrate that there are enough people that this is sufficiently overbroad that it's no longer something the state can do.
Right.
And I don't understand why that is. Why wouldn't, when we identify people for whom this law operates unconstitutionally, that's the premise, because now I'm in remedy, right? The premise is that you have a person who's successfully made an as-applied challenge. This, to me, unconstitutional. You say, too bad, unless you can show that it's also unconstitutional with respect to a sizable number of other people. And I don't understand why that's the case.
Because I don't agree with the premise that the law operates unconstitutionally as to an individual person just because it doesn't, the justification for the law doesn't apply to that person. That's what this court held in both Wynne and Michael M. It recognized that the justification that was put forward for the law might not be true for each and every person the law applied to, but this court said that's fine.
And if we read Caban and Lair to say something different, if I disagree with you, then we just...
Well, Wynne is the most recent of the cases. So
okay.
Even if you read the case that way, and Wynne is explicit about this. Wynne explicitly says, I believe it's, I'm not going to get the page number right, but Wynne explicitly says that we recognize that there are some men who were present at the birth of their child, who have a DNA test to prove that they were the father, that have been with their kids their entire life.
Yeah.
In fact, that was probably true of Wynne's father. Tough luck.
Okay, so Justice Barrett is worried, I think she said, about the implications of allowing as-applied challenges. I guess I'm worried about the implications of not. Because as Justice Kagan said, we have consistently said that facial challenges are really hard to get, that as-applied is really all there is. So now we're in a world in which you are setting up new barriers, in my view, to establishing an as-applied challenge. So at the end of the day, is your position that no matter how clear it is that the particular prescription is operating to disadvantage a particular group, that classifies you, treats you differently, you're just not going to be able to get a remedy for that individually anymore.
Let me take a step back, and then maybe this will help. Laws that classify, in general, are subject to rational basis review. Now, there's higher scrutiny for classifications on some things. For race, we have strict scrutiny. For sex, we only have intermediate scrutiny. What that means is it is okay to have a classification that doesn't operate perfectly for each and every person. So it's not the problem is that it's unconstitutional, but there's no remedy. The point is that it is constitutional,
I don't necessarily
even though it's
think that's
overbroad.
the takeaway. I think what that means is it's okay because we realize that in some circumstances, maybe even in many circumstances, this classification is justified. But when we can identify a situation in which it's not, I don't understand why a person can't bring that challenge.
Well, I can't say anything better than in both Michael M. and Wynne, the court recognized that there were people who wasn't tailored for and they didn't give them a remedy.
Thank you.
Thank you, counsel. Ms. Hartnett.
Mr. Chief Justice, and may it please the court. Idaho concedes that HB 500 draws a sex-based line by categorically excluding all students with the biological sex of male from women's teams. Sex classifications like that are closely scrutinized under the Equal Protection Clause to ensure they rest on evidence, not supposition. Idaho's articulated justification for this line is to protect women's sports from birth-sex males because of their, quote, biological advantages. That means HB 500 is aimed at controlling for sex-based biological advantages, not for all of the many reasons one athlete may be better than another that have nothing to do with sex. On the preliminary record in this case, and as the experts below agreed, circulating testosterone after puberty is the main determinant of sex-based biological advantage that HB 500 sought to address. And on this record, Lindsay Hecox has mitigated that advantage because she has suppressed her testosterone for over a year and taken estrogen. HB 500 thus fails heightened scrutiny as applied to Lindsay and transgender women like her who have no sex-based biological advantage as compared to birth-sex females. That analysis would come out the other way for the untalented cisgender boy. He would have the same sex-based advantage, the circulating testosterone, he just would not be as good at sports. It also would come out the other way here, for example, if a transgender woman had gone through a male puberty and had not mitigated that advantage. This court's cases have recognized that when the government's justification for a sex-based classification does not apply to a discrete subgroup of those classified, that classification is unconstitutional regarding that subgroup. And that holding in Caban, which I'm sure we'll discuss further, has been repeatedly referred to and reaffirmed, including more recently than Nguyen and Morales-Santana. Because the court can affirm based on sex discrimination, it's not necessary to reach the question of transgender status discrimination, but HB 500 also fails on that basis. If the court does not find the case moot, the preliminary injunction should be affirmed. I welcome the court's questions.
Couldn't you make a similar argument with respect to Title IX itself and the sex difference, the fact that you can have male and female sports?
No, Your Honor. So I think the point would be, the question would be, would the sex line that's drawn in sports, and that's a line that does exist, as a commonplace line, is that substantially related to the important state interest?
Well, you could have individuals who, for example, don't present the problem of physically outmatching women in a particular sport, or a group of people who don't.
Right, and the broader goal here, of course, is not sex separation for its own sake. The idea is to have equality in sports, and that's the ultimate objective that I think we're all talking about, not separation for its own sake.
Well, my point is the argument that you're making now with respect to this subcategory, could it not also be made with respect to the sex separation in Title IX generally?
Occasionally there have been examples of a boy challenging the separate teams because they want access to a team that's not available for the boys because of the way Title IX works. To be clear, we have not aware of an example of a boy challenging the sex separation so that they can be on the girls' team where there's a boys' team that exists. In that case, the courts do look at that under intermediate scrutiny, and they determine that the overall goal of ensuring equality in sport opportunity for women and men allows for the distinction.
Counsel, I wonder if you could address what has been, I think, the basic focus of the discussion up till now, which is, as I see it anyway, whether or not we should view your position as a challenge to the distinction between boys and girls on the basis of sex, or whether or not you are perfectly comfortable with the distinction between boys and girls. You just want an exception to the biological definition of girls.
Thank you, Your Honor. We're not asking for a particular definition or even really an exception. I think what we're asking for, and it is similar to the nature of the challenge that was brought in Caban. The situation there were there unmarried fathers that were barred completely from objecting to their child's adoption. And there the fathers said, we'd like to be able to have that objection. We have a substantial relationship with the children. And in the group, and there was actually a pretty tailored group in that case. In Justice Stevens' dissent, he points out it has to be an older child, and there has to be a participation in the rearing. For that subgroup, they were allowed to challenge that and get the relief. And so, I do note too that Justice Stevens pointed out that it was an indeterminately small subgroup of an unknown number of fathers. So I think that's the analogy that we would draw here to what we're asking.
So what would be the appropriate inquiry? And it's asking you basically for your response to Mr. Mooppan in particular, that going sort of challenge by challenge, whether it's based on a transgender status or anything else in the situation, is really transforming intermediate scrutiny to strict scrutiny.
We agree there would have to be a group. I don't think, in our view, in a way, at least the way that the cases have worked out, and this is Caban and Lair, it also goes through Nguyen and Morales-Santana. I would also direct the court to the illegitimacy or the non-marital children case. Those are Trimble and Lally. They're cited in the BPJ brief. In the same way, I think the court looks, is there a definable group that's not just a person who happens to not meet the fit, but actually a group where the rationale doesn't make sense for the subgroup. But the group can be somewhat specific. Like in the case of Caban, it was actually unmarried fathers who had acknowledged paternity and had a substantial relationship. In the Trimble case, it was non-marital children who had a confirmation of paternity and a relationship with the father.
Well, that sounds an awful lot like strict scrutiny, unless you're going to say whenever you can come forward with anything that is an exception to the boy-girl distinction, in any case at all, you can go forward with the strict scrutiny challenge, whether it's 1% or whether it's 12 people, and I'm just not quite sure grasping why your position isn't really an effort to apply strict scrutiny to a distinction that we haven't applied it to.
Thank you, Your Honor. I mean, all I can say, and I do agree the cases are not that many in this context. I think it's possibly because facial challenges were more in vogue before, and now as-applied challenges are more preferred, and so that may be explaining why a statute in Caban, for example, wasn't viewed as carving out the statute for the people it couldn't be applied to versus facially invalidating it. But I do think it matters because it's not just a matter of fit that makes intermediate scrutiny different. There also has to be an important government interest, not a compelling one, and this is really critical. You can burden the right in intermediate scrutiny. So in Nguyen, for example, that person failed because he actually didn't take the steps that would be needed to confirm the paternity. So you're allowed to actually, he may have had a compelling case on a one-off basis that, hey, I actually do have that relationship with the citizen father when I was born abroad, but he didn't take the steps that he needed to do. The same thing with Lair, and the same thing with Lally and the Trimble-Lally line. So you can actually burden the right by saying Lindsay Hecox has to actually submit testosterone tests or something else different than other people, and that would not be allowed if it were strict scrutiny.
And if we follow your approach, which allows a challenge to even a fairly small group that's affected, in what way would we not that would apply across an entire range of things where there's a distinction currently between boys and girls, quite apart from just athletics. Is that correct?
Your Honor, I do think that the question would, I think we're not trying to invent something here. I think we were trying to draw from what we understood to be precedent from the court, and I would direct you to the Equal Protection Scholars Brief. They have some scholars that have actually focused on this question of what does an as-applied challenge mean in the equal protection context. But I think taking a step back, the question always would be looking at what the state's asserted interest is here. And here the state is not asserting an interest of having the boys' teams be better and the girls' teams be worse. What they're trying to do is control for a sex-based biological advantage. And so I think a lot of the hypotheticals that you can maybe understandably think about, what about the untalented cisgender boy? What about the transgender woman who didn't mitigate? You know, what about this or that? That gets taken care of because the testosterone is the advantage on this record, and almost all the people that might want to try to get an as-applied challenge under some other idiosyncratic framework would not be able to show that their exclusion actually was.
Okay, and this will be my last question for my point was more that how we approach the situation of looking at it not as boys versus girls, but whether or not there should be an exception with respect to the definition of girls. That would, if we adopted that would have to apply across the board and not simply to the area of athletics.
I mean, I think it's a general framework for equal protection challenge that, again, predated this case, this litigation. There have been boys that have tried these challenges in the past. They generally have failed because they actually don't lack the opportunity or actually are treated, they're not being treated differently than similarly situated individuals.
You said, Ms. Hartnett, that you're not talking about individual by individual by individual. It has to be a defined group. So how big does the group have to be? How does it have to be defined? And why are there those requirements? If what you're saying is right about equal protection law, why wouldn't it extend to individual by individual by individual?
I don't think the court has foreclosed that other than this actual obvious conceptual question of like when do we get towards strict scrutiny. I think what I could tell you is that in the way that the court looked at it from Caban to Lair to Nguyen to Morales-Santana and then also Trimble and Lally for the case of non-marital children, the court seems to usually be trying to figure out not just is this individual somehow idiosyncratic, but are they part of a group that actually doesn't make sense to exclude. And that makes sense because usually you're trying to figure out is the interest served by the exclusion, and there's usually some principle why a subgroup was not properly included.
And what are the requirements of, what does that group have to look like? Mr. Mooppan suggested that it has to be, fairly sizable. It can't be 1% or less. why not? Why? What are the other requirements? Like, how do you go about defining which group, which subclasses get to make this challenge and which subclasses don't?
That's a good question, Your Honor. I think in Trimble, this is again the non-marital children case and cited in the BPJ brief, they said discrete categories that were unnecessarily excluded. That was the notion there. So I think that's where we were trying to make clear that we don't think it can just be we have a person that is extraordinarily idiosyncratic and they should get their case. And I don't think anything in your cases rules that out. I guess that's not actually the case presented here. We think we have an easier case because we actually have identified a discrete subgroup, transgender women who do not have an athletic advantage.
But I don't think you're answering Justice Kagan's question, which is fine. If you buy into you have this subgroup as you've identified it, Mr. Mooppan says that subgroup has to be big enough. Do you agree? And if so, how do we evaluate that?
I don't agree with that. I think that is I think in a way this is the Caban dissent kind of coming back after many decades, because there, Justice Stevens said in the dissent, he's assumed that the case in that case was assuming that the case extended only to himself and by implication to an unknown number of fathers, and went on to say indeterminately small part. So I think there's never been a numerical requirement. It's more of a question of whether there's a principle that some sort of a principle that allows for the exception in light of the failure to align with the interests that the state's asserting. And here, I think the record, and again, we're at a preliminary injunction stage, but the preliminary record was that the exclusion of our client actually was not going to advance the interest, nor the exclusion of other transgender women who do not, who have taken efforts to mitigate their testosterone, which was on the record here again, was the main driver of differential athletic performance.
Counsel, one might wonder whether the efforts to refashion our equal protection jurisprudence here that we've been discussing at length on sex discrimination is really a fallback from what one might wonder might have been your primary argument, which is that transgender status is itself a discrete and insular class. And I'm curious why you haven't brought that up and what thoughts you want to share with us. Your friend on the other side said the laws you pointed to in your brief don't address transgender persons as such, and that makes all the difference. Thoughts?
Well, thank you for the opportunity to address that. I think we were trying to find the most straightforward way to help the court to an answer here, and I think we do think
I've been wondering what's straightforward after all this discussion.
No, I understand. I think these are older cases, but it's very interesting to see the debate between the majority and Justice Stevens, and then Justice Stevens and O'Connor kind of admitting that he was applying his dissent in Caban. So these are cases from the court. We think they have some force. But to the question you've asked, I do think it's important to begin with, you heard my friend on the other side talk about cross-dressing or other laws. They didn't have any response to our point, because there isn't one, that transgender people were categorically excluded from immigration to this country under an overall umbrella of being a psychopath. That was the actual decision of this court in the Boutelier case. It was interpreting language of Congress that determined that when Congress used the term psychopathic personality to exclude people, they meant to include homosexuals and other sex perverts.
Perhaps not our finest hour.
Well, it's not your fault, but I think that.
Thank you for that.
No. Well, it was by reference to a congressional report. They were trying to figure out what did Congress mean, and there actually was a public health service report. I would direct your attention to it because I think it really does go to the level. I was surprised when I read this document. It's 1952 USCAN 1653 at 1701, trying to explain why sex perverts would include homosexuals, transvestites, which was the name of the day for transgender people. The term transgender did not become more common till now. So I think reading Boutelier and reading the USCAN that's cited in Boutelier is instructive. I also think that the laws on cross-dressing, I think that's an interesting point, because what that actually means as a practical matter for the transgender person was that they weren't allowed to leave their home as themselves to enjoy all of their civil rights. And we don't want to exaggerate it, but we also don't want to understate it. There were major cities in the country, Chicago, others, that actually barred you under subject to criminal penalty for leaving your house in clothes that weren't matching your gender. And people were actually prosecuted under those laws. So again, I appreciate, and we're not saying you have to have the same history. We're certainly not equating the experience of the transgender community to that of Black Americans or of women. But just as illegitimacy or non-marital children has been recognized as a class that gets closer look, I think we respectfully submit here it would make sense to do so. We appreciate, though, this is a question that the court hasn't recognized a suspect class for a long time. They also haven't shut the door to a suspect class since Cleburne. So I think we prefer, to the extent the court was still finding another path forward, the reason why we tried to help you find a way to answer the question here based on sex discrimination.
Well, to pick up on the issue of discrimination on the basis of transgender status, let me just go to some basics. Do you agree that a school may have separate teams for a category of students classified as boys and a category of students classified as girls?
Yes, Your Honor.
If it does that, then is it not necessary for there to be, for equal protection purposes, if that is challenged under the Equal Protection Clause, an understanding of what it means to be a boy or a girl or a man or a woman?
Yes, Your Honor.
And what is that definition? For equal protection purposes, what does it mean to be a boy or a girl or a man or a woman?
Sorry, I misunderstood your question. I think that the underlying enactment, whatever it was, the policy, the law, we'd have to have an understanding of how the state or the government was understanding that term to figure out whether or not someone was excluded. We do not have a definition for the court. And we don't take issue with we're not disputing the definition here. What we're saying is that the way it applies in practice is to exclude birth-sex males categorically from women's teams, and that there's a subset of those birth-sex males where it doesn't make sense to do so according to the state's own interest.
Well, how can a court determine whether there's discrimination on the basis of sex without knowing what sex means for equal protection purposes?
I think here we just know we basically know that that they've identified pursuant to their own statute, Lindsay qualifies as a birth-sex male, and she's being excluded categorically from the women's teams as the statute. So we're taking the statute's definitions as we find them, and we don't dispute them. We're just trying to figure out, do they create an equal protection problem?
All right. Suppose this school that has a boys, let's say, track team and a girls track team. The school has that. And a student who has the genes and the reproductive system of a male and had those at birth and has never taken puberty blockers, never taken female hormones, never had any gender-altering or affirming surgery, says, nevertheless, I am a woman. That's who I am. Can the school say, no, you cannot participate on the girls' team?
So you're just a birth-sex male who has all the advantages of birth-sex male hormones, and can the school bar him from the women's team? Yes, they can.
But that person, is that person not a woman in your understanding? If the person says, I sincerely believe I am a woman, I am in fact a woman. Is that person not a woman?
I would respect their self-identity in addressing the person, but in terms of the statute, I think the question is, does that person have a sex-based biological advantage that's going to make it unfair for that person to be part of the women's team? And that's the rationale for the regulation, and so that's the way we would be testing that hypothetical.
Well, the reason I'm asking has to do with discrimination on the basis of transgender status. So what you seem to be saying is, yes, it is permissible for the school to discriminate on the basis of transgender status, because if this person is a trans woman, a trans girl, and is barred from the team, from the girls' team, then that person is being subjected to differential treatment based on transgender status, right?
Well, then the question would be whether it was, the scrutiny would be satisfied. So from our perspective, that would be a transgender classification. It would get heightened scrutiny, and it may be satisfied here because of the need to have, to curtail unfair athletic advantage. That would be the analysis. We are not pressing in this case the notion, and the case does not require the court to decide whether transgender women who've gone through puberty and have not suppressed their testosterone would be able to play on a men's team. And the record here is a preliminary one where that doesn't present that question for the court.
When this does present a particular factual situation, and we have to decide that case, but looking to the broader issue that a lot of people are interested in, there are an awful lot of female athletes who are strongly opposed to participation by trans athletes in competitions with them. What do you say about them? Are they bigots? Are they deluded in thinking that they are subjected to unfair competition?
No, Your Honor, I would never call anyone that. And I think what we're saying here is that you have to, that's the reason why there is intermediate scrutiny, or even in rational review, you don't legislate based on undifferentiated fears. You base on trying to make a rational response to what is a perceived issue. I think here, although I would take issue with the notion that there was no reference to transgender individuals in the creation of this law, I really would direct the court to JA. Again, this is not about animus. I'm just saying that if you look at JA, pardon me, I need my JA 105 through 112, there are numerous references from the sponsor of the law saying the way we're going to try to protect women's sports is to not have transgender women play on the women's teams, and that was the fear that they had at the time. Again, that is not an accusation of animus. It's just a question of what was the statute doing, and then we go to the point of, does the statute survive heightened scrutiny? That would be the inquiry.
Do you think that the success of trans athletes in women's sports is proportional to the percentage of trans athletes who participate in women's sports?
I think I would direct your attention to, there's I want to make sure I have the right amicus. There's an amicus brief that talks about actually some of there are examples, obviously, of some transgender people that have participated and excelled. They actually are few and far between. You know, we have our client here who tried to make the NCAA team because of the injunction. She was too slow. She played club soccer, club running. She was even an officer in one of those clubs, just doing what you would hope a college student would do. You'll hear from my colleague about the other case. But I do think that, and there's a brief that in the amicus briefs that will share the examples of showing that's a bit overstated.
Would the analysis be different if they were more successful?
No, I think it would be, to the extent, I mean, we've already covered that transgender people are a meaningful slice of the population, but a small slice. I think the state, if there were a concern of women's sports being fully overrun by an outbreak of a huge new number of transgender people, that might be a different factual situation. In the end of the day, and we understand, that there were legislators who were concerned about that. The legislative history makes that clear here. But that wasn't the factual basis before the court. If there were actually a threat to women's participation in women's sports, that could be a different analysis, because obviously the goal of sex equality in sports is a very important goal. We don't take issue with that. We just would say that I think this is an important moment to just take a step back and say, is this law actually responding to a problem in a rational manner, or is it actually overreacting on the presumption that transgender women are categorically going to be strong athletes when that's not the case?
Well, just to put the big picture, and you know this, on the table, and let you respond to it, but obviously one of the great successes in America over the last 50 years has been the growth of women and girls sports, and it's inspiring. And there's some states in the federal government and the NCAA and the Olympic Committee, so these are a variety of groups who study this issue, think that allowing transgender women and girls to participate will undermine or reverse that amazing success and will create unfairness, because you said if large numbers, well, for the individual girl who does not make the team or doesn't get on the stand for the medal or doesn't make all league, there's a harm there. And I think we can't sweep that aside. And I think that's what's undergirding some of the concern in this big picture, and there are harms on both sides. So I completely understand that, but I just want to let you respond to that, because that is, the NCAA, the Olympic Committee, a lot of states, federal government, that's a lot of people who are concerned about women's sports and think this raises a big problem, and I just want to make sure you can explain that.
Thank you, Your Honor. And just to be clear, Title IX is a huge triumph, and I'm a veteran of women's sports myself. So I'm glad it exists. It's made a huge difference in our society. That's not what we're talking about here. But I do think, to the point of, for the podium question, I think the question is there an unfair biological advantage? That would be the question. So I understand the point. If there is somebody who's coming in with an unfair biological advantage, that would undermine the entire point of separate sports in the first place, which was to allow women to have a place to thrive, to be strong, to win, not to just be the B team. The question in this case is if the person had actually mitigated their sex-based advantage, which maybe interestingly, maybe counterintuitively, actually is more about circulating testosterone after puberty than a lot of the other things we might think are sex-related, then that girl that's come in second to a transgender person that's mitigated actually may just have come in second because the transgender person was similarly situated but was stronger in that one competition. That's why we are here not proposing a rule of absolute inclusion, but saying that in the case with people like our client who have mitigated, their exclusion doesn't match the statutory interest.
Counsel, can I ask you a question about analytically in the discrimination on the basis of transgender status? Since trans boys can play on boys' teams, how would we say that this discriminates on the basis of transgender status when its effect really only runs towards trans girls and not trans boys?
We understand the point, and I think that might be relevant to for example, animus point, right? There were not a complete exclusion of transgender people, there was an exclusion of transgender women. But I think on that piece, this court has never required the whole class to actually be excluded to look at the cases to whether the exclusion of a subclass was...
I'm talking about for triggering intermediate scrutiny if transgender status is a suspect class.
Right, so like Craig B. Bourne, for example, that's the one about the men that couldn't get the 18 to 20-year-olds. Right, that wasn't all men, it was a subset of men, and yet the court still viewed that as a sex classification subject to heightened scrutiny. And likewise here, even though it's just transgender women, in our view, that are being barred and not transgender men, that also would trigger heightened scrutiny. And I think there's the Rice v. Cayetano case from 2000. There's other examples of the court making clear that just because a subset of the protected class is being excluded, you still would apply heightened scrutiny.
Another question about the science. So you were talking about circulating testosterone being kind of the marker. Idaho is saying, well, that's not the only indication. There are other, when I asked the question about 6-year-old teams before that there are other just kind of genetic hardwired differences, maybe in size, et cetera, that don't have to do with circulating testosterone. Is it your understanding that testosterone is it?
So, and my colleague who will present the argument in the next case, is that the record there was more about prepubertal and puberty. Right. I think that the 5% even is not clear whether that's just environmental or biological, actually.
Right.
But I do think, so there are other things that I think, like height, bone size, there have been some other discussions of this. This is an underdeveloped record, by the way. This needs to go back and have a full trial, except that it's moot. But I think the point there is that, no, I'm not trying to make a point on that. I'm not trying to pretend that I'm going to have a trial when we're not. Yeah. But I think the point is that sometimes counterintuitively, it's like having a larger frame, but not having the muscle and the testosterone to drive it could actually put the person in a worse position. And that's a study that was commissioned by the Olympic Committee. It's footnote 6 of our brief, indicates that actually it could be put the transgender woman at a disadvantage if they happen to have larger bones and less testosterone or muscle to drive those bones.
Last question. So below, as I understand it, your client challenged the verification procedures.
Yes.
Except when we were talking about how this might be administered, I understood you to say that it would be by checking testosterone levels, because it would be okay to say, to Justice Alito's hypothetical about the cisgender male who has taken no steps and who is now trans, to exclude that person. But would that be an invasion? Would that be a violation itself, or too invasive to require someone to, and maybe not just once, but maybe to periodic testing to make sure that the circulating testosterone was low enough? Why wouldn't that be invasive?
So that's an ordinary blood work that a transgender person would get, and that's why I think it's of the nature of the minimal burdens, like in Nguyen and the other cases where the court has said intermediate scrutiny applies, and you actually can, if there's minimal things you have to do to make yourself fall in the category that we want to keep protected, we can require that of you. But
didn't you challenge it?
Well, that was different, actually, because the 3 things that you'd have to prove under the state's novel verification thing would have to be your genetic, your reproductive anatomy, which would require actually like a pelvic examination or examination of someone's, nude area. It would be chromosomes, which would require chromosomal testing. That's not what we're talking about. Or it would be endogenous testosterone. And the reason why that wasn't a problem is not because of a blood test. It's not invasive. It's because it would have required the transgender person to stop their hormone treatment to get back to an endogenous level to be able to show they're endogenous.
Okay, so the distinction between circulating and endogenous.
Right, the point was that was actually in a way, like, and I'm not trying to cast aspersions, but a kind of a false requirement for transgender people because they aren't on their endogenous testosterone when they're on hormone therapy. They're on a non-endogenous medical treatment.
Thank you, counsel. Justice Thomas? Justice Alito? Sotomayor?
I'd like you to address mootness because you raised it with Justice Barrett. Is this case moot? Could you respond to the other side's positions or arguments as to why it wasn't? And how do you respond to that? Secondly, Justice Barrett did raise earlier, this law applies even to primary primary schools, correct?
Taking your second question first, yes. I don't think it's in the record whether or not there are any primary schools, whether they sex separate or not, but that is the law.
And so, at least as to that subgroup, no one could doubt that primary school children might have the strongest argument that there's no difference in their physical makeup that would cause harm or otherwise create an advantage, correct?
That would be our position, Your Honor. In this case, we had both our client who was at college at the time, and then we had a high school intervener who was worried about being subject to the sex verification, so we didn't really get into the building a record on the
But the point is that the law might be overbroad in many ways.
Certainly, yep.
And there's still, as you noted, Idaho is the first or the second state to pass this law?
It was the first. I mean, these cases come to you because they're early
and
ones.
the record here was the most underdeveloped, correct?
Including because it was a preliminary injunction. There was a substantial amount of expert material in the record that allowed the district court to make appropriate findings, but it was not the level that you build up for a trial.
And both courts said that the record had to be looked at more carefully.
Expressly, they did.
All right, so answer the mootness question.
I mean, Your Honor, all I can say is that we've tried to provide the court with accurate information as soon as it came to pass. In 2024, when we opposed certiorari, our client still was active and intending to play sports. The court granted the case. She was preparing for what she hopes is her final year of college. She was concerned about the increasing hostility and the visibility. I mean, we're here now, and that's okay. She understands she brought the case. But that was the basis for her trying to end her sports career. And it isn't contrary to what she said before. She did intend to play sports through college. Her college has taken a long time. She's now sworn she will never play sports that are covered again, and she won't do that even if she happens to somehow win this case. So that is just the truth. But whether the court believes it's moot, that's, we put the facts before you for you to decide.
How about her graduating this year? There was a suggestion she might not.
As you can tell, we have, college students have so she is trying her best to get through college. I think at this point, and I'm just basing on what I know of as to today, she's unlikely to graduate by May, as my friend said, but is hoping to make through summer credits, could graduate in the fall.
Finally, in terms of the sports teams, the Olympic team, that all happened in 2025 after our president directed them to.
We do think that's worth parsing out. Again, there's been a lot of contentions made on both sides that are extra record, but I do think a lot of those things flowed from the executive order. There were some other sports orgs that were doing different things, but I think we have to be careful not to broad brush that because some of it may have been political, some of it may have been scientific, and the record really isn't fully before the court.
Justice Kagan?
Ms. Hartnett, I just want to get your understanding of what constitutional review would look like in this context. So you said it's not individual by individual. You have to come in and say there's a class that's not being treated appropriately. What is that class here?
Thank you, Your Honor. And I would say I don't think the court has ruled out the individual case. I just think we weren't presenting it that way because we were trying to align ourselves with how the court had looked at it. I think we would say we represent the group of people that do not have an athletic advantage, that have mitigated their their biological advantage of being born male.
So who do not have an athletic advantage for reasons of taking certain medications or hormones or
no sex-based biological advantage. So it would encompass both people that had gone through the male puberty and had mitigated. It would also encompass others that have not yet gone through puberty or that staved off puberty with the puberty blockers.
And as to those people, who has the burden of showing that the justification doesn't fit?
I think I think once we've identified the subclass under intermediate scrutiny, it is the state's burden to show a substantial relationship for that group, and they failed to, and that's how those other cases proceed.
You wouldn't think that because we are talking about an as-applied challenge to a law that's facially everybody can see is legitimate, that the burden should shift to you?
I don't think that's how the cases looked at it when they were assessing. They were kind of assessing whether the state had provided enough to allow the exclusion. For example, in Lair, the state had made an adequate showing to show why the parent in that case was properly excluded.
And how do you think the question of scientific uncertainty should play out in an analysis like this?
Thank you. That's a good question, and I know this was something the court did address in Scrimeti, a rational review case, but citing Carhart, which also talked about that. I think the one thing we definitely want to have is complete findings, so that's why we really were urging to have a full record developed before there were any final judgment of scientific uncertainty. I think the court has not fully grappled with what does scientific uncertainty mean and how does it come into conflict with heightened equal protection scrutiny, but I think we don't need to present that yet because on this record, there was not uncertainty. This person had mitigated testosterone was the determinant. Maybe on a later record that would come out differently, but I don't think that.
Just play it out a little bit if there were scientific uncertainty.
I mean, if it really were an equipoise, then I think that that is a situation where I think it's still heightened scrutiny. So under a heightened equal protection scrutiny, the burden is on the state to justify the law, and if they haven't been able to justify that, that usually fails. If it's really a question of they're at 50-50, do we allow the state some leeway? I don't think that's been answered in the court's cases. Normally, the heightened scrutiny controls, and there's not a deference on top of that in the equal protection context.
Thank you.
Justice Gorsuch.
Just to follow up on that, I wonder if that starts to sound like strict scrutiny, because the point of intermediate scrutiny, of course, is some leeway for the state, not a perfect fit, at least in the facial area. But if there's scientific uncertainty about whether puberty blockers and testosterone suppressants completely or mostly or some percentage of the time eliminate all competitive advantage, some competitive advantage. I mean, you've been very careful, I think, and rightly so, to talk about mitigating advantage. But I don't know, does the state have to show that it eliminates advantage and it doesn't eliminate, some percentage of advantage remains in each individual case, or for the group as a whole? I'm struggling to understand your response to Justice Kagan on that score. Maybe I'm inartfully posing the question, but I hope you understand.
I do understand your question. I think the question is at some level, I think the question is where you have science that's developing in real time at some level, what happens, how does that dovetail with trying a state that's trying to regulate and do that? I think what we can say on this record is the categorical exclusion is really not supported, I don't think, by any science. This again was from kindergarten through college. And so there'd be some subgroups at least. And I think there has to be an effort to try to tailor it. I think here the problem was there was a reaction of transgender women, a picture of what that would be, kind of an undifferentiated fear, frankly, from the Cleburne case. And so I think
I appreciate all of that, but it seems to me from my glance at the record, and quite a record it is, that there is a healthy scientific dispute about the efficacy of some of these treatments, and that's understandable. And I'm just wondering, how does that fit with, assume there is some dispute, and I understand the record remains to be developed further, but how does that fit with intermediate versus strict scrutiny?
At the end of the day, it's the state's burden to show a substantial relationship, and I think in the case of something where they're doing their best and have the best evidence some evidence to support what they're doing.
Some evidence, the best evidence, exactly. I mean, that's
a level of evidence that wasn't met here. So the study and the findings. I mean, the district court made a really good point. That study had actually been retracted, and it didn't pertain to transgender athletes. So in a way, this is not the hardest case. I appreciate it as a hypothetical. I guess what I would just urge in this area that's sensitive, obviously politically, but also as a matter of science, to at least let a record develop in one of these cases that lets you decide, actually, is this
I totally agree with that.
50-50 versus 80-20?
All right, but 50-50, does the government win? Does 70-20 the government win? That's what I'm getting at. I understand the complexity of the record and the difficulty of the science, but if we're going to have individual cases brought, that's the kind of question we're going to ultimately have to answer, not the science question, but the percentage question, if you will.
No, I understand that. I mean, VMI does provide some sort of a metric of what we would do there, which was we looked to see there were kind of evidentiary debates on both sides of that. But even if you could say that a lot of women may not have ever made the cut, the fact that there were some that did was enough to invalidate the entire policy. So I think there are ways for courts to make those judgments, and I think the court has not yet, I think, encountered a case where heightened scrutiny puts a heavy burden on the state. It's not an insurmountable one, like strict scrutiny normally is. And then what happens if it ends up with the evidence being a tie or close to it when we go back to the trial court? I think that would be that would be breaking some new ground, because I don't think there's an equal protection case that decides that issue. Usually the evidence is kind of clear on one side or the other about whether the restriction is justified.
That would remain for us to decide at a later point.
I do think that's the most prudent, but definitely on a record that's more developed, because I think I think in the end of the day, it might end up being a surprise to, we don't know yet, but I think we have some good evidence that actually at the end of the day, being transgender woman, actually to the extent there are, and you've repressed your testosterone, you're at somewhat of a disadvantage in many ways because you have, again, this larger frame with weaker muscles and no testosterone.
Thank you. Justice Kavanaugh?
Just to follow up on Justice Gorsuch's question, a broader frame about the role of this court when there's scientific uncertainty. I mean, there'll be different district courts who do different things, almost certainly in different cases, and in an area of scientific uncertainty where there's strong assertions of equality interests on both sides. And so it's going to come to this court, and we have to decide for the whole country, constitutionalize this. And I guess given that half the states are allowing it, allowing transgender girls and women to participate, about half are not, why would we, at this point, just the role of this court, jump in and try to constitutionalize a rule for the whole country while there's still, as you say, uncertainty and debate, while there's still strong interest on the other side? And I think one of the themes of your argument's been the more people learn, the more they'll agree with you. At least I've detected that theme in your argument. So why would we get involved at this point and constitutionalize?
I understand the question, Your Honor, and I do think that the Equal Protection Clause's demands have never been viewed as kind of a separate avenue from the legislative process. They can and do often coexist. And here, I think the point is we have two as-applied challenges to early laws. They have their unique cases in their own right. I don't think this court needs to set rules forever on this area. I think the most important thing would be to allow a record to develop, even in areas of controversy. And we look back at what you cited in Scrimeti, you cited Carhart. There were extensive findings. There also were findings in VMI. There were findings in Craig v. Boren. I'm learning things by reading these cases over again. There were findings in those cases. And so I think that at least before the court decides to either step back fully or to embrace its role here of providing the scrutiny that should be attended to groups when there's a worry that the democratic process isn't actually going to fairly respond to their concerns, I think the point, at least at a minimum, would be get a full record, which we don't have here. That would be my request.
Thank you.
Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal?
Thank you, Mr. Chief Justice. A few points. I heard just a moment ago that there is no real threat to women's sports. We strenuously disagree. We cite Your Honors to the UN Special Rapporteur's report that says 600 women have lost 890 medals in 29 different sports. That's what we're talking about. It is a real threat. Medical transition does not reliably suppress all male athletic advantages. I'd cite Your Honors to our record in which our expert, Dr. Brown, shows the experience of one C.C. Telfer, an elite track athlete who underwent a medical transition and whose track times did not change. That is the story in many situations, and unless we can reliably distinguish between those situations and the situations in which testosterone suppression does reliably eliminate the advantage, then we can't do that. We need a broader classification, and sex is the right one. And if it were merely politically motivated, I would add we wouldn't see this same rule being implemented by World Athletics, World Boxing, the NAIA, these different groups that were not influenced by recent politics but came to these decisions after studies, after lengthy examination, and reached the same decision that Idaho has. Justice Gorsuch, in your colloquy with Respondents' counsel, she agreed with us that this is not the same as the discrimination that has been faced on the basis of race or on the basis of sex in this country. We agree it's not close to the discrimination that people have faced on the basis of race or sex in this country. That said, the court does not need to reach that answer here, because if there is no transgender status classification in Scrimeti, there certainly cannot be one in this case. In fact, as our briefs argue, the court can and should avoid all of these questions by applying rational basis review. Bottom line, sports are assigned by sex because sex is what matters in sports. It is the fairest and the safest and the most administrable way to assign sports teams. It's been widely accepted for many decades because it's necessary for fair competition, because where sports are concerned, men and women are obviously not the same. If Idaho can't enforce a sex-based line here in sports where nobody disputes that biological differences matter, then no line based on biological sex can survive constitutional scrutiny. The court should uphold the Fairness in Women's Sports Act and reverse.
Thank you, counsel. The case is submitted.
Ladies and gentlemen, you are staying for the second case. Please remain in your seat.
Argument next in case 2443, West Virginia versus BPJ. Mr. Williams?
Mr. Chief Justice, and may it please the court. States have long assigned students to sports teams by sex. West Virginia is no different. Maintaining separate boys and girls sports teams ensures that girls can safely and fairly compete in school sports. The question today is whether this enduring structure can continue. It can. Title IX permits sex-separated teams. It does so because biological sex matters in athletics in ways both obvious and undeniable. The text, history, context, and structure of the statute, alongside regulations expressly authorizing what West Virginia has done, confirm as much. Respondent says that West Virginia schools can no longer designate teams by looking to biological sex. Instead, schools must place students on sports teams based on their self-identified gender. But that idea turns Title IX, a law Congress passed to protect educational opportunities for girls, into a law that actually denies those opportunities for girls. The court should not embrace that backwards logic. Aside from its problems with Title IX, the decision below constitutionalizes one side's view of a hotly disputed issue. But West Virginia's law does not offend the Equal Protection Clause either. The West Virginia legislature reasonably and rationally defines sex based on biology and acknowledged the physical differences that biology creates. Given those differences, the law satisfies rational basis review. And the state's law satisfies even intermediate scrutiny because it is substantially related to the important governmental interest in ensuring fairness and safety in girls' sports. Respondent attacks the law by searching for a transgender classification that simply isn't there. The law is indifferent to gender identity because sports are indifferent to gender identity. Ultimately, West Virginia's law, like the laws of at least 26 other states, simply preserves the enduring structure on which girls' sports depends. It should be upheld. I welcome the court's questions.
What's your view of what Title IX, how it defined the separated sexes, male and female?
So under Title IX, Your Honor, we would look to the ordinary understanding of sex at the time that Title IX was passed, 1972, and I think also relevant would be 1974 when the Javits Amendment was passed. And at that time, the ordinary understanding of sex was biological sex, consistent with the understanding of sex reflected in West Virginia's statute. I think that's also consistent, frankly, with this court's own understanding of sex and some of its own cases like Frontiera, where it likewise focused on things like reproductive function.
Well, with that definition, how would you square this challenge with the continued existence of Title IX?
So I think this challenge fails under Title IX, and in fact, it amounts to a backdoor attack on Title IX, in the sense that Title IX itself contemplates sex distinctions, and express regulations specifically applying to the context of athletics expressly contemplate the distinctions between sex of male and female sports teams.
In interpreting this definition, would it make a difference, or does it make a difference that this is a spending clause statute?
I think it absolutely does, Your Honor. Obviously, in the spending clause context, as this court has somewhat recently reminded lower courts, it's important for Congress to speak with an even clearer voice because of the contractual nature of the conditions that are imposed. States like West Virginia have to understand exactly the obligations that they're assuming in the context of a spending clause analysis. And so it amounts to effectively a canon of construction that requires that clearer statement in order for the condition to attach.
I would have thought that's an interesting argument, that this is spending clause legislation in Title IX, and Congress has to speak with a particularly clear voice, and whatever it's said here isn't clear enough. You didn't raise that argument. And there's an argument from your friend on the other side that you waived the argument, or forfeited it at least.
Right.
And it sure isn't the lead argument in your brief. Help me out. Why?
So we, of course, start with the plain text of the statute, Your Honor, as this court has told us to do several times.
Yeah, well, I might start with the constitutional authority under which that statute was adopted, counsel.
I think that's equally compelling authority for our understanding of the
equally compelling, the Constitution equal?
Perhaps greater compelling authority.
I would have thought, yeah.
West Virginia, as you know,
why isn't it in your brief?
West Virginia is maybe uniquely a fan of clear statement rules, as Your Honor might know from past cases. But in the spending clause context, I think it is, in fact, the case that your court has repeatedly stressed that Congress has to speak with that exception.
I know what we've said. I'm wondering about what you didn't say.
So I think if you're looking at the way that West Virginia has characterized it, certainly we have made that argument and presented that argument to this court. I'd refer you to the topside brief. It's clear and centered under a clear heading. As I think what their suggestion is from the other side is that we didn't clearly enough raise that argument below. We would take issue with that characterization. There was obviously binding contrary authority in the Fourth Circuit. And so I think strategically we decided not to make that the front and center argument because we understood that was dead on arrival in that particular court. But that's not to say that we waived the issue by any means. It's a canon of construction that continues to assist this court in its application of the text of the statute.
But, counsel, can I just ask you about this, though? Have we ever applied the spending clause's notice requirement outside of the damages context? Because here we're not talking about a situation in which BPG is seeking damages, and I thought that was sort of a crux of the spending clause analysis.
I will concede, Your Honor, that many of the cases that talk about this rise in the context of, or maybe even all of the cases that rise in the context. I'll concede as much, yes, Your Honor. But I don't think the court has ever suggested that the specific request for damages is the reason for its analysis. And I think that actually would be inconsistent.
But we would be having to address that, I guess, and extend it in this context if we were to take a spending clause tack.
I would respectfully disagree, Your Honor. I would say that just because the court hasn't done so before doesn't mean it's an extension per se. I think that what the court has said is that you view the language of these statutes as effectively contractual agreements. And I think that that same sort of contractual logic applies whether you're asking the state to pay out damages or whether you're asking it to take specific action under compulsion of that.
So who is the contract between here? And I thought the regulated party needs to know what it's agreeing to so it can consent. But here the regulated party is the schools, and it's the state that's coming in. So I'm just trying to understand how the spending clause analysis works in this context.
So I think the state is certainly one party that does receive federal educational funds, but it's also the many other petitioners that stand before you, including the county school board and the state school board, are also petitioners in this case. I think there would certainly be if anybody, we're clearly bound by the conditions of Title IX.
So it would map on. I mean, I guess I'm worried that this
Right.
might actually implicate the question that we didn't resolve in Moyle, and so we'd have to kind of figure that out because it seems like it's a different set of facts than the typical spending clause application.
I think, if anything, Your Honor, this is maybe easier than your typical spending clause analysis because you've got everybody from the state all the way down to the local county school board. Anybody and everybody who's involved in this case is a party to this action. In fact, you resolved a petition for cert from the Athletics Commission saying we're not actually a state actor, and the Fourth Circuit saw things quite differently. So I think there's really no concern in this case that you have an absent actor problem when it comes to the spending clause analysis. And ultimately, of course, if it's just a canon of construction, if you're looking for a clear statement, then I think it would apply regardless of the particular party who might be in front of you because the statute applies across the board. You know, the regulated party is going to be affected regardless of whether they happen to be in front of you in the given case.
Can I ask you
I'm sorry. I presume that if it's statutory construction, a canon of statutory construction, it's hard to say you can waive that?
It's very hard to say you can waive that, Your Honor. Yes.
I just wanted to ask if, on your understanding of Title IX, you could have separated by sex classrooms in biology or math based on some evidence that you have that say men are better at math and science. What are the limits to your Title IX theory?
So I think your instinct there in part arises from the fact that we're skeptical of any notion that there are inherent differences. So I want to kind of acknowledge the real reality of this.
Well, your whole position in this case depends on there being inherent differences, right?
It does, and I think that that's exactly why discrimination in the Title IX context, where it acknowledges merely inherent biological differences, that's not discrimination, that's a distinction. And I think that's consistent with this court's longstanding understanding of what discrimination means. It looks to differential treatment of similarly situated individuals. So even in a case like North Haven, you're talking about differential treatment of similarly situated individuals. So if we're talking about in an athletic context, you're not addressing similarly situated individuals. And I think, again, the Javits Amendment and the regulations that flowed from the Javits Amendment are a realistic reflection of those meaningful biological differences.
The Javits Amendment gives you a reason in the sports context maybe to do it. I'm just wondering whether, your friends on the other side have basically conceded that Title IX allows sex-separated sports teams. So I don't know that we need to really get into that. I'd be a little bit concerned about what the ramifications of that might be. And the Javits Amendment, in the context of sports, makes a difference anyway. But more broadly, I mean, if a state produced some studies saying, listen, women's presence in, calculus is holding men back because they're so much more capable and they can just move so much more quickly, seems to me like there'd be some risk on your understanding that that would be okay.
I think, again, realistically, Your Honor, that would almost certainly fail on the lack
How about chess club?
A chess distinction, I think, again, might fail because there's an actual lack of evidence of meaningful physiological differences that are reflected in the existence of the express regulations in the athletics context.
I mean, I think a lot of people would say, if you look at the ranks of chess grandmasters, there are not a whole lot of women there. And, what does that mean? Well,
I think,
I think that there's a sort of intuitive. I think there are a lot of chess grandmasters who would tell you that women just for whatever reason, they're not as good as this.
I think chess is an interestingly closer question. I've come to understand just recently, in fact, that there are sex distinctions in the elite.
You're fighting the hypothetical, and I guess the question really is, okay, Title IX says you can't discriminate on the basis of sex.
Yeah, sure.
I understand what that means. I think I do, right? Can't treat men and women differently. Okay, all right, fine. You're saying, but it matters whether they're similarly situated, and your friends in the government like that line too. Well, I got a lot of evidence that girls perform a lot better in high school than boys. Okay, there's a lot of scientific evidence, whatever, or let's just posit that, all right? Well, so I'm going to have a special remedial program for boys, and the women can't come. And because they're not similarly situated. Why on earth would Title IX care about that? It says you can't discriminate on the basis of sex in a program or activity of your educational institution.
So I think...
Why put that gloss on it?
And, Your Honor, I want to be clear. I think the task for the court today is somewhat easier in part because of the express regulations that they have actually not challenged and that do expressly contemplate exactly what West Virginia has done. So I think... Your hypothetical, yes, of course, is there, but I think the reality is that Congress and the agency have together kind of addressed this specific question in a way that makes this court's task much easier. But I think the problem may be with
maybe another answer, we don't need to rely on this similarly situated argument. Is that what you're trying to tell me, counsel?
I think you could also take that approach, yes, Your Honor. And I think the reality is that that hypothetical addresses a situation that's much closer to the sort of exclusion and the specific context that gave rise to Title IX in the first place. And so I think that the court would be much more legitimately concerned that that would detect the very problem that Congress is trying to head off in passing Title IX in the first place. But I think that really kind of puts the lie to the position that West Virginia is somehow discriminating because it's advancing the very same purpose that Congress itself was trying to advance in enacting Title IX in the first place. I mean, that's why West Virginia somewhat deliberately made its law mirror the exact same language from the express regulations themselves.
I'm afraid I've got one more question. Oh, I'm sorry. Please go ahead. No, you're.
I can do both.
No, you can't do both. That's not fair. That's not fair. I mean, even by our standards. You make the argument that on the basis of means solely because of. Solely. We have long said that because of means but for, not solely because of. The Rehab Act speaks of solely because of. It seems to me an awful big stretch, counsel, to say that on the basis of imports anything other than but for causation. And, you know, Comcast is against you there. And I just wonder why you put your eggs in that basket.
So 3 answers, Your Honor.
And by the way, isn't the distinction here solely because of sex anyway?
Well, let me take each of those in turn, or I'll try. I don't think that the case turns on the court accepting the idea that it's solely on the basis of sex. So I think you could stop.
That's a sufficient answer right there.
Fair enough.
Thank you. Your turn.
Thank you.
Can you explain the relevance and significance of the Javits Amendment to distinguishing sports from all these other hypotheticals?
So I think the relevance and significance is Your Honors are faced with a unique set of regulations in that Congress was directly and intimately involved in both the instigation of the regulation in 1974 and then sort of—
And in that law referred to the nature of particular sports, right?
It did. So what they said was, we want you, the agency, Hugh, to go ahead and implement Title IX writ large. And it called out one specific problem that I think arose on the floor about whether Title IX applies to intercollegiate athletics, in particular intercollegiate athletics. And I would say—
And that's been extended to high school by the regulations.
Exactly.
But ruling for you on sports does not open the door, in my view, given the Javits Amendment, to the chess club necessarily. That could be separately analyzed, but it doesn't follow from a law that says sports.
That's exactly right, and that's exactly why we were trying to make your job easier in the sense that we took the language expressly from the regulations and mapped it over under our own statute. So there's really no debate. If it's outside the context of Title IX, it's outside the context of our statute. So at that point, the court's analysis is done. But I think when you have a regulatory scheme where Congress was specifically involved, in fact, undertook a review, then that's exactly the sort of regulation that even in a post-Loper-Bright world continues to have importance because it's longstanding, continuous, contemporaneously issued, all those sorts of check boxes that this court, under a Skidmore framework, continues to place substantial weight on. So I think that makes the court's task relatively straightforward.
And what about Bostock?
No.
You want to deal with Bostock?
I think— So I guess it depends on the way in which you mean it. Does it deal in Bostock?
If an employer said we're going to fire all the transgender women, that'd be a violation. If a school says we're not going to allow the transgender women to play sports, you say that's not a violation. Both statutes use the term sex. Can you explain?
I think the reason why is, well, to be clear, our statute is very different from a specific choice to say a transgender person shall not participate because of their transgender status. And I think that really is what makes the difference between this case and Bostock, is Bostock is attacking status-based discrimination, and West Virginia would, I think, be in a much different position if we had just said transgender persons shall not compete. But that's not what West Virginia—
What if it said transgender women and girls shall not compete in women's and girls' sports?
I think, again, that's a much closer question. I think if we're talking about engaging with the actual status—
You think you could lose under Title IX with a statute that said that?
I think Bostock, I think, is, now I understand Your Honor's question. I think Bostock raises an interesting question as to whether that reference to transgender status would in turn implicate the sex status that Title IX is meant to address. But ultimately, I think the court doesn't need to address that because you can stop at the first step, right? You don't have an actual transgender exclusion that would give rise to that kind of linkage of analysis.
Thank you, counsel. In terms of Bostock, I understand that to say that discrimination on the basis of transgender status is discrimination on the basis of sex. But the question here is whether or not a sex-based classification is necessarily a transgender classification. And I wonder if that is consistent with your understanding.
It's entirely consistent. I would say on the equal protection side in particular, and also in the Title IX context, I think for some of the reasons I just discussed with Justice Kavanaugh, I think the court can stop and say that a sex definition and a reference to biological sex is not the same as a transgender classification. And I think even if we engage in the sort of but-for causation analysis, I think it's as simple as saying, does the result change if you change the gender identity of the individual involved? And the reality is, if you apply the West Virginia statute to someone identifying as a biological boy identifying as a boy, applies in the very same way as a biological boy identifying as a girl.
Justice Thomas? Justice Alito? Justice Sotomayor?
I find it strange that the district court and the court below did find a Title IX violation, but not an equal protection violation, and remanded for the equal protection violation. I'm not sure how it could do that, because it would seem to me that if the evidence is not sufficient to justify finding an equal protection violation, it's not sufficient to find a Title IX violation. Is that correct? At least on the record as it exists now.
Right, and so to be clear, the district court actually ruled for West Virginia on both Title IX and so the Fourth Circuit said, you lose on Title IX and we're not sure about equal protection.
But assume the Fourth Circuit is right.
Right. Well, so in answer to your question, I think that doesn't make sense. And I think the reason why it doesn't make sense is because the Fourth Circuit effectively stripped out what they said is Title IX doesn't leave room for any kind of justification or any kind of analysis of what the reasons might have been for the state's action. And I think respectfully, particularly when you look at the regulations themselves, that actually does contemplate exactly that sort of analysis.
I agree with you on the regulations.
Right.
And so could you not have a Title IX violation but still have, let's assume, and I know you're going to fight the factual premise.
I'll try to embrace it, Your Honor.
All right, embrace it. All the scientific evidence showed that there's no difference between cisgender girls and trans girls. I know there's a fight about it.
It hurts.
I know it hurts. But assume it. Could you not still have violated? Could we hold that as the regulation stands, the regulation would permit you to discriminate, but the equal protection clause would not?
So let me try to get my head in the framework of assuming. I think the regulation would still allow us, under its express terms,
I'm assuming
right.
Yes.
And so you're asking, even assuming our compliance with the regulation, could we still have a potential equal protection problem?
Yes.
In that world, I think we would still be fine under the equal protection analysis, frankly, for some of the reasons that you heard from the solicitor earlier today, where it's because even if you assume the heightened level of scrutiny, let's assume that we're in an intermediate scrutiny world, it's still a reasonable fit. It's not a perfect fit.
Then we're back to that.
Exactly. And
right.
I know we've had a long colloquy about that today, but ultimately I think that's what
I just destroyed that by saying that the science has said there's no difference. Well, and we know that's not true. But assuming the science said there was no difference,
right?
How could you ever say it's reasonable?
So I'm assuming a world in which there's no difference between. So you're saying testosterone suppressed individuals? Is that?
No,
or you're saying all men and women, full stop?
Right.
Oh, okay. Maybe I apologize for misunderstanding the hypo. If we're assuming a world in which there's really no biological difference, full stop, as to men and women, full stop, then I think, right, the legitimate governmental interest falls away. I agree with you.
Justice Kagan? Disagree? Justice Kavanaugh?
There are, as we've discussed, a bunch of states that allow biological males who identify as female, transgender women and girls to play women and girls sports. We were talking about that with the Solicitor General earlier. On your theory of Title IX,
right,
are those states violating Title IX rights of the biological females?
I think it's a much closer question under Title IX than it is under equal protection. And I think the reason being is that the regulations specifically say there's
what do you think the answer is under equal protection? I might as well ask that.
So under equal protection, I think we agree with our friends in Idaho that there's enough room for California to make a different determination.
Okay.
I think under Title IX, the reason why it's a closer question is because of the existence of the regs. And the regs start by saying you start with co-ed teams, and then you can move down to sex-separated teams in the context of contact and competitive skill. And it really contemplates a real, genuine sex distinction in that move down B provision.
Mm-hmm.
And then, of course, it pivots. It also has the catch-all where it says, but actually in the contact sports, you can't even, you can't move back in the co-ed world. So I think if a state is moving away from a genuine sex distinction as the regulator contemplated and as Congress ultimately contemplated, then maybe they're kind of, if you think of B as a safe harbor in a sense, they're outside the scope of that safe harbor, and now they're running into the problem in A. So I don't think the court needs to get into any of that.
Right, I agree. I'm just trying to know what's coming.
But I think that is, it's a closer question at least than the equal.
Because your theory is that sex is biological sex in Title IX, or is that not your theory?
No, that is, and it's not our theory, Your Honor. It's just it's the ordinary understanding of what sex meant, both in 72 and 74 when the regulations were themselves implemented. So I think we're just trying to be consistent with that.
Thank you.
Thank you.
Justice Barrett. Justice Jackson?
So I guess I'm trying to puzzle through whether or not there is some independent form of discrimination against transgender women that is distinct from the sex separation that Title IX allows. So I appreciate that your argument is that because the regulations permit sex separation and that hasn't been challenged, that should be the end of this inquiry. Basically. And I think you get there because you say you're sort of picking up on this idea that maybe this is just about a definition of who is a male or a woman. Is that right?
I think to some degree, but it's also, Your Honor,
degree.
It's just because we're indifferent to a person's gender identity in applying the law.
But the law actually operates differently, I think, for cisgender women and transgender women. That is, with respect to their desire to play on a team that matches their gender identity, cisgender women can do it, transgender women cannot. And so we do appreciate a distinction, I think, that is being drawn on the basis of your gender status, gender identity status, trans or cis, right?
So, and I want to make sure I understand
Yes.
if we're operating in Title IX world or equal protection world, because I think it might make a difference to the answer. But
okay, let's start with Title IX.
So Title IX, I think the question of, I look at this statute and see a distinction between boy and girl indifferent to gender identity. And I think that...
Right, but I'm testing that proposition, right? You see that distinction, and I see it too on the separation of teams level at the beginning.
Right, and I think what I'm hearing is that distinction arises from a difference in effect, and I don't see a disparate impact analysis that's sort of hidden away in Title IX.
But why is that a difference in effect? So it's like a second order discrimination, right? The first order is separating male from female.
Right.
The second order is separating transgender women from cisgender women, right?
Respectfully, I would disagree, Your Honor. The reason why is just because I think anytime you have a classification, you could divide it into subclassifications, and I don't think that then becomes, like, the law in the same way applies to brown-haired biological girls and blonde-headed biological girls.
No, I understand, but I don't think you can get...
Based on hair color.
I'm not sure, and maybe this is switching to the equal protection. I don't think you can get out of the implications of making a classification by setting it up as a definition, as a subclass. And so we've already okayed the classification because it's really all about classification. You can't distinguish in that way, right?
Well, I think what the court said on the equal protection side is you look at the facial classification, and I think here it's effectively unconceded that the facial classification is between boy and girl. And I think at that point, if maybe you have a situation where you think that the classification is somehow a proxy for some sort of secret secondary classification, but I don't.
No, but the definition implicates another division. So here's an example. So suppose that we have Title IX exempting, and I think it does this, certain religious institutions from its requirements. And let's say Title IX then went on to define, this is in my hypothetical, religious institutions to include only those institutions that proselytize. I mean, is that a classification problem or a definition problem? I would say it would be a classification problem, and you'd still have to apply all of the heightened scrutiny just because, they're defining religious institutions in a certain way. Similarly here, you have the overarching classification, everybody has to be play on the team that is the same as their sex at birth. But then you have a gender identity definition that is operating within that, meaning a distinction, meaning that for cisgender girls, they can play consistent with their gender identity. For transgender girls, they can't.
So I think that, okay. So as to the part about your ability to pass over from boy to girl,
yes,
you can go from one way but not the other. I want to be clear that BPJ is not challenging that specific classification. I think that's important to start with. But I think, if anything, that's useful evidence as to the lack of a transgender-based discrimination, because if the legislature were just sort of unsettled by the notion of transgender athletes, I think the answer would have been to then bar them from passing over in any way consistent with their gender.
I appreciate that. I guess I was getting at the what I understood the Chief Justice to be trying to discuss, which was this notion that this is really just about the definition of we accept that you can separate boys and girls, and we are now looking at the definition of a girl, and we're saying only people who were girl assigned at birth qualify.
And there is authority cited in our brief. This court, I don't think, has ever phrased it quite as in the way of this definitional framing that we're talking about right now, but certainly cases like Jana Rock in the Second Circuit do approach it from this sort of definitional framing, and they say that if you effectively concede that there's an initial ability to draw a classification, then that suffices to satisfy the intermediate scrutiny question. But then past that, the definitional question is evaluated through rational basis review, and that's Jana Rock. I recognize this court has never gone as far as that, but I don't think the court needs to go as far as that because, again, I think the way that you would do the analysis is to start by looking to the face of the statute, and if the face of the statute is engaged in a conceded boy-girl sex classification is conceded to be legitimate, then at that point, you kind of know which world you're operating in.
Thank you.
Thank you.
Thank you, counsel. Mr. Mooppan?
Mr. Chief Justice, and may it please the court. So there have been a lot of different arguments made this morning, and so I think it might be helpful to just focus on what I think are the easiest way to resolve both of the claims in this case. On the equal protection claim, it's the arguments we discussed this morning about intermediate scrutiny doesn't work on this as-applied basis. So let me focus for the Title IX claim. I think the simplest way to resolve the Title IX claim in this case is as follows. The regs expressly authorize sex-separated teams. The other side isn't challenging those regs. When those regs use the word sex, they obviously use the word sex to mean biological sex in the reproductive biology sense. That's the ordinary meaning of the term in 1972 and 1974. As a result, whether or not they are right that taking testosterone suppression eliminates any physical advantage doesn't matter because the regs define separation based on sex, based on biology, not based on circulating testosterone levels. So the difference that their claim that they've eliminated the difference just doesn't matter under the language of the regs, and that's enough to resolve the case.
So your argument, as I understand it, is that they're not similarly situated.
So that's an additional argument you could make is to say that even if you just focus on the language of the statute says discriminate on the basis of sex. Discrimination, as this court has repeatedly recognized, including in Bostick, means treating one person worse than someone who is similarly situated. And yes, we don't think a man taking performance-altering drugs is similarly situated to a woman, but you don't even have to reach that question because under the regs, the question is, the regs say you could separate based on sex. Everyone agrees that sex in those regs means biological sex. Therefore, the circulating testosterone levels are just legally irrelevant under the regs.
So why do you say you can separate the sexes? Why are you now taking the position in other cases that if states choose not to separate the sexes in the way you want, that they're violating Title IX?
Well, so again, we think that's a separate question and you should leave it separate. But the argument we're making in those cases is the statute and the regs allow separation based on sex because of the biological differences between men and women. If you purport to separate based on biological sex, but then you allow some biological males to play on the female team, you've undermined the justification for separating in the first place. Because normally you can't separate. If you take, for example, world history class, you can't have world history class for men and women. That's generally prohibited by the statute. The reason you could separate for sex for sports is the biological difference. And if you then undermine that, you've undermined the justification for separation.
So we're now back always to the science. Is there really a difference? And a difference for this kind of person? If it's not clear the way you want it to be in terms of separating the sexes, I'm wondering why it's clear for your attempt to force those states who are choosing not to do this. You're now saying you must.
Again, that question is not presented in this case, and for this case, the factual dispute is irrelevant.
Mr. Mooppan, do you think that the spending clause should inform our analysis here?
I don't think this court should invoke the spending clause in this case.
Why not?
For two reasons. One, we think that the statute and the regs clearly do not permit the claim.
I understand that.
And then the second is how the spending clause applies in the context of Title IX is, I think, a little more complicated than my friend suggested. It's not a clear statement requirement. I think if you look at some of these clear notice cases like Jackson and Geyser, I don't think you would say that those statutes had a clear statement.
It's a clear notice requirement.
Right, but how that applies is a little tricky, and I think in the case...
Why? I mean, your argument is that in 1974 and 1960, sex meant biology, and that there's not clear notice otherwise. Why isn't that the end of it?
Again, so I think the end of it is the statute clearly doesn't permit this claim. I'm just saying that I would be cautious about speaking about how the clear notice requirement applies because it is not a clear statement requirement.
I understand that. You're not answering my question with
how.
Respect.
So I guess
if it's a clear notice requirement at minimum and a voluntary agreement. And sex at the time of the statute meant, as Bostock said, there's a good argument it's biology. And why wouldn't West Virginia be within its rights to say we didn't have clear notice otherwise?
The scope of the clear notice requirement is a tricky question. If you look at this court's cases, I suspect...
What's tricky about that?
I suspect Your Honor would think a lot of the cases where this court has found Title IX to apply, you would think there's not clear notice.
All right.
And so I think it's a tricky issue, and I think it's a case that should be briefed, and I don't think it's an issue you need to solve in this case.
And then on the statute itself, it speaks of discrimination in program or activity, and in Davis we explained that requires kind of a look at the whole of the institution because the definition of program activity is the whole institution. And so that's less individual focused, it seems to me. Thoughts?
Well, I think that's true for the funding, but I don't think that's true in terms of how the discrimination provision works. If you discriminate or exclude in one part of the school, I don't think you could justify that by saying, well, all the rest of the school, we treat everyone fairly. I think those cases you're talking about, as long as you're receiving funding somewhere, the whole school's activities are covered.
Okay. And so it really boils down to the living accommodations provision, which Congress anticipated there would be sex-separated living accommodations being permissible, the Javits Amendment, and then the regulations that are long-standing and then therefore entitled to some serious consideration.
Well, no. So, Your Honor asked why we run the similarly situated argument. take, for example...
Don't bring that back up.
Well, locker rooms and showers aren't covered by any of the things you just identified. Not the living facilities provision, not the Javits Amendment. None of those things covered locker rooms and showers. So unless you use a similarly situated requirement, you would have to say that Title IX bans single-sex locker rooms and showers.
Okay, all right. If that's your view, then let's talk about the similarly situated. I guess I have to. What about the hypothetical I posed earlier that when it comes to high school performance, girls are sure a lot better than boys, and so we're only going to have remedial classes for boys and girls aren't free to attend?
So I don't think those differences are based on inherent biological differences.
Well, let's say I've got really good science. I mean, it's all about the science, right? I got the science. You're fighting the hypothetical.
I'm not fighting the hypothetical, Your Honor. I think what I would say, Your Honor, is that this court has held in cases like VMI that in general, classification based on sex is impermissible because in general, men and women are similarly situated. Where that's not true is for the sorts of real, enduring, obvious differences that this court talked about in cases like VMI, the differences in reproductive biology. I don't think the sort of pseudoscience you're suggesting has been baked.
Well, it's not pseudo. It's good science.
That's pseudoscience to say boys' brain development happens at a different stage than girls' does.
Well, with all respect, I don't think there's any science anywhere that has suggested that these sort of intellectual differences are traceable to biological differences, and I don't think the statute
with
should be read
respect,
to
I don't think you're a PhD in this stuff, and neither, I know I'm not, but I'm asking to deal with a hypothetical.
And so I guess what I would say about that, Your Honor, is...
I mean, the statute says no discrimination on the basis of sex. Right. And you're saying, it's okay when they're not similarly situated. And I'm giving you're worried about locker rooms. Right. Great. I appreciate that. But I'm worried about that math remedial class or the chess club or whatever.
Right. And so, look, let me put it this way. The general rule is you have to treat men and women the same. And
I would have thought that's what the statute says.
And I think you have to be very careful about recognizing an exception. And so when you recognize an exception for what's similarly situated, I think you should tether it to the sorts of long recognized differences that would have been recognized at the time the statute was enacted. At the time the statute was enacted, no one would have doubted that it said it didn't require...
I think at the time the statute was enacted, 1964, there are a lot of people who thought boys are better at certain things than girls at others that we don't believe anymore.
Not based on inherent biological differences.
I think that maybe in 1964 they did.
And if they did, they didn't have any basis for it. Whereas for...
And I'm giving you a hypothetical where I have the science to prove it. And you're saying it's still not good enough.
I guess if you're asking me a hypothetical where the science existed in 1972 and everyone agreed with it, then it might be a different inquiry. That really is a hypothetical because there wasn't...
Do we have to, I think these are very, very hard questions. I started with the math question before. But do we have to, because of the Javits Amendment, because the other side has conceded that Title IX permits sex-separated sports, can we avoid your whole similarly situated argument that you run? Because I don't really like it that much either.
Absolutely. That's why when I stood up here, the first thing I said was the easiest way out of this case on this claim is to say that the regs permit sex separation. They don't dispute
Save locker rooms and all that.
Right. The only reason I went into it is I was nervous that any sort of suggestion that there isn't a similarly situated requirement could lead to results that I don't think the court would actually stand up to, like locker rooms and showers. And so I think I have no problem if the court doesn't take a position on it one way.
Okay, and I'll say, I said I don't like the argument. At first blush, I don't like it. I'm not trying to prejudice anyone making that argument later, but I think it opens a huge can of worms that maybe we don't need to get into here because the Javits Amendment and the concessions.
That's right. As long as you don't cut it off the other way, I think that's perfectly fine.
Thank you, counsel. Justice Thomas? Justice Lee? Justice Sotomayor? Justice Kagan?
Mr. Mooppan, you talked about you are litigating this case the opposite way among states that do not prohibit trans women and girls from participating in sports teams. Is that correct?
Yes.
So, and you said, and I appreciate this, that we should not address that question. Are there arguments that do suggest what the answer is on that question that we should be careful about? Or do you think that they're really self-contained boxes?
I think they're generally distinct, and what I could confidently say is the argument that I identified at the outset and with Justice Barrett just now. If you just say that the regs mean sex, sex doesn't mean circulating testosterone, and therefore you're not required to allow boys to play on girls' team regardless of their circulating testosterone level, that argument would not influence the outcome of those other cases one way or the other.
Are there any arguments that would influence the outcome one way or the other?
I don't think so. Maybe if you engage in discussion about what the regs meant with respect to things like equal opportunity, that might be the sort of issue where it might have implications for the other case.
Thank you.
Justice Gorsuch? Justice Kavanaugh?
I just want to be crystal clear about that. If we say sex in Title IX is biological sex, and then we get to the next case, the California case or whatever it is, how would California still prevail if we've said that here?
I think the argument the other side would make would be that the regs don't prohibit them from accommodating transgender individuals. Even though the regs permit separation based on sex, they also don't forbid accommodation of transgender individuals. That's the argument they would make. And they would say it doesn't matter that you're allowing some boys who have a biological advantage to play on the girls.
What's the argument you're currently making in opposition to that?
That the justification for separating on the basis of sex is the biological difference. And so you're undermining the justification for the separation.
Right. And so we start with the separation. I think what you're saying is once you separate boys and girls teams, which everyone does, and it may be even required in my view, to have equal girls teams, then California really doesn't have an argument if we say that sex in Title IX means biological sex, which may be okay. I just want to make sure I know what we're doing.
Look, Your Honor, obviously we don't think they can argue that, but I'm confident that California would stand up here and say that even if you ruled the way I just urged, they should be able to argue the opposite by saying essentially that they're allowed to accommodate on the basis of gender identity, even though the regs mean sex and sex means biological sex. That's the argument they would make. Whether that argument's right or wrong is for another case, but I don't think if you adopt the argument I'm making here today, their hands are going to be tied.
Okay. And then on this premise that has been conceded, I just want to make sure I understand your view. My understanding is that it's sex-separated sports teams, so long as they're equal opportunity for girls and boys, are perfectly constitutionally permissible. Is that not your understanding?
Yes.
Yes.
Per the arguments in both cases.
I mean, it's conceded, but it's conceded because it's obvious.
Right, because there are obvious biological differences between men and women, and that's why.
Well, the why people may debate, but it's obvious. It's conceded, and so too Title IX because of the Javits Amendment, at least, even if not Title IX originally.
Well, I would say even without the Javits Amendment, because importantly, the Javits Amendment is only about intercollegiate. So.
And it's been interpreted in the regs, so to go to high school, and no one's ever challenged that part. That's the part, okay.
Right.
But that also, sex-separated sports teams are perfectly permissible under Title IX, at least with the Javits Amendment, and probably without, correct?
That's right.
And that's conceded, but that's, it's conceded again because everyone accepts that. And it has accepted that for a long time, so long as the opportunities for boys and girls, men and women are equal.
That's right. And I think what the other side in this case is trying to do is say, yeah, that's fine, but they're being excluded. And the problem with that is they're not being excluded from participating on the boys' team. They're choosing not to participate on the boys' team. Now, for understandable reasons, given their gender identity. But the state is not excluding them from the boys' team. And Justice Sotomayor, this explains the confusion in the Fourth Circuit's opinion, because I agree with you. It is very strange that the Fourth Circuit
Okay, we got to go back. Sorry. You can, finish that off. Sorry.
The reason why the Fourth Circuit found that there was a viable Title IX claim, even though they said that there was a factual dispute, is because they bought into this notion that because the transgender boy doesn't want to play on the girls' team, doesn't want to play on the boys' team and can't play on the girls' team, they're excluded. That's true even if they have a physical advantage. And so the court said, we don't care about the physical advantage, it's still a Title IX violation. And that's clearly wrong. That's a misinterpretation of the statute. And the error in it is that they're not being excluded from the boys' team. They're choosing not to participate on the boys' team.
Sorry, one more. Bostock does not control here because, fill in the blank.
Because the law doesn't classify on the basis of transgender status. It classifies on the basis of sex, biological sex. Just like in Scrimeti, the law there classified on the basis of age and medical treatment. Here, the law classifies on the basis of biological sex. The person's gender identity is wholly irrelevant to how the law applies.
Thank you.
Justice Barrett? Justice Jackson?
But they are being prevented from playing on the team that matches their gender identity, correct?
That's the effect. So let me use your example from earlier. You said there is a cisgender woman, she could play on the team she wants.
Right.
There's a boy who identifies as a girl, he can't play on the team he wants. Take that same boy and switch his gender identity, but say he still wanted to play on the girls' team. Say he was a very unathletic boy. He likewise couldn't play on the team. So it's not the gender identity that's keeping him off the girls' team, it's his biological sex. His gender identity is wholly irrelevant to it. Now, I agree with you, there's a very significant disparate impact on transgender individuals by this law because they're the boys who are most likely to want to play.
Have we said that Title IX never covers that kind of disparate impact in terms of its discriminatory effect?
Well, it certainly doesn't cover disparate. First of all, I don't think Title IX covers disparate impact, period, because it uses.
But in terms of its discriminatory effect, I'm just trying to understand it. Is there something to this notion that that differential treatment in effect in this way could be something that Title IX cares about?
I don't think Title IX covers disparate impact even on the basis of sex, and it certainly doesn't cover disparate impact on the basis of gender identity.
Okay.
Thank you, counsel. Mr. Block?
Mr. Chief Justice, and may it please the court, BPJ signed up for school sports because she was an 11-year-old girl starting a new middle school who wanted to meet people, make new friends, and be part of a team. West Virginia argues that to protect these opportunities for cisgender girls, it has to deny them to BPJ. But Title IX and the Equal Protection Clause protect everyone. And if the evidence shows there are no relevant physiological differences between BPJ and other girls, then there's no basis to exclude her. In thinking through the Title IX claim in particular, it's important to distinguish between how Title IX operates as a general matter and how it operates outside the context of athletics. And I'm glad that we're doing that this morning. Instead of focusing on athletics, West Virginia argues more generally that this court's reasoning in Bostock does not apply to Title IX. To distinguish Title VII from Title IX, West Virginia argues that Title IX protects groups instead of individuals and applies only when sex is the sole cause of adverse treatment. That approach takes a wrecking ball to the text of Title IX and the structure of this court's anti-discrimination precedents. It would dilute Title IX's protections for everyone, not just transgender students, and not just in the context of sports. West Virginia's law treats BPJ differently from other girls on the basis of sex, and it treats her worse in a way that harms her. Outside the context of athletics, that's all BPJ would need to establish a Title IX violation. But the Javits Amendment provides extra breathing room for reasonable regulations that take into account sex-based differences in athletics to provide equal athletic opportunity for everyone. West Virginia's exclusion of BPJ does not fall within that framework. Unlike the exclusion of a cisgender boy, excluding BPJ doesn't advance any interest in ensuring overall fairness and safety. And unlike the case of a cisgender boy, excluding BPJ from the girls' teams excludes her from all athletic opportunity while stigmatizing and separating her from her peers. I welcome the court's questions.
Doesn't your claim ultimately depend on the existence of sex-segregated sports?
Yeah, no, I don't think so, Your Honor. I think this is similar to Morales-Santana, where the claim was an equal protection claim.
Well, I mean, let's say there were no Title IX requirement for sex-segregated sports.
Yeah, well, if there were no Title IX requirement, and I don't think Title IX requires sex-segregated sports.
Well, permits.
If there were no Title IX and all the sports were co-ed, then she wouldn't be subjected to disparate treatment on the basis of sex. So I think the claim is the discrimination, and it's perfectly possible to.
So doesn't that suggest that you're a subcategory of the sex of the relevant class of female athletes? Isn't that your point?
Yes, well, for the equal protection claim.
Well, but you're not. My point is that you're challenging a category that does not exist in the statute, but is dependent upon the existence of a category in the statute that you're not challenging.
Well, I wouldn't put it that way. I would put it the way as there's a classification that we think is valid as applied to most people, but is invalid as applied to a discrete subset of those people. But I don't think the success of that equal protection claim hinges as an a priori matter on the existence of girls' teams. There are lots of ways to remedy an equal protection violation.
But I think, given the way you phrased it, the question becomes a little different, because what it seems to me you have to establish is the basis for requiring an exception to the classification. You're not challenging the idea of having boys and girls separate sports. You're saying that you cannot exclude transgender girls from the definition of girls. And that's an entirely different question than the equal protection question.
I don't think we're arguing for an exception. I think we're bringing exactly the same argument in Caban. In Caban, the plaintiff wasn't saying this is valid for everyone, but I want an exception from it. In Caban, the plaintiff was saying this is valid for other fathers, but it's not valid as applies to me. So I just think it's an as-applied equal protection claim. I understand the court might decide those claims don't exist, but I don't think it's a claim asking for an exception. It's a claim saying it's as applied to them, it's okay, as applied to me, it's not.
Counsel, how do you get to a Title IX violation? I know exactly how you get to an equal protection violation, okay? When if you accept that the regulation does, by its own terms, permit sex-based separate sports, does permit schools to do this. What in Title IX explicitly or even logically says that you have to give transgender
Thank you. I appreciate
girls the same opportunity? Because the regulation said, it's not just the statute, it's the regulation say, you can create separate sex teams.
No, thank you. I take the point. I think there's always been a tension between the underlying text of Title IX, which protects individuals, not groups, and the regulations, which are authorized by the Javits Amendment and have special leeway to make some group-based measurements. But if you look at the rationale for the regulations, Hugh, when it issued the regulations, said that we think that our group-based method, which otherwise would have been completely impermissible for Title IX, adequately protects the rights of individuals. Because if boys and girls as groups are being given equal sets of overall opportunity, then every individual in the group also has a set of equal opportunity to choose from.
Yeah, I think that's the problem. And, you're absolutely right to worry about the wrecking ball, but I think we've kind of taken a wrecking ball to that. There's no solely in the statute, all right? And we're talking about individuals. But Javits changed Title IX. And it said, sports are different. And we've got these regulations that have been out there for 50-plus years. And, normally Skidmore kind of comes in there. Forget about the spending clause, I guess. But maybe I'll ask you about that, too. Well, why doesn't that make this case very different than Title VII?
Yeah, so I completely agree. The Javits Amendment is what makes this different from Title VII, and I'm very happy with however this decision comes out to have a decision that's focused specifically on the unique context of athletics as opposed to these broad arguments about Bostock applying to Title IX as a general matter. But I guess what I'd say is the regulations still require equal athletic opportunity. It's not a complete exception for sex-separated teams.
Yeah, but Javits says it can be reasonable.
Yes.
And do you dispute that the Hugh regulation that's been on the books for 50-plus years is reasonable?
I think it is absolutely reasonable as applied to cisgender students. I think that as applied to transgender students, instead of providing them equal overall opportunity, it's a complete exclusion from the program. And so that's our argument, that it's reasonable as applied in the context of cisgender people, but interpreting the regulations to authorize this sort of categorical exclusion that doesn't give BPJ an equal set of opportunities to choose from would be an unreasonable way to implement Title IX.
Okay, gotcha.
It's unreasonable as to all transgender students.
No, I think it's a combination. I think so. A reasonableness test, I think that requires some sort of ends means fit, and I think that exists when it comes to cisgender students. I think what makes BPJ's case differently from a cisgender student is two things. First, she doesn't have any of the physiological distinctions that justify the sex separation in the first place. And second of all, the harm to her is of a material different kind. It's one thing to say we're not going to let boys play volleyball because they have all these other sports to choose from, or we're not going to let girls play football because they have all these other sports to choose from. It's another thing to say you don't get any sports.
But in that argument, does it matter whether BPJ has a competitive advantage or not?
Yes, we think it does, and I appreciate the opportunity to clarify that we don't have any objection to vacating the grant of summary judgment in our favor. We did our best to defend the judgment below, but our argument before the Fourth Circuit for summary judgment was that there wasn't a genuine disputed fact about whether she had an advantage. The Fourth Circuit, sua sponte, granted summary judgment to us based on the theory that that fact wasn't material. That's never been our argument in this case.
So your argument depends on depends on her not having a competitive advantage because she's not been through male puberty.
And not just not been through male puberty, but also gone through a female hormonal puberty with all the physiological changes accompanying it.
But that the argument goes away if those facts go away.
Yes, absolutely. Which is at the beginning of the argument, Justice Kagan, you talked about this could be resolved based on a legal principle or based on the facts. And I really do want to make a pitch for resolving it based on the facts because, look, if they're right about the facts, then we should lose. And the irony is that in order to win summary judgment in this posture, when there's a disputed question of fact below, is they can only win in this posture if we're right about the facts and there aren't any advantages. And I don't think there's any need at this juncture for this court to issue that broad a holding when, according to them, once the evidence comes in below, we're not going to get past summary judgment. I mean,
you're not suggesting that we decide the factual question.
No. I'm suggesting that the case be allowed to be decided on remand on the factual question, which I think, look, this is an important issue. It may affect the whole country, and the court wants to get it right. And I don't think the best way to get it right is to rely on, cherry-picked studies or assertions in amicus briefs. I think the way to get it right is to let all the facts they're trying to put in the record actually be put in the record. And then we'll have the facts in front of us, and maybe they'll make the issue go away. But I think that's unnecessary to intervene at this instance with a sweeping legal conclusion to something that might actually be a narrow factual dispute.
Counsel, can you explain whether or why your theory would allow a cisgender boy who just couldn't make the boys' team? I mean, he doesn't have an equal opportunity, he can't play, there's no team he can play on, and let's say that his athletic ability can be shown that he has no competitive advantage and he wants to be on the girls' team. Why can't he on your theory?
I appreciate the question. I think I just want to be clear about what we think the justification for the separate teams is. We don't think the boys' team is for better athletes and you have a backup team for athletes that aren't as good. I think the purpose of the teams is to control for the variable of sex-based advantages so that talented women athletes have all the same opportunities as talented male athletes. But also, untalented male athletes should be compared to untalented women athletes. So they're not being separated based on how good you are, right? The whole point is to allow female athletes to have all the same opportunities as men by controlling for the sex-based differential that comes through puberty. And so that's why I don't think that the claim is the same there. I think that's what's happened here is by virtue of her medical care, BPJ has already effectively controlled for those sex-based advantages. And so she is completely in the position that she would have been if her birth-assigned sex had been female. As opposed to a cisgender boy who's just not very good at sports, and if his birth-assigned sex were female, maybe he'd be even worse, I don't know. But But again, the purpose is to control for the variable of sex to provide equality, not to have a good team and a team for people that can't cut it. Now, I'm happy to address.
Can I ask a question on the law?
Yes.
On Title IX? I mean, I hate that a kid who wants to play sports might not be able to play sports. Hate that. But it's kind of a zero-sum game for a lot of teams. And someone who tries out and makes it, who is a transgender girl, will bump from the starting lineup, from playing time, from the team, from the all-league, and those things matter to people big time, will bump someone else. And so one way to resolve it, as you say, is the facts, try to figure out, is there really a competitive advantage? I think we're going to get a lot of scientific uncertainty about that, a lot of debate about that, a lot of different district courts. The other way on the law, one way on the law is, okay, well, sex in Title IX and in Javits meant biological sex, and it's up to Congress to adjust that going forward if they want, given, as you say, and your co-counsel said earlier, you know, people are learning more about this, and maybe there really is no advantage. Well, if that's true, and some states are operating under that basis, that's the way to go. But for now, at least the law says biological sex, and I think we have to recognize on both sides the zero sum. It's not like, oh, just to add another person to the team. That's not how sports works. It's someone else is going to get disadvantaged. So I just want you to address that.
I'm happy to, and I guess I have three answers. The first is I completely understand that many parts of sports are zero-sum, but this law isn't limited to zero-sum opportunities. So BPJ played on the cross-country team where there were no cuts. She came in near the back. It wasn't
but I'm sorry to interrupt, but you wouldn't have a different rule if she was finishing in the top 5.
No, but it wasn't a zero-sum.
Or if they had cuts.
But what I'm saying is in
this particular case, but usually with teams, I don't mean to, just don't want to get out of that. Usually with teams, they're cuts.
Yes.
Those mean a lot to people. There's starting lineups. Those mean a lot to people. There's who gets a college recruit. That means a lot to people.
Yes. I just want to say that there still are some areas where there are win-win solutions. I think even being able to be on practices with a team consistent with your gender identity instead of your sex assigned at birth can be enormously important. So I think some scenarios are zero-sum, but not everything having to do with sports is. And I do think that one of the vices of this law is that it sweeps so broadly that even win-win solutions are taken off the table. In terms of aspects where it's zero-sum, no one likes to lose. No one likes to not make the team. And people often don't make the team. The cisgender girls don't make the team when competing against other cisgender girls all the time. And the question, I think, is whether it's an unfair advantage to not make the team because a transgender girl participated. And if there is no sex-based biological distinction there, then I think it's an unfortunate situation, but I think it's the unfortunate situation that comes with having a zero-sum game, not inherent unfairness. Then the third thing is, I think however the court resolves this case, I really urge the court not to do it based on a definition of sex argument. We are not disputing in this case that West Virginia can have its definition of sex. Our argument is it's using this definition to inflict discrimination and deny equal athletic opportunity, but we are not saying their definition of sex is wrong. However, I don't think it follows that Title IX created some national definition of sex that preempted states' ability to say, actually, we are most concerned about discrimination that happens through gender roles.
Can I ask you something? That's a very important point here, I think, for what happens in the future, what you just said. Do you think sex in Title IX can reasonably be interpreted to allow different states to take different understandings of that in their sports leagues?
I do, because I don't...
Why is that? That's real important, I think, going forward.
Right. Because I don't think the purpose of Title IX is to have an accurate definition of sex. I think the purpose is to make sure that sex isn't being used to discriminate by denying opportunities. Just as I don't think we need to define race in order to enforce Title VI. So I think I wouldn't look to whether or not it's accurate to classify, BPJ as male or female. I think the question is she being denied an opportunity because of that classification? But obviously sex can mean more than just
So if we didn't want to prevent a different state from making a different choice from West Virginia, what should we not say, or what should we say to prevent that from happening?
Well, I wrote down the answer to that when you asked Mr. Mooppan. I have two things. I wrote, don't give definition of sex, and I also said I wouldn't decide this by assuming that Title IX provides a right to single-sex teams. In the regulations, single-sex teams are optional, they're not mandatory, and in addition to that, we've been talking about the regulations, but on the ground, the way this plays out in practice is you have a 1979 policy statement, a sub-regulatory document that has a complicated test for determining when a sex-separated team is or is not required. And so I think that both because I think saying there's a right to a sex-separated team would predetermine some of the questions in that other case. That's one reason why I don't think you should do that. But second, I think the more the court gets into questions that are handled in these complex regulatory documents, I think the more I'd be worried about this court accidentally saying something about how Title IX works that doesn't actually map on to how it is actually playing out on the ground.
Title IX prohibits discrimination on the basis of sex. It's a statutory term. It must mean something. You're arguing that here there's discrimination on the basis of sex. And how can we decide that question without knowing what sex means in Title IX? I mean, it could mean biological sex. It could mean gender identity. It could mean whatever a state wants to define it to mean. But it has to mean something. How can we decide that without knowing what the statutory term means?
Well, I think there are a whole range of sex-based characteristics that can give rise to discrimination. I think if someone said, I'm going to discriminate against anyone who acts in a feminine manner, like anyone with limp wrists, I don't care who they are, but I'm going to discriminate against them. I think that would be sex discrimination. It would be sort of gender presentation. But I wouldn't say that's not covered by Title IX. And so I'm not saying that biological differences aren't part of sex, but I'm saying that sex also has broader connotations, and there's no reason to keep that out of the statute. And I'm certainly not saying that sex means gender identity. I just want to be very clear about that. I don't think that, just as I would say this, our argument is that there's a group of people who are assigned male at birth for whom being placed on the boys' team is harmful, right? We happen to have a word for those people. It is transgender girls. But I don't think that means that we're elevating gender identity to be the new definition of sex. Just as in Phillips versus Martin Marietta, there's a subset of women, who are harmed by the policy. Not all women, but there's a subset of women who had young children. And there's a name for them, it's mothers, but that doesn't mean that we're replacing the word sex with mothers. I think
how do you respond to or deal with the other side's characterization of that harm as just the disparate impact of this regulation? That really, it's not discrimination, I think they're saying, but it is just the downstream effect of the application of the classification that the Javits Amendment allows, and that's just the way it goes.
Yeah, so I guess I would say this. I think this court has dealt with the issue of things like constructive denials and constructive discharges in a variety of contexts. And under Title IX, an outright denial isn't required. Davis says a constructive denial it also counts. And whenever there's a question of constructive denials, the court applies a standard that's reasonable person in the plaintiff's position under all the circumstances. And they use that for constructive denials. You've used that for retaliation claims. And if you look at Burlington versus White, I think it's very on point here, because one of the points that Burlington versus White said is that there's some actions that aren't going to be harmful to most people, but they might be harmful to some people. So Burlington versus White used a mother with young children might find a change in her work schedule to be incredibly harmful. right? That doesn't mean that, we're arguing that, this is a disparate impact classification on people who have young children. It's a sex classification. The sex classification is just harming some people and not harming other people. So that's how we would view it. I think this is a facial sex classification any way you cut it. And
I'm sorry, you don't think we should have an operating definition of sex in Title IX? Now, I understand the idea that the question then becomes not whether or not there's discrimination on the basis of sex, but whether there's discrimination on the basis of whatever characteristic you think should be included in the definition of sex. Now, when it's used as a statutory term, I'm not sure you have that kind of flexibility. The question would be instead, what does Congress think the word means?
Well, Your Honor, I guess I'd say I think Congress prohibited discrimination based on sex.
I'm sorry, go ahead.
Yeah, and so I don't think that, just as I don't think Congress adopted a definition of race, in Title VI in order to prohibit discrimination on the basis of race. I think I'm not trying to police the accuracy of the terminology that's being used. All I'm saying is that what's being prohibited is using this classification to discriminate, not.
So but without really knowing what this distinction is.
Well, I don't think the examples I've given about sex-based characteristics fall outside the common understanding of things that are related to sex.
Well, related to sex. I guess what you're saying is then we do have to accept for your position that we're not dealing when Congress says sex, we're not dealing with biological sex. But we're dealing with other characteristics that people might associate with sex?
No. I think for this case, you can accept for the sake of this case that we're talking about what they've termed to be biological sex. I think that resolves this case. I was just talking about in addressing other potential cases.
So we don't have to say anything about the matter. You're willing for us to proceed on that assumption.
Exactly. Just like in Bostock, I think you can proceed for argument's sake. Without taking a definitive position here, because it might have downstream consequences in other cases that even the United States doesn't want the court to prejudge here. Now, I would like to say one quick thing on Justice Barrett's reference to separate classrooms. I mean, it is true, and the ACLU's litigated cases about theories that there's different brain sexes for women versus boys, and that's why you need separate classrooms. I think the instinct was completely correct that you can have a lot of scientific justifications for discrimination. That doesn't mean that the discrimination is allowed or immune from scrutiny. And in fact, some of the studies that are cited in the amicus brief say boys are naturally more aggressive, right, and favor competition more because that's in their DNA. So I do think even in these studies, the idea that you're completely, just basing it on pure biology and not on other generalizations doesn't quite hold up. I'd also, to the extent that we want to go back to Caban, I do want to just make a couple quick things clear. Caban was not a facial challenge. It wasn't. And neither was some of the First Amendment cases they were talking about weren't equal protection First Amendment cases. They were commercial speech cases. Michael M. also wasn't a facial challenge. He wasn't saying I should have an exception because a prepubertal girl was involved. He was saying the statute is overbroad because in theory it could apply to a prepubertal girl. So I do think that some of the characterization of the cases doesn't hold up to our reading of them.
So how does a Caban type as applied intermediate scrutiny analysis work in your view? It is an underdeveloped area of the law. Is it enough for one person to show that she bucks the trend or not?
Yeah, I don't think so. I think I agree with my co-counsel that I think we're talking about a discrete, definable group that will reliably not serve the government's interest. And I don't think Nguyen is a counterpoint to that, because the whole point in Nguyen was that men who were not similarly situated had an opportunity to demonstrate that. There are three very easy methods of transmitting citizenship. And Nguyen emphasized that in order to do it, those were minimal burdens. And that is the key fact in Nguyen that distinguishes it from this case. This is a categorical ban. And Nguyen and Caban and all the court's cases distinguish between categorical bans and more narrow procedural requirements that do treat men and women differently, but still provide the opportunity for demonstrating that you're not similarly situated.
I think a hard question that Ms. Hartnett got, maybe the hardest question on these lines, was if we recognize these sorts of as-applied challenges, doesn't that effectively turn intermediate scrutiny into strict scrutiny? Right. What would your answer be to that? Would it be any different, or
no,
do you want to elaborate?
I think the answer is it absolutely wouldn't. You still are only looking for a substantial relationship, which means that you can have these sorts of requirements where there are a lot of under Caban and under Lair. There's still a lot of fathers that are out of luck that they actually probably do have a good relationship with her kid, but they didn't fill out the right paperwork, they didn't do this, they didn't do that, and heightened scrutiny doesn't require that they be excused from those procedural burdens. So I do think that heightened scrutiny allows you to have procedural requirements that people have to go through, and those can be enforced. Strict scrutiny does not allow that. But that's different from saying that if the complete rationale for a classification just doesn't apply to you, that there's no equal protection claim you can bring. And some of it's complicated to talk about the difference between facial and as applied post-CASA, because I think a lot of the things that we called facial challenges now would be viewed as overbreadth challenges, right? Where someone is trying to say the law is so overbroad in general, it has to all be struck down. And we have that for First Amendment. I don't think we have that anymore for most equal protection claims. And so I think taking this facial as applied framework from before CASA, where we allowed these facial attacks on statutes, and then just transporting it into as applied cases post CASA doesn't necessarily work. I think some of the terminology might need to be rethought. And so, again, that's another reason why there's not a lot of precedent in this area, as several of you all have acknowledged. And that's another reason why I don't think this should be the case that makes that precedent when it's unnecessary to do so.
Thank you, counsel. Justice Thomas? Justice Alito? Justice Sotomayor?
Would you address a little bit the quantum of certainty or uncertainty that would have to exist in the science? Your co-counsel, or the counsel in the other case, said that if it's 50%, the state loses. But I'm always hesitant about these percentage cases because it's never qualitative. It's never quantitative, it's qualitative. So what do you think the qualitative standard is?
Well, I mean, to be clear, I don't actually think there's uncertainty in the case of someone who's had puberty blockers and then gender-affirming hormones. Our position is there's zero uncertainty. It's actually clearly in our favor. So but in general, I think it's hard to give, a quantitative answer to that. I think part of heightened scrutiny involves taking all of these factors into account. This court, has said on several occasions that heightened scrutiny can accommodate deference. And I honestly think it's a case-by-case decision that also looks at how harmful the classification is, how burdensome it is. I don't think you just look at the accuracy of the classification and add a number value for how certain we are that it's accurate. I think many other factors come into play.
Thank you. Justice Kagan? No. Justice Gorsuch? Justice Barrett? Justice Jackson? Thank you, counsel. Rebuttal, Mr. Williams?
I think you've now heard Respondent abandon the Fourth Circuit's logic on Title IX, and I think in many ways that makes this court's task that much easier. Congress authorized regulations allowing sex-separated athletics. West Virginia's definition of sex tracks the ordinary meaning in 1972 and 1974 and the regulatory framework that Congress endorsed. I think, Mr. Chief Justice, your question really highlighted how BPJ's approach unmoors the statute and the regulation under Title IX on the basis of sex. BPJ's test, in turn, begins to look more towards other characteristics that aren't on the basis of biological sex, and I think that's not consistent with what we see there. I also think the answer to Justice Barrett's question reflected how, under BPJ's theory, this really isn't about competitive advantage, that really what this does turn on is gender identity, because BPJ continues to maintain that a cisgender boy who continues to not have those same biological advantages would nevertheless still be kept off of the girls' sports team. So if you endorse that philosophy, that would require the court to hold that long-standing Title IX athletic regulations are unlawful. It would eliminate sex-separated athletics entirely, and I think it would defeat Title IX's core purpose of ensuring equal athletic opportunity for both sexes. On the equal protection side of the House, the question is whether the classification is substantially related to an important governmental interest. And I think that BPJ ultimately wants to rewrite the classification to be something that it is not. Biological sex substantially relates to athletic performance. That's exactly why, in fact, Title IX regulations authorize sex-separated teams in the first place. Respondents' test effectively ratchets up the intermediate scrutiny standard into a perfect fit, best disposition case that this court has repeatedly said is not the standard under intermediate scrutiny cases. That is the standard for strict scrutiny cases. You have heard it several times today. Justice Sotomayor, you asked about deference. I think this court has also repeatedly recognized that in areas of evolving science and medicine, especially involving children, legislatures have the primary responsibility for weighing competing evidence and making the policy judgments. I think the court just recently said that in Scrimeti, but I certainly don't think that case stands alone in recognizing that, especially when you have competing balances of harms, Justice Kavanaugh, when you're weighing these sorts of zero-sum games, that's a choice, that's a policy judgment that ultimately rests in the hands of the legislature. In the end, this court has, quote, recognized physical differences between men and women. They are enduring, and inherent differences between men and women are cause for celebration. That is all that West Virginia's law does here. It should be upheld. Thank you.
Thank you, counsel. The case is submitted.